that expressed the sense of the Senate that the United States would not bar people from entering this country based on their religion. He voted against each of 3 bipartisan comprehensive immigration bills in 2006, 2007, and 2013. Twice, he voted against the DREAM Act, the bill for undocumented youth, known as Dreamers, who were brought here as children through no choice of their own, calling it a, quote, reckless proposal for mass amnesty, end quote. He voted against efforts to prohibit the use of waterboarding and other so-called enhanced interrogation techniques, calling them lawful and praising Attorney General Mukasey in 2008 for refusing to rule out the use of waterboarding in the future. These interrogation techniques are and were, at the time, illegal. And thanks to a provision Senator McCain placed in the Defense Authorization Bill this past year, they are now prohibited from use. In addition, Senator Sessions voted against the Matthew Shepard and James Byrd Hate Crimes Act, which, among other things, expanded the hate crimes law to cover sexual orientation and gender identity. Arguing against the hate crimes law in 2009, he said this: "Today, I'm not sure women or people with different sexual orientations face that kind of discrimination. I just don't see it," end quote. Well, this senator regretfully sees it. Hate crimes are happening. The Department of Justice must see it, must investigate it, and prosecute it appropriately. Those are votes that are deeply concerning. They are recent, they are important, and they clearly show this senator's point of view. Now, for all these reasons, this hearing must determine clearly whether this senator will enforce laws he voted against. We, the American people, want to know how he intends to use this awesome power of the Attorney General if he is confirmed. Will he use it fairly? Will he use it in a way that respects law and the Constitution? Will he use it in a way that eases tensions among our communities and our law enforcement officers? Will he be independent of the White House? Will he tell the President no when necessary and faithfully enforce ethic laws and constitutional restrictions? So we will ask questions and we will press for answers. Ultimately, we must determine whether Senator Sessions can be the Attorney General for all of our people. Mr. Chairman, I'd like to conclude with one final point. We cannot ignore that there are deep concerns and anxieties throughout America. There is a deep fear about what a Trump administration will bring in many places. And this is the context in which we must consider Senator Sessions' record and nomination to become the chief law enforcement of America. Communities across this country are concerned about whether they will be able to rely on the Department of Justice to protect their rights and freedoms. These freedoms are so cherished. They are what make us unique among nations. There have been sit-ins, protests, and writings, and the committee has received letters of opposition from 400 different civil rights organizations, 1,400 law professors, 1,000 law students, a broad task force of organizations that oppose domestic violence, 70 reproductive health organizations, and many, many others. All these letters express deep anxiety about the direction of this country and whether this nominee will enforce the law fairly, evenly, without personal bias. So I hope today's questions are probing and the answers are fulsome. Ladies and gentlemen, this is the only way we have to know whether this man can dispatch himself from the president and from his record and vote in full according to the laws of the United States of America. Thank you very much, Mr. Chairman.
And thank you, Senator Feinstein. Before I turn to Senators Shelby and Collins for their opening statement, I'd note that the committee received a letter from former Secretary of State Condoleezza Rice indicating that she had hoped to join our colleagues in introducing Senator Sessions. She strongly supports his nomination. It's a powerful letter, and I hope my colleagues will take time to read it, and I'd like to have it entered in the record at this point. Now to Senator Shelby and Senator Collins in that order. Proceed.
Chairman Grassley, Ranking Member Feinstein, thank you for allowing me to be a part of this historic hearing today. Although my friend and colleague Jeff Sessions is well known to the members of this committee, it's my distinct privilege to introduce him as President-elect Donald Trump's nominee to serve as our next United States Attorney General. Before joining the Senate, Jeff Sessions began his distinguished career as a practicing attorney and then served as the United States Attorney for Alabama's Southern District before ultimately becoming the Attorney General of the state of Alabama. During the past 20 years here in the U.S. Senate that I have served with Jeff Sessions, I've had the opportunity to know him well, not just as a skilled attorney with an accomplished record as a prosecutor and as a legislator, but as a man of extraordinary character. I have the highest regard not only for his intellect, but for his integrity. Unfortunately, since the announcement of his nomination, Jeff's political opponents have attacked his character with baseless and tired allegations. But in reality, Jeff Sessions' extensive record of treating all Americans equally under the law is clear and well documented. Throughout his decades of public service, including his impressive tenure on this committee, Jeff's commitment to upholding the rule of law, I believe, is unparalleled. The integrity, humility, and gravity with which Jeff Sessions will approach the office of Attorney General of the United States is unquestionable. I have no doubt, Mr. Chairman, that he will apply the law with the impartiality that's required of the job. I'm also confident that this committee will report favorably and expeditiously Jeff Sessions' nomination to be the next Attorney General of the United States.
Thank you, Mr. Chairman. Mr. Chairman, Senator Feinstein, members of this distinguished committee, I am pleased to join Senator Shelby in presenting my friend and colleague, Senator Jeff Sessions, and to offer my support for his nomination to be our next Attorney General. Jeff Sessions and I were first sworn into the United States Senate on the very same day. In the 20 years since, we have worked closely on some issues and on opposite sides on others. In fact, it would be fair to say that we have had our share of vigorous debates and policy disagreements. Through these experiences, I have come to know Senator Sessions professionally as a trusted colleague and personally as a good friend. I can vouch confidently for the fact that Jeff Sessions is a person of integrity, a principled leader, and a dedicated public servant. As a senator, Jeff Sessions has worked across the aisle to lead important legislative reforms. He has worked with Senator Dick Durbin to pass the Fair Sentencing Act, a law that addressed the unfair racial disparity in crack cocaine sentencing. He worked with Senator Ted Kennedy to pass the Prison Rape Elimination Act, and with Senator Chris Coons on the reauthorization of the Victims of Child Abuse Act. An area where Senator Sessions and I have worked together is in opposing unfair trade agreements and practices that hurt American workers. What I want this committee and the American people to know is that Jeff Sessions is the same genuine, fair-minded person in unguarded private moments as he is in the halls of the Senate. We first came to know each other during dinners with other members of our Senate class, where we discussed everything from our politics to our families. I have never witnessed anything to suggest that Senator Sessions is anyone other than a dedicated public servant and a decent man. In 1980, long before he ran for the Senate or even dreamed of being Attorney General, Jeff Sessions sponsored the first African-American member of the Mobile Lions Club. As U.S. Attorney, he provided leadership in the successful convictions of 2 Klan members who had murdered an African-American teenager. As ranking member of the Senate Judiciary Committee in 2009, he appointed the first African-American to serve as chief counsel to the Republican members. My friends, these are not the actions of an individual who is motivated by racial animus. In spite of this strong record, Senator Sessions' nomination has generated controversy. He has had to withstand some very painful attacks on his characters, both years ago and again today, with little or no acknowledgement of his accomplishments and actions or the responses he has made to the accusations levied against him. As this committee debates this nomination, I would draw your attention to an important epilogue to Jeff Sessions' nomination 31 years ago to be a federal judge. The late Senator Arlen Specter of Pennsylvania was a member of the Judiciary Committee when the Sessions nomination was considered in 1986. Senator Specter, then a Republican, voted against Jeff Sessions. Years later, in 2009, Senator Specter had switched parties. He was asked by a reporter if he regretted any of the more than 10,000 votes he had cast. Out of all of those votes, then Democratic Senator Specter cited just one. It was his vote against confirming Jeff Sessions as a federal judge. When asked why, Senator Specter replied, quote, "Because I have since found that Senator Sessions is egalitarian," end quote. In other words, once Senator Specter served with Jeff Sessions and had the opportunity to get to know him, he changed his mind. I hope that you will keep Arlen Specter's reflections in mind as this committee evaluates Senator Sessions' public service, his character, and his fidelity to the rule of law. The members of this committee have an advantage that Senator Specter did not. The vast majority of you have already served with Senator Sessions, and you know him well. If this committee places its trust in him, I have every confidence that Jeff Sessions will execute the office of Attorney General honestly, faithfully, and fully in the pursuit of justice. Thank you, Mr. Chairman. Thank you, Ranking Member Feinstein and members of this committee.
And thank both of our colleagues for your powerful statement. I appreciate it very much. And you're free to go, and we'll call the nominee at this point. Senator Sessions, before you're seated, I'd like to administer the oath. Would you raise your hand, please, and answer this question? Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, and please be seated. Senator Sessions, it's our normal process, if you desire to introduce people that are with you, including your family, I'm sure you're very proud of. You're free to do that, and then go immediately to your opening statement.
My wife, Mary, my best friend for 47 years. Without her love and support and son's life, none of this would have been possible for me and our family. And we are so proud of our three children, each one of which are here today. Mary Abigail Reinhardt, our oldest, is married to Nate Washington, and they're now stationed in the Pacific. Thank you. They're now stationed in the Pacific Coast. They have two children, Jane Ritchie and Jimbo, and they wish me well this morning. My daughter, Ruth Walk, maybe Ruth, you would stand up, and her husband, John Walk. John is an attorney with the Department of Homeland Security, and they have four children, as you see before you today, Gracie, and Hannah, and Joanna, and Phoebe. Phoebe and Joanna are twins. And we're so proud of them. My son, Sam, is a graduate of Auburn and Alabama Law School. Sorry, Sam, about the game last night. Lindsay, congratulations, wherever he is. Sam is an attorney in Birmingham, and he's married to Angela Stratus. They have four children, Alexa, Sophia, Lewis, and Nicholas. 10 grandchildren. The oldest is 9, and you can imagine the week we had at the beach this summer in Alabama. Finally, I want to express how humbled I am to have received such overwhelming support and encouragement from our nation's law enforcement community. Many are here today. Mr. Chairman, with your permission, I would like to ask those present, please, to stand and be recognized, the law enforcement members that are here today. Would you please stand? Every major law enforcement organization in America has endorsed my candidacy. I feel the weight of the confidence they've placed in me. And gentlemen and ladies, I'll do my best to be worthy of that. And if I may, Mr. Chairman, yesterday was Law Enforcement Officer Appreciation Day. Sadly, on that day, we lost 2 of our brave officers. Orlando Police Department, Master Sergeant Deborah Clayton, one of the first officers to respond to the Orlando nightclub shooting in June, was shot and killed while confronting a subject wanted for murder. Sergeant Clayton, a 17-year veteran of the force, was married with 2 children. While assisting in the search for that assailant, Orange County Deputy First Class Sheriff Norman Lewis was killed in a traffic accident on his motorcycle. He was an 11-year veteran of the sheriff's office. These honorable and dedicated have dedicated their lives to keeping their community safe, and we should remember their service and keep them and our families and their families in our prayers. Chairman Grassley, Ranking Member Feinstein, distinguished members of the committee, I'm honored to appear before you today. I thank you for the opportunity to respond to your questions as you discharge your duty in the appointment process as prescribed by the Constitution. I also want to thank my dear friends.
USA. No Trump. No KKK. No fascist USA. This is a racist, illegitimate, just like the whole Trump and fascist regime. Prevent it from ruling. People can flood into the streets. January 14th. Let me stand up. January 14th and stay in the street. Stop the Trump regime before you no Trump, no KKK, no fascist
Mr. Chairman, if I might. Dear friends, I want to thank Richard Shelby, my colleague, and Senator Susan Collins for the kind and generous introductions. It was very moving and touching for me. It's hard to believe, really, that the three of us have served together in this body for almost 20 years. When I arrived in the Senate in 1997, I probably wouldn't have anticipated becoming so close with a colleague from Maine, two people from the northernmost part of our country and the southernmost part of our country. It took us a while to perhaps understand our accents, but once we did, we became fast friends. Of course, Richard Shelby and I never had an accent problem. He was has been a steadfast friend, and I think we've been a pretty good team representing the interest of Alabama and the United States. I want to thank President-elect Donald Trump for the confidence and trust he has shown in me by nominating me to serve as the Attorney General of the United States. I feel the weight of an honor greater than I aspired to. If I'm confirmed, I will commit to you and to the American people to be worthy of the office and the special trust that comes with it. So I come before you today as a colleague who's worked with you for years, and some of you 20 years. You know who I am. You know what I believe in. You know that I'm a man of my word and can be trusted to do what I say I will do. You know that I revere the Constitution, that I'm committed to the rule of law, and you know that I believe in fairness, in impartiality, and equal justice under law. Over the years, you've heard me say many times that I love the Department of Justice. The office of Attorney General of the United States is not a normal political office, and anyone who holds it must have total fidelity to the laws and the Constitution of the United States. He or she must be committed to following the law. He or she must be willing to tell the president or other top officials if he or they overreach. He or she cannot be a mere rubber stamp. He or she must set the example for the employees of the department to do the right thing and ensure that when they do the right thing, they know the Attorney General will back them up, no matter what politician might call or what powerful special interest, influential contributor, or friend might try to intervene. The message must be clear. Everyone is expected to do their duty. That is the way I was expected to perform as an assistant United States attorney, working for Attorney General Meese and part of my career. And that is the way I trained my assistants when I became United States Attorney. And if confirmed, that is the way I will lead the Department of Justice. In my over 14 years in the Department of Justice, I tried cases personally of every kind: drug trafficking, very large international smuggling cases, many firearms cases, other violent crimes, a series of public corruption cases of quite significance, financial wrongdoing, and environmental violations. Our office supported historic civil rights cases and major civil cases. Protecting the people of this country from crime, and especially from violent crime, is a high calling of the men and women of the Department of Justice. Today, I'm afraid it's become more important than ever. Since the early 1980s, good policing and prosecutions over a period of years have been a strong force in reducing crime, making our communities safer. Drug use and murders are half what they were in 1980 when I became a United States attorney. So I'm very concerned that the recent jump in violent crime and murder rates are not anomalies, but the beginning of a dangerous trend that could reverse those hard-won gains that have made America a safer and more prosperous place. The latest FBI statistics show that all crime increased nearly 4% from 2014 to 2015, the largest increase since 1991, with murders increasing nearly 11%, the single largest increase since 1971. In 2016, there were 4,368 shooting victims in Chicago. In Baltimore, homicides reached the second highest per capita rate ever. The country is also in the throes of a heroin epidemic, with overdose deaths more than tripling between 2010 and 2014. Tripling. Nearly 50,000 people a year die from drug overdose. Meanwhile, illegal drugs flood across our southern border and into every city and town in the country, bringing violence, addiction, and misery. We must not lose perspective when discussing these statistics. We must always remember that these crimes are being committed against real people, real victims. It's important that they are kept in the forefront of our minds in these conversations and to ensure that their rights are protected. So these trends cannot continue. It is a fundamental civil right to be safe in your home and your community. If I am confirmed, we will systematically prosecute criminals who use guns in committing crimes. As United States Attorney, my office was a national leader in gun prosecutions nearly every year. We will partner with state and local law enforcement to take down these major drug trafficking cartels and dismantle criminal gangs. We will prosecute those who repeatedly violate our borders. It will be my priority to confront these crimes vigorously, effectively, and immediately. Approximately 90% of all law enforcement officers are not federal, but they're state and local. They are the ones on the front lines. They are better educated, trained, and equipped than ever before. They are the ones who we rely on to keep our neighborhoods and playgrounds and schools safe. But in the last several years, law enforcement as a whole has been unfairly maligned and blamed for the unacceptable actions of a few of their bad actors. They believe the political leadership in the country has abandoned them. They felt they have become targets. Morale has suffered, and last year, while under intense public criticism, the number of police officers killed in the line of duty increased by 10% over 2015. And firearms deaths of police officers are up 68%. So this is a wake-up call, colleagues. It cannot continue. If we're to be more effective in dealing with rising crime, we will have to rely and work with more effectively local law enforcement, asking them to lead the way. To do that, they must know they're supported, and if I am so fortunate as to be confirmed as Attorney General, they can be assured they will have my support in their lawful duties. As I discussed with many of you in our meeting prior to this hearing, the federal government has an important role to play in this area also. We must use the research and the expertise and the training that has been developed by the Department of Justice to help these agencies in developing the most effective and lawful law enforcement methods to reduce crime. We must reestablish and strengthen the partnership between federal and local officers to enhance a common and unified effort to reverse the rising crime trends. I did this as United States Attorney. I worked directly and continuously with local and state and law enforcement officials. If confirmed, this will be one of my priority objectives. There are also many things the department can do to assist the state and local officers to strengthen relationships with their own communities, where policies like community-based policing have absolutely been proven to work. I am committed to this effort and to ensuring that the Department of Justice is a unifying force for improving relations between the police in this country and the communities they serve. This is particularly important in our minority communities. Make no mistake, positive relations and great communications between the people and their police are essential for any good police department. And when police fail in their duties, they must be held accountable. I have done these things as United States Attorney. I have worked to advance these kind of policies. In recent years, our law enforcement officers have been called upon to protect our country from the rising threat of terrorism that has reached our shores. If I'm confirmed, protecting the American people from the scourge of radical Islamic terrorism will continue to be a top priority. We will work diligently to respond to threats using all lawful means to keep our country safe. Partnerships will also be vital to achieving much more effective enforcement against cyber threats, and the Department of Justice clearly has a lead role to play in that essential effort. We must honestly assess our vulnerabilities and have a clear plan for defense as well as offense when it comes to cyber security. The Department of Justice must never falter in its obligation to protect the civil rights of every American, particularly those who are most vulnerable. A special priority for me in this regard will be the aggressive enforcement of laws to ensure access to the ballot for every eligible voter without hindrance or discrimination, and to ensure the integrity of the electoral process, which has been a great heritage of the Department of Justice. Further, this government must improve its ability to protect the United States Treasury from fraud, waste, and abuse. This is a federal responsibility. We cannot afford to lose a single dollar to corruption, and you can be sure if I'm confirmed, I will make it a high priority of the Department of Justice to root out and prosecute fraud in federal programs and to recover monies lost due to fraud and false claims, as well as contracting fraud and issues of that kind. The Justice Department must remain ever faithful to the Constitution's promise that our government is one of laws and not of men. It will be my unyielding commitment to you, if confirmed, to see that the laws are enforced faithfully, effectively, and impartially. The Attorney General must hold everyone, no matter how powerful, accountable. No one is above the law, and no American will be beneath its protection. No powerful special interest will cower this department. I want to address personally the fabulous men and women that work in the Department of Justice. That includes personnel in Main Justice here in Washington, but also the much larger number that faithfully fulfill their responsibilities every day throughout the nation. As a United States Attorney, I work with them constantly. I know them and the culture of their agencies. The federal investigative agencies represent the finest collection of law enforcement officers in the world. I know their integrity and their professionalism, and I pledge to them a unity of effort that is unmatched. Together, we can and will reach the highest standards and the highest results. It would be the greatest honor for me to lead these fine public servants. To my colleagues, I appreciate the time each of you have taken to meet me one-on-one. As senators, we don't always have enough opportunity to sit down and discuss matters face-to-face. I had some great visits. I understand and respect the conviction that you bring to your duties. Even though we may not always be in agreement, you have always been understanding and respectful of my positions and I of yours. In our meetings over the past weeks, you have had the opportunity to share with me and you're relating to the department from unprosecuted crimes on tribal lands, a matter that is greater than I had understood, to the scourge of human trafficking and child exploitation, to concerns about cuts in grant programs, to the protection of American civil liberties, and the surge of heroin overdose deaths, to just name a few things. I learned a lot during those meetings, and particularly in my meeting with Senator Whitehouse, who discussed cybersecurity. He has a great deal of knowledge there, and I'm glad that Senator Whitehouse, you and Senator Graham have taken a lead on this important issue, and I think we can work together and make some progress. Senator Graham, and congratulations on your football victory last night. That later. Pretty thin. So I want to assure all of my colleagues that I have given your concerns earnest reflection and will bear them in mind as I move forward. I will sincerely endeavor to keep these lines of communications open and hope that we can continue our collegiality and friendships. In that regard, if I'm confirmed, I commit to all of you that the Department of Justice will be responsive, Mr. Chairman, to Congress, and will work with you on your priorities, all of you, and provide you with guidance and views where appropriate. The Department will respect your constitutional duties, your oversight role, and the particularly critically important separation of powers between the executive and legislative branches. Let me address another issue straight on. I was accused in 1986 of failing to protect the voting rights of African Americans by presenting the Perry County case, the voter fraud case, and of condemning civil rights advocates and organizations, and even harboring, amazingly, sympathies for the KKK. These are damnably false charges. The voter fraud case my office prosecuted was in response to pleas from African American incumbent elected officials who claimed that the absentee ballot process involved a situation in which ballots cast for them were stolen, altered, and cast for their opponents. The prosecution sought to protect the integrity of the ballot, not the block voting. It was a voting rights case. As to the KKK, I invited civil rights attorneys from Washington, D.C. to help us solve a very difficult investigation into the unconscionable, horrendous death of a young African American coming home from the 7-Eleven store at night simply because he was black, Michael Donald, and actively backed the attorneys throughout the case, and they broke that case. That effort led to a guilty plea and a life sentence in court for one defendant and his testimony against the other defendant. There was no federal death penalty at the time. I felt the death penalty was appropriate in this case, and I pushed to have it tried in state court, which was done. That defendant was indeed convicted and sentenced to death, and 10 years later, ironically, as Alabama's Attorney General, my staff participated in the defense of that verdict and sentence, and a few months after I became United States Senator, that murdering Klansman was indeed executed. I abhor the Klan and what it represents and its hateful ideology. I insisted Marsh Dees of the Southern Poverty Law Center and his lawsuit that led to the successful collapse of the Klan, at least in Alabama, the seizure of their building, at least for that period of time. As Civil Rights Division attorneys have testified before the committee, I supported fully their historic cases that the Justice Department filed to advance civil rights and that I supported, including cases to desegregate schools, abolish at-large elections for cities, county commissions, and school boards. These at-large elections were mechanisms used to block African-American candidates from being able to be elected to boards and commissions. It was a deliberate and part of a systemic plan to reduce the ability of African Americans to have influence in the election and governing process. I never declared the NAACP was un-American or that a civil rights attorney was a disgrace to his race. There is nothing I am more proud of than my 14 years of service in the Department of Justice. I love and venerate that great institution. I hold dear its highest ideals. As God gives me the ability, I will work every day to be worthy of the demands of this august office. You can be absolutely sure that I understand the immense responsibility I would have. I am not naive. I know the threat that our rising crime and addiction rates pose to the health and safety of our country. I know the threat of terrorism. I deeply understand the history of civil rights in our country and the horrendous impact that relentless and systemic discrimination and the denial of voting rights has had on our African American brothers and sisters. I have witnessed it. We must continue to move forward and never back. I understand the demands for justice and fairness made by our LGBT community. I will ensure that the statutes protecting their civil rights and their safety are fully enforced. I understand the lifelong scars borne by women who are victims of assault and abuse. And if I am so fortunate to be confirmed as your Attorney General, you can know that I understand the absolute necessity that all my actions must fall within the bounds of the Constitution and the laws of the United States. While all humans must recognize the limits of their abilities, and I certainly do, I am ready for this job. We will do it right. Your input will be valued. Local law enforcement will be our partners. Many friends in federal government that I've had in law enforcement will be respected. I've always loved the law. It is the very foundation of this country. It is the exceptional foundation of America. I have an abiding commitment to pursuing and achieving justice and a record of doing that. And if confirmed, I will give all my efforts to this goal. I only ask that you do your duty as God gives you the ability to see that duty as you are charged by the Constitution. Thank you for your courtesies. I look forward to the further hearing. Thank you, Mr. Chairman.
Before I ask questions, I want to thank you, Senator Sessions, for your service in the Senate, but more importantly, for taking on this responsibility you've been nominated for, and to thank you for your opening statement. I'm glad that you were able to mention the names of a lot of your family that are with you, and there's a lot of other people that we may not have their name, and I would ask the staff to put in the record the names of all the other people who are accompanying you today as well, if they're willing to give us that name. And it's a proud day for you, your wife, son, and daughters, and their families. I welcome all of you very much. Now to the questioning. The Attorney General, I'll take 10 minutes, and Senator Feinstein will go back and forth as we usually do. The Attorney General of the United States is, of course, the nation's chief law enforcement officer. He or she is not the president's lawyer, nor is he the president's wingman, as Attorney General Holder described himself. Rather, he or she has an independent obligation to the Constitution and to the American people. Now, I know you care deeply about this foundational principle. So I'm going to ask you a question. I've heard you ask other nominees for Attorney General. Occasionally, you'll be called upon to offer an opinion to the president who appointed you. You'll have to tell him yes or no. And sometimes presidents don't like to be told no. So I'd like to know, will you be able to stand up and say no to the President of the United States if, in your judgment, the law and your duty demands it? And the reason I ask that is because I know you work very hard for the President-elect.
Mr. Chairman, I understand the importance of your question. I understand the responsibility of the Attorney General, and I will do so. You simply have to help the President do things that he might desire in a lawful way and have to be able to say no, both for the country, for the legal system, and for the President, to avoid situations that are not acceptable. I understand that duty. I've observed it through my years here, and I will fulfill that responsibility.
Say, just so my colleagues don't think I'm taking advantage of time, somebody didn't start the clock.
Oh, it's your clock. Here's mine.
Oh, you got it. Okay. It's just, well, the light isn't working. I'm sorry. I can read it now. So I heard what you said, but just to emphasize, let me follow up. Well, if you disagree with the president's chosen course of action, and you told him so, and he intends to pursue that course of action anyway, what are your options at that point?
Mr. Chairman, I think Attorney General should first work with the President. Hopefully that Attorney General would have the confidence of the President and avoid a situation that would be unacceptable. I do believe that if Attorney General is asked to do something that's plainly unlawful, he cannot participate in that, he or she, and that person would have to resign ultimately before agreeing to execute a policy that the Attorney General believes would be unlawful or unconstitutional. I would say, Mr. Chairman, that there are areas that are brightly clear and right. There are areas that may be gray, and there are areas that are unacceptable. And a good Attorney General needs to know where those lines are to help the President where possible and to resist improper, unacceptable actions.
Okay. You served in this department for 14 or 15 years. You served as your state's Attorney General. And of course, you serve on this committee for a long time. And we have oversight over the department that you might head. And you've done that all for 20 years. I've had my share of disagreements with the department's leadership over the last few years. Some of those were purely policy disagreements, but some issues were especially troubling to me in that the department failed to perform fundamental functions to enforce the law. As Attorney General, day in and day out, you'll be faced with difficult and sometimes thorny legal problems. What will your approach be to ensuring that the department enforces the law? And more broadly, what is your vision for the department?
Mr. Chairman, the ultimate responsibility of the Attorney General and the Department of Justice is to execute the laws passed by this Congress and to follow the Constitution in that process and carry its principles out. So you can be sure I understand that. We may have had disagreements here about whether a law should be passed, but once passed, I will do my dead level best to ensure it's properly and fairly enforced. I do believe that we have a crime problem. I won't perhaps go in time now unless you want me to describe what we can do to address that. And there are other challenges this country faces. I would be pleased to recognize the influence of the legislative branch and to welcome the insights that you might have.
Since that's a very important issue with me and I suppose every colleague here, let me emphasize by saying, is it fair to say then that regardless of what your position may have been as a legislator, your approach as Attorney General will be to enforce the law regardless of policy differences?
Absolutely, Mr. Chairman. I don't think I have any hesitation or any lack of an ability to separate the roles that I have had. To go from the legislative branch to the executive branch is a transfer of not only position, but of the way you approach issues. I would be an executive function, an enforcement function of the laws this great legislative body might pass.
During the course of the presidential campaign, you made a number of statements about the investigation of former Secretary of State Hillary Clinton relating to her handling of sensitive emails and regarding certain actions of the Clinton Foundation. You weren't alone in that criticism. I was certainly critical in the same way, as were millions of Americans on those matters. But now you've been nominated to serve as Attorney General. In light of those comments that you made, some have expressed concern about whether you can approach the Clinton matter impartially in both fact and appearance. How do you plan to address those concerns?
Mr. Chairman, it was a highly contentious campaign. I, like a lot of people, made comments about the issues in that campaign. With regard to Secretary Clinton and some of the comments I made, I do believe that that could place my objectivity in question. I've given that thought. I believe the proper thing for me to do would be to recuse myself from any questions involving those kind of investigations that involve Secretary Clinton that were raised during the campaign, or could be otherwise connected to it.
Okay. I think let me emphasize then with a follow-up question, to be very clear, you intend to recuse yourself from both the Clinton email investigation and any matters involving the Clinton Foundation, if there are any?
Yes.
Let me follow up again because it's important. When you say you'll recuse, you mean that you'll actually recuse and the decision will therefore fall to, I assume, a Deputy Attorney General. I ask because after Attorney General Lynch met with President Clinton in Phoenix, she said she would, quote unquote, defer to the FBI, but she never officially recused.
No, she did not officially recuse, and there's a procedure for that which I would follow. And I believe that would be the best approach for the country, because we can never have a political dispute turn into a criminal dispute. That's not in any way that would suggest anything other than absolute objectivity. This country does not punish its political enemies, but this country ensures that no one is above the law.
You touched on something that's very dear to me, and that's working with having executive branch people work with members of the Congress. And you also mentioned working with us on oversight. But since that's very important to me, let me say that the executive branch has always been one of my top priorities, regardless of who occupies the White House. I've often said I'm an equal opportunity overseer. Now, over the years, I've asked quite a few executive nominees, both Republican and Democrat, to make commitments to respond to oversight. You said you would, but in my experience, nominees are usually pretty receptive to oversight requests during these type of hearings, but after they've been confirmed, oversight doesn't seem to be a high priority for them. As I told you when we met privately in my office, sometimes I think nominees should go ahead and be a little more straightforward during their hearings. And instead of saying yes to everything we ask about oversight, it'd be more honest to say maybe when asked if they would respond to our questions. Now, because you've served on this committee and understand the importance of oversight, I'm hoping you'll be different than your predecessors in response to oversight questions. And so I have with me that I'll give to one of your staff a whole bunch of letters that haven't been answered yet. One of them even you signed with me to the Department of Justice. And I hope that you would go to great lengths to see that these gets answered. So next May or June, if I'm contacting you that they haven't been answered, then the Trump administration might be blamed for it. And these are all a result of not getting answers from the last administration. So I hope you'll help me get answers to these, at least the one you helped me write.
Mr. Chairman, you are correct that this committee has oversight, but it goes beyond that. This committee and the Congress funds the various branches of the executive branch, the various departments. And you have every right, before you fund our agencies and departments, to get responsive answers to questions that are proper. Sometimes the Congress is asked for issues that maybe there's legitimate reason to object to, but they should object and state why. Mr. Chairman, I will be responsive to your request, and I understand your history, perhaps more than anyone in this Congress, to advance the idea that the executive branch needs to be held accountable. And I salute you for it.
And if Senator Feinstein contacts you, don't use this excuse that so many people use, that if you aren't chairman of a committee, you don't have to answer the question. I want her questions answered just like you'd answer mine.
I understand that.
Senator Feinstein.
Thank you. Thank you. Thank you. That was above and beyond the call. Thank you, Mr. Chairman. I would like to begin with the second largest criminal industry in this country, which is now, believe it or not, by revenues produced, human sex trafficking. And trafficking victims are among the most vulnerable in our society. The average age is 12 to 14. They are beaten, raped, abused, at times handcuffed at night so they can't escape, and often moved from place to place, forced to have sex with multiple men each night. The Justice for Victims of Trafficking Act, signed into law in 2015, created a domestic trafficking victims fund for victim services to be administered by the Department of Justice. Part of that fund contains up to $30 million for health care or medical items or services to trafficking victims. These funds are subject to the Hyde Amendment, which says no appropriated funding can be used to pay for abortion. However, the Hyde Amendment does not apply in cases of rape. On the Senate floor, Senator Cornyn discussed the Hyde language and said, and I quote, "Everyone knows the Hyde Amendment language contains an exception for rape and health of the mother. So under this act, these limitations on spending wouldn't have anything to do with the services available to help those victims of human trafficking." In short, Senator Cornyn asserted that the Hyde Amendment, which contains an exception for rape, would not affect the availability of services for these victims. The Domestic Trafficking Victims Fund will be under the jurisdiction of the Department of Justice. Here's the question. Will you ensure that these grant funds are not denied to service providers who will assist victims of human trafficking in obtaining comprehensive services they need, including abortion, if that is what is required for a young girl impregnated during this horrific abuse?
Senator Feinstein, I appreciate that question, and I do appreciate the fact that our country has been talking and I believe taking action for a number of years to deal with sex trafficking more effectively. I don't know that we've reached the level of actual effectiveness we need to, but Congress and you and others have been very, very outspoken about this, and there are all kinds of great citizens groups that have focused on it. So it's a very important issue. I was not aware of how the language for this grant program has been established. I do appreciate your concerns on it. It's a matter that I have not thought through, but ultimately it's a matter for this United States Congress, not so much a matter for the Attorney General. We need to put our money out to assist in this activity according to the rules established by the Congress.
Well, I'm delighted that Senator Cornyn is here. I quoted him directly from the floor that the Hyde Amendment would not prevent the distribution of these funds. And so I hope you would agree to that. And that's certainly most important to me because Congress has spoken and the bill is law.
I understand that, and we would follow the law.
Okay. As you know, the Constitution also protects a woman's right to have access to health care and determine whether to terminate her pregnancy in consultation with her family and her doctor. I'm old enough to remember what it was like before, when I was a student at Stanford and thereafter. In the early 1960s, I actually sentenced women in California convicted of felony abortion to state prison for maximum sentences of up to 10 years, and they still went back to it because the need was so great. So was the morbidity, and so was the mortality. This right, passed now by the Constitution, as recognized in Roe, Planned Parenthood v. Casey, and the Supreme Court's recent decision in Whole Women's Health and Helterstedt. In fact, the court recently struck down onerous regulations imposed by Texas on women's health clinics. You have referred to Roe v. Wade as, quote, one of the worst, colossally erroneous Supreme Court decisions of all time, end quote. Is that still your view?
It is. I believe it violated the Constitution and really attempted to set policy and not follow law. It is the law of the land. It has been so established and settled for quite a long time, and it deserves respect, and I would respect it and follow it.
On November 14, 2016, appearing on the TV show 60 Minutes, the president-elect said that the issue of same-sex marriage was, quote, already settled. It's law. It was settled in the Supreme Court. It's done, and I'm fine with that. Do you agree that the issue of same-sex marriage is settled law?
Supreme Court has ruled on that. The dissented vigorously, but it was 5-4, and 5 justices on the Supreme Court, the majority of the court, has established the definition of marriage for the entire United States of America, and I will follow that decision.
Here's another question. If you believe same-sex marriage is settled law, but a woman's right to choose is not, what is the difference?
Well, I haven't said that the woman's right to choose or the Roe versus Wade and its progeny is not the law of the land or not clear today. So I would follow that law.
Thank you. I would like to ask one question based on the letter that we received for 1,400 law professors. They're from 49 states. Only Alaska's left out. I inquired why, and they said because Alaska doesn't have a law school. So it's a pretty comprehensive list representing law professors in every state that has a law school. What they said, and this is what I want you to respond to. Nothing in Senator Sessions' public life since 1986 has convinced us that he is a different man than the 39-year-old attorney who was deemed too racially insensitive to be a federal district court judge. Excuse me. All of us believe it's unacceptable for someone with Senator Sessions' record to lead the Department of Justice. So I want your response to this and answer to the question, how do you intend to put behind you what are strongly felt personal views, take off the political hat, and be an attorney general who fairly enforces the law and the Constitution for all?
Well, Senator Feinstein, I would direct their attention first to the remarks of Senator Specter, who in his entire career said he made one vote that he would regret, and that was the vote against me. He indicated he thought I was an egalitarian, a person who treated people equally and respected people equally. This caricature of me in 1986 was not correct. I had become United States Attorney. I supported, as the civil rights attorney said, major civil rights cases in my district that integrated schools, that prosecuted the Klan, that ended single-member districts, that denied African Americans the right to hold office. I did everything I was required to do. And the complaints about the voter fraud case and the complaints about the Klan case that I vigorously prosecuted and supported are false. And I do hope this hearing today will show that I conducted myself honorably and properly at that time, and that I am the same person, perhaps wiser and maybe a little better, I hope so, today than I was then, but I did not harbor the kind of animosities and race-based discrimination ideas that I was accused of. I did not.
Thank you. Thank you, Mr. Chairman.
Okay. Senator Hatch and then Senator Leahy.
Well, thank you, Mr. Chairman.
Before your time starts, I'd like to mention that the committee received a letter in support of Senator Sessions' nomination from Attorneys General Ashcroft, Barr, Gonzalez, Meese, and McKasey, as well as a number of former deputy attorney generals. They wrote in part as follows, a sentence from that letter. Based on our collective and extensive experience, we also know him to be a person of unwavering dedication to the mission of the department to assure that our country is governed by a fair and even-handed rule of law. I ask consent to put that letter in the record. Senator Hatch.
Well, thank you, Mr. Chairman. I first want to thank you for your fair approach to this, our first hearing of the 115th Congress. You've scheduled and you've structured this hearing in line with this committee's precedents. In fact, you're including more witnesses in this hearing than the past average for Attorney General nominees. Senator Sessions has provided this committee with more than 150,000 pages of material relevant to his nomination. That is 100 times what Attorney General Lynch Provost and almost 30 times what Attorney General Holder provided. This material comes from someone we know, someone many of us have served with in the Senate and on this very committee. Yet some on the far left will stop at nothing to defeat this nomination. They oppose this nomination precisely because Senator Sessions will not politicize the Justice Department or use its resources to further a political agenda. They make up one thing after another to create a caricature that bears no resemblance to the nominee, who is actually before us here today. Now, I've been on this committee for a long time, and I've seen these dirty tactics used before, and they're not going to work this time. Senator Sessions, it sounds a little strange to say this, but welcome to the Senate. The Senate Judiciary Committee. I'm sure there will be some need to address false claims and fabricated charges during this hearing. Believe it or not, however, I actually have some questions about issues and policies that you will be addressing when you become Attorney General. The first is one I have raised with every incoming Attorney General nominee for nearly 25 years, and it concerns enforcement of federal laws prohibiting obscenity. In the 108th Congress, you introduced Senate Concurrent Resolution 77, expressing the sense of the Congress that federal obscenity laws should be vigorously enforced throughout the United States. It pleased the Senate, it passed the Senate unanimously, it pleased it too. In fact, it is the only resolution on this subject ever passed by either the Senate or the House. Now, Senator Sessions, with your permission, I want to share with you that resolution adopted last year by the Utah legislature outlining why pornography should be viewed as a public health problem, as well as some of the latest research into the harms of obscenity. Is it still your view that federal laws prohibiting adult obscenity should be vigorously enhanced?
Mr. Chairman, those laws are clear, and they are being prosecuted today and should be continued to be effectively and vigorously prosecuted in the cases that are appropriate.
In making this a priority for the Justice Department, would you consider reestablishing a specific unit dedicated to prosecuting this category of crime?
So that unit has been disbanded. I'm not sure I knew that, but it was a part of the Department of Justice for a long time, and I would consider that.
Okay. For several years now, Senator Chris Coons and Representative Tom Marino and Susan Delben and I have raised the importance of safeguarding data privacy on an international scale from unauthorized government access. Now, that is why we continue to push forward the International Communications Privacy Act, which establishes a legal standard for accessing extraterritorial communications. The need for a legislative solution was reinforced in July when the U.S. Court of Appeals for the Second Circuit held in Microsoft v. United States that current law does not authorize U.S. law enforcement officials to access electronic communications stored outside the United States. If confirmed, will you and your staff work with us to strike the needed balance to strengthen privacy and promote trust in the United States technologies worldwide while enabling law enforcement to fulfill its important public safety mission?
That'll be a high responsibility, Senator. I know you've worked hard on that for a number of years, as have others, members of this committee, Senator Coons and others. So working that out, understanding the new technology, but the great principles of the right to privacy, the ability of individuals to protect data that they believe is private and should be protected. All of those are great issues in this new technological world we're in, and I would be pleased to work with you on that. And I do not have firm and fast opinions on the subject.
Well, thank you so much. Now, I'd like to turn now to rapid DNA, technology that will allow law enforcement officials to speedily process DNA samples in 90 minutes or less. FBI Director Comey told this committee that rapid DNA would help law enforcement, quote, change the world in a very, very exciting way, unquote. Legislation authorizing law enforcement to use this technology, which you co-sponsored, passed the Senate last year. I was disappointed, however, that it got tied up with criminal justice reform efforts in the House. Now, I have two questions. First, do you agree with FBI Director Comey and with law enforcement leaders across the country that rapid DNA legislation is important? and will help law enforcement to do their jobs better and faster? And secondly, do you agree with me that we should work to pass this legislation sooner rather than later and should avoid tying it to efforts on other legislative issues whose path forward is unclear?
Mr. Chairman, rapid DNA analysis is a hugely important issue for the whole American criminal justice system. It presents tremendous opportunities to solve crimes in an effective way and can produce justice because it is a kind of thing that you can't fake or mislead. So I am very strongly in favor of that. And my personal view, after many years in the law enforcement community, is that one of the biggest bottlenecks, colleagues, of all of our laws involving prosecutions of criminal activity is the bottleneck of the scientific analysis, the forensic sciences, where we fail sometimes to get DNA back, fail to get back fingerprint analysis, fail to get back drug analysis, chemical analysis, and all of this slows down and stops cases that should long since have been brought forward and disposed of.
Okay. I've read that some Democratic senators accuse you of opposing the Violence Against Women's Act. That caught my attention because, like I did, you actually voted to reauthorize it. As I recall, in 2013, there were not one but two bills to reauthorize VAWA, the Violence Against Women Act. One had controversial provisions that had never been received in a hearing. The other did not. Am I right that you supported reauthorizing the Violence Against Women Act?
Absolutely. I supported it in 2000 when it passed. I supported it in 2005 when the bill, both of those bills I supported became law. And then in this cycle, Senator Grassley had a bill that I thought was preferable, and I supported his bill that actually had tougher penalties than the other bill. And it is kind of frustrating to be accused of opposing VAWA, the Violence Against Women Act, when I have voted for it in the past. There was some specific add-on provision in the bill that caused my concern, and I think other people's concern.
And, Mr. Chairman, I ask consent to place in the record an op-ed published in USA Today on this subject by Penny Nance, president of Concerned Women for America, the nation's largest public policy women's organization, if you can.
Without objection, it will be included.
Now, I have a question about the Justice Department's Civil Rights Division. The division enforces the Religious Land Use and Institutionalized Persons Act, which protects the right of prison inmates to worship and protects churches and religious institutions from burdensome zoning and other restrictions. So I introduced this legislation in 2000. It passed without objection in both the Senate and the House. I would note for the record that next Monday, January 16th, is Religious Freedom Day. I hope that you will make the religious freedom of all Americans a priority under your leadership. The Civil Rights Division also has a unit dedicated to combating human trafficking. It was created in 2007, and one of my former Judiciary Committee counsels, Grace Chun Becker, was its first head. Perhaps you could comment on the significance of issues such as religious freedom and human trafficking and why it's important to include them within the civil rights agenda of the department.
Mr. Chairman, religious freedom is a great heritage of America. We respect people's religion. We encourage them to express themselves and to develop their relationships with the higher power as they choose. We respect that. It's mandated in the Constitution. But there are situations in which I believe we can reach accommodations that would allow the religious beliefs of persons to be honored in some fashion, as opposed to just dictating everything under a single provision or policy. So I believe you're correct. We should recognize religious freedom. It will be a very high priority of mine.
Well, that means a lot to me. Now, Mr. Chairman, let me close by asking consent to place in the record letters from the National Center for Missing and Exploited Children and the Boys and Girls Clubs of America. They attest to Senator Sessions' work on behalf of the vulnerable children and young people. And I also ask consent to place in the record a letter supporting this nomination from nearly 24 men and women who have served as Assistant Attorneys General in 10 different offices and divisions. They say that as both U.S. Senator and U.S. Attorney, quote, Senator Sessions has demonstrated a commitment to the rule of law and to the even-handed administration of justice. I could not agree more.
Without objection,
Thank you.
Those will be included.
Thank you.
Thank you, Mr. Chairman, and welcome Senator Sessions and Mrs. Sessions. Let me just follow up. You were just asked about Violence Against Women Act and your support. Let's deal with the facts. Let's deal with what was actually voted on. Let's deal with the Violence Against Women Act that you voted against. You strongly oppose the Violence Against Women Reauthorization Act of 2013. Spoke against it. You voted against it. That law expanded protections for some of the most vulnerable groups of domestic violence and sexual assault survivors, students, immigrants, LGBTQ victims, and those on tribal lands. Now, the Justice Department, by all accounts, has done an excellent job implementing and enforcing it over the last 3 years. I believe, and we were both prosecutors, I went to a lot of domestic violence scenes, crime scenes, as a young prosecutor. I believe that all victims of domestic and sexual violence deserve protection. Why did you vote against expanding protections for LGBT victims, students, immigrants, and tribal victims of domestic violence and sexual assault? Why did you vote no?
Mr. Chairman, I did indeed support the bill in 2000 and in 2000.
I'm talking about the bill that is the law today.
I understand
the law
what you're
today
saying.
is passed in 2013 by an overwhelming margin in the Senate and by an overwhelming margin in the Republican-controlled House, signed into law by President Obama. I'm asking about that. Why did you oppose it?
Mr. Chairman, a number of people opposed some of the provisions in that bill, not the entire bill.
I'm just asking about
I'm
you.
trying to answer.
Go ahead.
So when we voted in the committee, 8 of the 9 Republicans voted against the bill. One of the more concerning provisions was a provision that gave tribal courts jurisdiction to tri-persons who were not tribal members. That's contrary, I believe, the only time that's ever happened. That was the big concern that I raised, I believe, primarily on the legislation. So I voted with the chairman and the legislation he had that I thought did the job for protecting women, to reauthorize the Violence Against Women Act, but at the same time did not have other things attached to it that I thought were concerning.
Well, on the tribal courts, those have now been prosecuted very carefully. Defendants receive due process rights. They have to. None of the non-Indian defendants who have been prosecuted have appealed to federal courts. Many feel it's made victims on tribal land safer. Do you agree with that? Do you agree with the way the Justice Department has handled such cases?
Mr. Chairman, I do believe that the law has been passed by Congress. I'm interested to see how it plays out in the real world, and I will do my best to make my judgment about how to enforce that as Attorney General. Well, certainly the law itself has many powerful provisions that I'm glad was passed and that is in law and provides protections to women as victims of violence.
On the tribal lands, it's been used and prosecuted for 3 years. Do you feel it's been handled correctly?
Mr. Chairman, I have no understanding of that, but of the results of it so far. I'm interested, first time I've heard it commented on. Let me say this to you directly. In meeting with senators prior to this hearing, I've had quite a number, perhaps more than any other issue, that I learned a lot about, and that is that non-Indians that have been going on to tribal lands and committing crimes, including rape, have not been effectively prosecuted. Now, under current law and historically, they would be prosecuted in the federal government by the United States attorneys, and that has not been happening sufficiently, I am now convinced. So I do think the FBI, particularly maybe the Bureau of Indian Affairs investigators, should be beefed up, and the U.S. attorneys need to do probably a better job of prosecuting cases that need to be prosecuted in federal court.
Those were facts that came out pretty clearly in the hearings before you voted against that provision. That is why Senator Crapo and I and others included it in the bill. But let me, there have not been any tests of that. Nobody's appealed this, nobody's objected to it. But would you be able to, if somebody does, would you be able to defend it in court?
I would defend the statute if it's reasonably defensible. Yes, it's passed by Congress. It would be the duty of the Attorney General, whether they voted for it or support it, to defend it. And now, did I call you Mr. Chairman, a while ago? I think I did. So
well, that's okay.
You've been my chairman many years.
Listen, I spent 20 years back and forth on this. I'm delighted to turn it over to Senator Feinstein and Senator Grassley, but
well, you'll be handling all the money of the United States, I understand, in your new position.
In 2009, I offered the Matthew Shepard and James Byrd Hate Crimes Prevention Act as an amendment to the defense bill. It extended hate crimes protections to LGBT individuals, women, and individuals with disabilities. It passed the Senate overwhelmingly. You opposed it. You stated at a hearing that you're not sure women or people with different sexual orientations face that kind of discrimination. And then you said, I just don't see it. Do you still believe that women and LGBT individuals do not face the kind of discrimination that the hate crimes legislation was passed to prevent?
Mr. Chairman, Senator Leahy, having discussed that issue at some length, that does not sound like something I said or intended to say. What I did intend...
You did say it.
Well, I understand, but I've seen things taken out of context and not give an accurate picture. My view is and was a concern that it appeared that these cases were being prosecuted effectively in state courts where they would normally be expected to be prosecuted. I asked Attorney General Holder to list cases that he had that indicated they were not being properly prosecuted. I noted that Mr. Byrd was given the death penalty in Texas for his offense, and Mr. Shepard, there were 2 life sentences imposed as a result of the situation in his state. So the question simply was, do we have a problem that requires an expansion of federal law into an area that the federal government has not been historically involved? Senator Hatch had a proposal that we do a study to see the extent of the problem, and that we should have evidence that that indicates a shortage of prosecutions and a lack of willingness to prosecute before adding this law.
As far as the study, last year the FBI said that LGBT individuals were more likely to be targeted for hate crimes than any other minority group in the country. I mean, we can study this forever, but that's a pretty strong fact.
Well, I will tell you, Senator.
And in 2010, you stated expanding hate crime protections to LGBT individuals was unwarranted, possibly unconstitutional. You said the bill has been said to cheapen the civil rights movement, especially considering what the FBI has found. Do you still feel that way?
Mr. Chairman, the law has been passed. The Congress has spoken. You can be sure I will enforce it.
Thank you. When you were, well, I don't want to go as much over time as Senator Hatch did, but I'll ask you one question. The president-elect has repeatedly asserted his intention to institute a ban on Muslim immigrants to the United States. In December 2015, you voted against a resolution that I offered in this committee that expressed a sense of the Senate that the United States must not bar individuals from entering into the United States based on their religion. All Democrats, most Republicans, including the chairman, voted in support of my resolution. Do you agree with the president-elect that the United States can or should deny entry to members of a particular religion, based on their religion? I mean, we do background checks for terrorism, but based on their religion. Do you agree with the president-elect the United States can or should deny entry to all members of a particular religion?
Senator Leahy, I believe the president-elect has, subsequent to that statement, made clear that he believes the focus should be on individuals coming from countries that have history of terrorism, and he's also indicated that his policy and what he suggests is strong vetting of people from those countries before they're admitted to the United States.
Then why did you vote against the resolution?
I almost called you Mr. Chairman again. Senator Leahy, my view and concern was, in the resolution, it was suggesting that you could not seriously consider a person's religious views, even and often, sometimes, at least not in a majority, but many people do have religious views that are inimical to the public safety of the United States. I did not want to have a resolution that suggested that that could not be a factor in the vetting process before someone is admitted. But I have no belief and do not support the idea that Muslims as a religious group should be denied admission to the United States. We have great Muslim citizens who've contributed in so many different ways. And America, as I said in my remarks at the occasion that we discussed it in committee, are great believers in religious freedom and the right of people to exercise their religious beliefs.
Before I turn to...
Consent to put some items in the paper.
Yes, without objection, your inserts will be included. I have a letter from Solicitor General Ted Olson in support of Senator Sessions, quoting in part, with respect to civil rights, he says, quote, as a lawyer who has devoted years of effort to litigating and vindicating the civil rights of our fellow gay, lesbian, and transgender citizens, I recognize that people of good faith can disagree on legal issues. Such honest disagreement should not disqualify them from holding public office. In particular, I have no reservations about Senator Sessions' ability to handle these issues fairly in accordance with law and to protect the civil rights of these and all of our citizens. I'd like to include that in the record without objection. Senator Graham.
Thank you, Mr. Chairman. We're about to get an answer to the age-old question, can you be confirmed Attorney General of the United States over the objection of 1,400 law professors? I don't know what the betting line in Vegas is, but I like your chances. Speaking of football, I want to congratulate the University of Alabama for one heck of a streak. One of the most dominant football teams in the history of college football. And I want to acknowledge the Clemson Tigers, where I live 5 miles from the stadium, that was the finest college football game I think I've ever seen. Yeah. Dabo Swinney and the Tigers represent everything good about college athletics. And while we were on different teams early this morning, I want to let the good people of Alabama know that in terms of their Senator Jeff Sessions, he is a fine man, an outstanding fellow who I often disagree with. I've traveled the world with. I've got to know him and his family, and I will enthusiastically support you for the next Attorney General of the United States. Now, let's talk about issues. Some people believe that the only way you can get justice in this world is for the federal government to administer it. Have you heard such thoughts?
Well, I have.
Yeah.
I think I know what you're talking about.
Yeah, I think I do too. I think the whole point is for the federal government to take over an area of law, there should be a good reason. Do you agree with that?
Yes.
If a state's not prosecuting crimes against people based on their sex, their race, whatever reason, then it's proper for the federal government to come in and provide justice. Do you agree with that?
I do.
When the state's doing its job, the federal government should let the states do their job.
That is correct. That's
That's
the
the
general
way-
principle, and there's not a general federal crime, federal statute that federalizes all crime in America.
To the
It's never
people who are
been-
listening, that's just the way we think. You may not agree with that, but we think that way. And I think we really got a good reason to think that way. I think that's the way they set up the whole system. Muslims. As you know, me and the president-elect have had our differences about religious tests. Would you support a law that says you can't come to America because you're a Muslim?
No.
Would you support a law that says that if you're a Muslim, you say you're a Muslim, and when we ask you, what does that mean to you? Well, that means I got to kill everybody that's different from me. It's okay to say they can't come.
I think that would be a prudent decision.
I hope we can keep people out of the country who want to kill everybody because of their religion. I hope we're smart enough to know that's not what most people in the Muslim faith believe. So
But it can be the religion of that person.
that's right. That's the point we're trying to make here. About the Wire Act, what's your view of the Obama administration's interpretation of the Wire Act to allow online video poker or poker gambling?
Senator Graham, I was shocked at the memorandum, I guess the enforcement memorandum that the Department of Justice issued with regard to the Wire Act and criticized it. Apparently, there is some justification or argument that can be made to support the Department of Justice's position, but I did oppose it when it happened, and it seemed to me to be an unusual.
Would you revisit it?
I would revisit it, and I would make a decision about it based on careful study, rather than, and I haven't gone that far to give you an opinion today.
Immigration. You've said that the executive order of President Obama you believe is unconstitutional, the DACA law. Do you still have that position?
I did, for a number of reasons.
Well, no, I'm not, I mean,
Right.
I agree with you. Now, we got 800,000 people have come out of the shadows that have been signed up. Will you advise the next president, President Trump, to repeal that executive order?
There will be a decision that needs to be studied and that he would need to agree to, but it's an executive order, really a memorandum of the Department of Homeland Security. It would certainly be constitutional, I believe, to end that order, and the Department of Justice, I think, could have no objection to a decision to abandon that order because it is very questionable, in my opinion, constitutionally.
Once we repeal it, and I agree that I believe it is an overreach, what do we do with the 800,000 kids who've come out of the shadows?
Senator Graham, fundamentally, we need to fix this immigration system. Colleagues, it's not been working right. We've entered more and more millions of people illegally into the country. Each one of them produces some sort of humanitarian concern, but it is particularly true for children. So we've been placed in a bad situation. I really would urge us all to work together. I would try to be supportive.
Would you prefer
to end the illegality and put us in a position where we can wrestle with how to handle these difficult, compassionate decisions.
Right. And the best way to do it is for Congress and the administration to work together and pass a law, not an executive order.
Exactly.
Okay. When it comes to the law of war, do you believe that people who join al-Qaeda or affiliated groups are subject to being captured or killed under the law of war?
I do, Senator. I don't see how we could see it otherwise. And it's the responsibility of the military to protect the United States from people who attack us.
Do you believe the threats to the homeland are growing or lessening?
I believe they are growing, and we're seeing that now in Europe, and we're also seeing it right here in America.
Do you support the continuation of Gitmo as a confinement facility for foreign terrorists?
Senator Graham, I think it's designed for that purpose. It fits that purpose marvelously well. It's a safe place to keep prisoners. We've invested a lot of money in that, and I believe it should be utilized in that fashion, and have opposed the closing of it. But as Attorney General,
I just wanted to see if they were still listening. I think they're on the fence about Gitmo, but I'm not sure. Let me tell you, I support this administration's effort to make sure we prosecute terrorism as a military action, not a law enforcement action. They're not trying to steal our cars or rob your bank account. They're trying to destroy our way of life, and I hope you'll go after them without apology, apply the law, and the law is the law of war, not domestic criminal law, and you'll have a friend in Senator Graham if you intend to do that. Cyber attacks. Do you think the Russians were behind hacking into our election?
I have done no research into that. I know just what the media says about it.
Do you think you could get briefed anytime soon?
Well, I'll need to.
I think you do too. You like the FBI?
Do I like them?
Yeah.
Some of my best friends are FBI.
Do you generally trust them?
Yes.
Are you aware of the fact that the FBI has concluded that it was the Russian intelligence services who hacked into the DNC and Podesta's emails?
I do understand that.
From your point
Or
of
at
view.
least that's what's been reported, and I've not been briefed by them
Right.
On the subject.
From your point of view, there's no reason for us to be suspicious of them.
Of their decision?
Yeah.
I'm sure it was honorably reached.
How do you feel about a foreign entity trying to interfere in our election? I'm not saying they changed the outcome, but it's pretty clear to me they did. How do you feel about it? What should we do?
Senator Graham, I think it's a insignificant event. We have penetration apparently throughout our government by foreign entities. We know the Chinese have revealed millions of background information on millions of people in the United States. And these, I suppose, ultimately are part of international big power politics. But when a nation uses their improperly gained or intelligence-wise gained information to take policy positions that impact another nation's democracy or their approach to any issue, then that raises real serious matters. It's really, I suppose, goes in many ways to the State Department, our Defense Department, and how we as a nation have to react to that, which would include developing some protocols where when people breach our systems that a price is paid, even if we can't prove the exact person who did it.
I agree. I got 20 seconds left. I've known you for, I guess, 15 years now, and we've had a lot of contests on the floor, and sometimes we agree, sometimes we don't. I'm from South Carolina, so I know what it's like sometimes to be accused of being a conservative from the South. That means something other than you're a conservative from the South. In your case, people have fairly promptly tried to label you as a racist or a bigot or whatever you want to say. How does that make you feel? And this is your chance to say something to those people.
Well, it does not feel good.
If nothing else, I'm clearing the room for you. And I would suggest that the freedom of speech also has some courtesy to listen. So what's your answer?
Senator Graham, I appreciate the question. You have a southern name. You come from South Alabama. That sounds worse to some people, South Alabama. When I came up as a United States attorney, I had no real support group. I didn't prepare myself well in 1986. And there was an organized effort to caricature me as something that wasn't true. And it was very painful. I didn't know how to respond and didn't respond very well. I hope my tenure in this body has shown you that the caricature that was created of me was not accurate. It wasn't accurate then, and it's not accurate now. And I just want you to know that as a Southerner who actually saw discrimination and have no doubt it existed in a systematic and powerful and negative way to the people, great millions of people in the South, particularly of our country, I know that was wrong. I know we need to do better. We can never go back. I am totally committed to maintaining the freedom and equality that this country has to provide to every citizen, and I will assure you that that's how I will approach it.
Senator Durbin.
Thank you, Mr. Chairman. Senator Sessions, let me first say I'm glad that you brought your family with you today. It's a beautiful family with your wife and your son and daughters and those 4 beautiful little granddaughters. And you kept them as quiet as you could for as long as you could. So thank you so much for being here today. I'm sure it was great moral support and part of your effort here today. When you came by my office last week, I talked to you about a man named Alton Mills, and with the permission of the chair, he's my guest today. I asked Mr. Mills if he'd please stand up. Alton, thank you for being here today. I'd like to tell you a story so you can understand my question a little better. When Alton Mills was 22 years old, unemployed, he made a bad decision. He started selling crack cocaine on the streets of Chicago. He was arrested twice for possession of small amounts of crack cocaine. The third time that he was arrested, the kingpins who had employed him turned on him, and as a consequence, he ended up being prosecuted under the 3 strikes and you're out law. At the age of 24, he was sentenced to life without parole. He had never been in prison before, and as I mentioned, there were no allegations made against him other than possession and sale, no violence, no guns, nothing of that nature. Alton Mills ended up, despite the sentencing judge's admonition that he believed this was fundamentally unfair and his hands were tied, Alton Mills ended up spending 22 years in federal prison until December 2015 when President Obama commuted his sentence. He was finally able to go home to his family. Senator Sessions, 7 years ago, you and I co-sponsored a bill known as the Fair Sentencing Act, which Senator Collins referenced earlier, and that reduced the brutal sentencing disparity for crack cocaine crimes over powder cocaine. It was originally 100 to 1. We agreed in the Senate Gym, I might add, to bring that down to 18 to 1. Inmates, overwhelmingly African American, were spared thousands of prison years because of our joint effort to end this injustice. Yet when I asked you to join me in appealing to the Sentencing Commission to follow our law, and when I asked you to join Senator Grassley and me in permitting the almost 5,000 still serving under this unfair 100 to 1 standard to petition individually for leniency, you refused. And you said of President Obama's pardoning of people like Alton Mills, and I quote, "President Obama continues to abuse executive power in an unprecedented, reckless manner to systematically release high-level drug traffickers and firearms felons. So-called low-level nonviolent offenders simply do not exist in the federal system," you said. Senator Sessions, Alton Mills, and many more just like him do exist. So if you refuse to even acknowledge the fundamental injustice of many of our sentencing laws, Why should you be entrusted with the most important criminal prosecution office in America?
Senator Durbin, I think that's rather unfair based on our relationship and how we work together. In 2001, I introduced legislation very similar to the bill that you and I successfully made law. It would have reduced it to 20 to 1. Our bill went to 18 to 1, a little better, but fundamentally that. I was criticized by the Bush Department of Justice. My legislation was opposed by them. It was 7 years later or so, or really longer, before our bill ever passed. So I stepped out against my own Republican administration and said openly on the floor of the Senate that I believe these crack cocaine laws were too harsh, and particularly it was disadvantageous to the African-American community where most of the punishments were falling. And it was not fair, and we ought to fix it. So I just want to say, I took a strong stand on that, and I did not agree, you and I did not agree on the retroactivity because a lot of these were plea bargain cases and may not have been totally driven by the mandatory minimums. But so I thought the court had basically now agreed that it is retroactive. I don't know what group is not being covered by it, but a large group was covered by a court decision. We sort of left it open, as I remember.
We did.
You and I discussed it.
Let me say, on the issue of fairness, I will acknowledge you stepped out on this issue. And you and I both recognize the brutal injustice of 100 to 1. And we agreed on 18 to 1. That's how laws are made. And now we have 5,000 prisoners sitting in federal prison, still there under this brutal, unjust 100 to 1. And all I've asked, and all Senator Grassley's asked, allow them as individuals to petition to the judge, to the prosecutor, to the Department of Justice, so that their sentences could be considered. That's something you've opposed. So in fairness, tell me why you still oppose that.
Well, first I will tell you with absolute certainty that if this is a decision of this body, it's not the Attorney General's decision about when and where a mandatory minimum is imposed and whether it can be retroactively altered. So I will follow any law that you passed, number one. Number two, I understood the sincere belief you had on that issue, and it was a difficult call, and that's why we really never worked it out. So I understand what you're saying, but I did believe that you are upsetting finality in the justice system, that you are suggesting that these kind of factors were not considered when the plea bargaining went down. So it's an honorable debate to have, and I respect your position on it.
Senator, you have been outspoken on another issue, and I would like to address it if I could. I have invited here today Sergeant Oscar Vasquez, if he would be kind enough to stand up and be recognized. Sergeant, thank you for being here. I'll tell you his incredible story in short form. Brought to the United States as a child. In high school, he and 3 other dreamers started a robotics club and won a college-level robotics competition. They made a movie out of his story. He graduated from Arizona State University with an engineering degree. The Obama administration granted him a waiver and allowed him to become a citizen and enlist in the United States Army, where he served in combat in Afghanistan. Senator Sessions, since joining the Senate in 1997, you'd voted against every immigration bill that included a path to citizenship for the undocumented. You described the DREAM Act, which I introduced 15 years ago to spare children who are undocumented through no fault of their own, as, quote, a reckless proposal for mass amnesty. You opposed the bipartisan comprehensive immigration reform bill, which passed the Senate 4 years ago. You've objected to immigrants volunteering to serve in our armed forces, saying, quote, in terms of who's going most likely to be a spy, somebody from Cullman, Alabama, or somebody from Kenya. When I asked what you would do to address the almost 800,000 dreamers like Oscar Vasquez, who would be subject to deportation if President Obama's executive order was repealed, you said, quote, I believe in following the law. There is too much focus on people who are here illegally and not enough on the law. Senator Sessions, there's not a spot of evidence in your public career to suggest that as Attorney General, you would use the authority of that office to resolve the challenges of our broken immigration system in a fair and humane manner. Tell me I'm wrong.
Well, you are wrong, Senator Durbin. I'm going to follow the laws passed by Congress. As a matter of policy, we disagreed on some of those issues. I do believe that if you continually go through a cycle of amnesty, that you undermine the respect for the law and encourage more illegal immigration into America. I believe the American people spoke clearly in this election. I believe they agreed with my basic view, and I think it's a good view, a decent view, a solid legal view for the United States of America, that we create a lawful system of immigration that allows people to apply to this country, and if they're accepted, they get in. If they're not accepted, they don't get in, and I believe that's right and just, and the American people are right to ask for it. We have not delivered that for them.
Senator Graham asked this question, and I listened to your answer. When he asked you what would happen to those 800,000 currently protected by President Obama's executive order known as DACA, who cannot be deported for 2 years, it's renewable, and can work for 2 years, and you said, let Congress pass a comprehensive immigration reform bill. You opposed the only bipartisan effort that we've had on the Senate floor in modern memory. And what's going to happen to those 800,000 if you revoke that order and they are subject to deportation tomorrow? What is going to happen to them? What is the humane legal answer to that?
Well, the first thing I would say is that my response to Senator Graham dealt with whose responsibility this is. I had a responsibility as a member of this body to express my view and vote as I believe was correct on dealing with issues of immigration. That's not the Attorney General's role. The Attorney General's role is to enforce the law. And as you know, Senator Durbin, we're not able financially or any other way to seek out and remove everybody that's in the country illegally. President Trump has indicated that criminal aliens, like President Obama indicated, certainly are the top group of people. And so I would think that the best thing for us to do, and I would urge colleagues that we understand this, let's fix this system. And then we can work together after this lawlessness has been ended, and then we can ask the American people and enter into a dialogue about how to compassionately treat people who've been here a long time.
That does not answer the question about 800,000 that would be left in the lurch, whose lives would be ruined while you're waiting on Congress for a bill that you opposed.
Well, I thought it did answer it pretty closely to what you asked, and I understand your concerns.
Senator Cornyn.
Senator Sessions, congratulations to you and your family on this once-in-a-lifetime honor to serve as the head of the Department of Justice. You know, sitting here listening to the questions and some of the comments that have been made, both by the protesters and others, it strikes me that many people have been surprised to learn more about your record, your outstanding record as a prosecutor, or somebody who treated that responsibility to uphold and enforce the law and the Constitution without fear or favor. I think some people here listening today have been somewhat surprised by your record in complete context. Those of us who've served with you in the Senate, some as many as 20 years, like Senator Shelby and Senator Collins, testified to your character. But I like to think that those of us who serve with you most closely in the Senate, particularly here on the Judiciary Committee, know more about you than just your record and your character. We know your heart. We know what kind of person you are. You're a good and decent and honorable man. You've got an outstanding record that you should be proud of, and I know you are, and you should be. For example, when somebody says that you unfairly prosecuted some African Americans for voter fraud in Alabama, it strikes me as incomplete, is the most charitable thing I can say, when they leave out the fact that the very complainants in that case were also African Americans. In other words, the people you prosecuted were African Americans, but the people whose voting rights you were trying to vindicate were African Americans. Isn't that correct?
That is correct.
Does that strike you as a fair characterization of your approach toward enforcing the law, that people would leave that important factor out?
It's not, Senator Cornyn, and it's been out there for a long time. If you ask people who casually follow the news, they probably saw it otherwise. And these were good people who had tried. They asked me to get involved in this case in 2002. A majority African-American grand jury with African-American foreman asked the federal government to investigate the 1982 election. I declined. I hoped that that investigation would have stopped the problem. But 2 years later, the same thing was happening again. We had African-American incumbent officials pleading with us to take some action. We approached the Department of Justice in Washington, the Public Integrity Voting Section. They approved an investigation, and it developed into a legitimate case involving charges of vote fraud, taking absentee ballots from voters, opening them up and changing their vote and casting them for somebody they did not intend the vote to be cast for. It was a voting rights case, and I just feel like we tried to conduct ourselves in the right way. I never got in the argument of race or other matters. I just tried to defend myself as best I could. I would note, colleagues, and just in the last few days, the son of Albert Turner has written a letter and said I was just doing my job, and he understood the reason and the justification for the prosecution, and that I would be a good attorney general. So that was gratifying to me, and that's the real truth of the matter.
Senator Sessions, I know the nature of these confirmation hearings is that people pick out issues that they're concerned about or where there may be some good faith disagreement on policy, and that's what they focus on. But let me just ask you, maybe it's not a great analogy, but let me try anyway. You've been married to your wife, Mary, almost 50 years, right?
Well, it hadn't gotten to 50 yet, 47, soon
47,
to be 48.
okay. Well, that's a good run. Let me just ask.
Let it continue.
Are there,
I've been blessed.
Are there occasions when you and your wife disagree?
No, Senator. Wait a minute, I'm under oath. On occasion, we do, yes.
Well, do you think it would be fair to characterize the nature of your relationship with your wife based upon those handful of disagreements that you've had with her over time?
That's a good point. Thank you for making it. No, I don't.
Well, and to your original point, your wife is always right.
That is correct.
You are under oath. Well, so this is the nature of these confirmation hearings. People are identifying specific issues where there are policy differences. But my point is that does not characterize your entire record of 20 years in the United States Senate or how you've conducted yourself as a prosecutor representing the United States government in our Article III courts. Let me get to a specific issue, a couple in the time I have remaining. I was really pleased to hear you say in your opening statement that many in law enforcement feel that our political leaders have on occasion abandoned them. You said police ought to be held accountable. But do you believe that it is ever, under any circumstances, appropriate for somebody to assault a police officer, for example?
There's virtually no defense for that kind of action, and I do believe that we are failing to appreciate police officers who place their lives at risk, as this sergeant was just killed yesterday trying to deal with a violent criminal and vindicate the law, and she was killed. That is the kind of thing that too often happens. We need to be sure that when we criticize law officers, it is narrowly focused on the right basis for criticism, and to smear whole departments places those officers at greater risk. And we are seeing an increase in murder of police officers. It's up 10% last year. So I just could say I could feel in my bones how it was going to play out in the real world when we had what I thought oftentimes was legitimate criticism of a perhaps wrongdoing by an officer, but spilling over to a condemnation of our entire police force. And morale has been affected, and it's impacted the crime rates in Baltimore and crime rates in Chicago. I don't think there's any doubt about it. I regret that's happening. I think it can be restored, but we need to understand the requirement that police work with the community and be respectful of their community, but we as a nation need to respect our law officers too.
Well, I, for one, appreciate your comments, because we ought to hold our police and law enforcement officers up in the high regard to which they deserve based on their service to the communities. And your comments remind me to some extent of Chief David Brown's comments, the Dallas police chief, following the tragic killing of 5 Dallas police officers recently, where he said that police ought to be held accountable, but under no circumstances could any assault against a police officer be justified based on what somebody else did somewhere at some time. So I, for one, appreciate that very much. You mentioned Baltimore and Chicago, and we've seen an incredible number of people, frequently in minority communities, who've been killed as results of crimes related to felons who perhaps are in possession of guns that they have no legal right to be in possession of. Earlier, you talked about prosecuting gun crimes, and I'm glad to hear you say that. Project Exile, which originated, I think, in Richmond, Virginia, which targeted felons and other people who cannot legally own or possess firearms, was enormously effective. And when I look at the record of the last 5 and 10 years at the Justice Department, prosecution of those kinds of crimes down 15.5% in the last 5 years, down 34.8% in the last 10 years. Can you assure us that you will make prosecuting those people who cannot legally possess or use firearms a priority again in the Department of Justice and help break the back of this crime wave that's affecting so many people in our local communities like Chicago or Baltimore, and particularly minority communities?
I can, Senator Cornyn. I'm familiar with how that plays out in the real world. My best judgment, colleagues, is that properly enforced, the federal gun laws can reduce crime and violence in our cities and communities. It was highlighted in Richmond and Project Exile, but I have to tell you, I've always believed that. When I was United States Attorney in the 80s and into the early 90s, we produced a newsletter that went out to all local law enforcement called Project Triggerlock, and went to federal law enforcement too, and it highlighted the progress that was being made by prosecuting criminals who use guns to carry out their crimes. Criminals are most likely the kind of person that will shoot somebody when they go about their business. And if those people are not carrying guns because they believe they might go to federal court, be sent to a federal jail for 5 years perhaps, they'll stop carrying those guns during their drug dealing and their other activities that are criminal. Fewer people get killed. Fewer people get killed. So I truly believe that we need to step that up. It's a compassionate thing. If one of these individuals carrying a gun shoots somebody, not only is there a victim, they end up with hammering and sentence in jail for interminable periods. The culture, the communities are safer with fewer guns in the hands of criminals.
Thank you.
Before we go to Senator Whitehouse, members have asked me about our break. And if it's okay with Senator Sessions, it would work out about 1 o'clock if we have 3 on this side and 3 on this side for the 1 hour, because it's noon right now. Is that okay with you, Senator Sessions?
Mr. Chairman, I'm at your disposal.
And so this will give my colleagues an opportunity that want to go to the respective political party caucuses to go. And we would take a recess of about 30 to 40 minutes.
That's very fair.
Okay. Thank you, Senator. So then now, Senator Whitehouse.
Senator Sessions, hello.
Thank you, Senator Whitehouse.
When we met, I told you that I was going to ask you a particular question, so I'm going to lead off with that particular question. Following the Gonzalez scandals at the Department of Justice, the department adopted procedures governing communications between the White House and the Department of Justice, consistent with constraints that were outlined years ago in correspondence between Senator Hatch and the Reno Justice Department, limiting contacts between a very small number of officials at the White House and a very small number of officials at the Department of Justice. Will you honor and maintain those procedures at the Department of Justice?
I will, Senator Whitehouse. You, as an honorable and effective United States Attorney yourself, know how that works and why it's important. Attorney General McCasey issued a firm and
Very clear about supporting that policy. Yes.
Maybe still pending, and I would say to you, well, that's the appropriate way to do it. After you and I talked, I've read the Reno Memorandum, the Gorelick Memorandum, and I think I would maintain those rules.
On the subject of honorable prosecutions, when is it appropriate for a prosecutor to disclose derogatory investigative information about a subject who was not charged?
That's a very dangerous thing, and it's a pretty broad question as you've asked it, but you need to be very careful about that, and there are certain rules, like grand jury rules, that are very significant.
And isn't it also true that it is customary practice, because of the concern about the improper release of derogatory investigative information, that the department customarily limits its factual assertions, even after an individual has been charged, to the facts that were charged in the information or the indictment?
I believe that's correct, yes. That's a standard operating policy in most offices. There may be some exceptions, but I think that's standard operating procedure in the United States Attorney's offices like you and I had.
As a question of law, does waterboarding constitute torture?
Well, there was a dispute about that when we had the torture definition in our law. The Department of Justice memorandum concluded it did not necessarily prohibit that, but Congress has taken an action now that makes it absolutely improper and illegal to use waterboarding or any other form of torture in the United States by our military and by all our other departments and agencies.
Consistent with the wishes of the United States military.
They have been supportive of that, and in fact, I just take a moment to defend the military. The military
You don't need to defend them from me. I'm all for our military.
But so many people, truly believe, think that the military conducted waterboarding. They never conducted any waterboarding. That was by intelligence agencies. Their rules were maintained. I used to teach the Geneva Conventions and the rules of warfare as an Army reservist to my personnel, and the military did not do that.
And General Petraeus sent a military-wide letter disavowing the value of torture, as we both know. Another question as a matter of law. Is fraudulent speech protected by the First Amendment?
Well, fraudulent speech, if it amounts to an attempt to obtain a thing of value for the person the fraudulent speech is directed,
which is an element of fraud.
Absolutely fraud and can be prosecuted. And I think we see too much of that. We see these phone calls at night to elderly people. We see mailings go out that seem to me to be awfully far from truth and seducing people to probably make unwise decisions.
So fraudulent corporate speech would also not be protected by the First Amendment.
That is correct, and it's subject to civil and or criminal complaint.
And speaking of civil complaints, was the Department of Justice wrong when it brought and won the civil RICO action against the tobacco industry?
Well, Senator, they won those cases. They took them to court and eventually won a monumental victory. That is correct. And it's
hard to say
part of the law and firmly established.
Hard to say they were wrong if they won, right?
That's correct.
As you know, the United States has retaliated against Russia for its interference with the 2016 elections. In Europe, Baltic states, Germany, and Italy have raised concerns of Russia meddling in their country's elections. I know this has been touched on before, but I want to make sure it's clear. Will the Department of Justice and the FBI under your administration be allowed to continue to investigate the Russian connection, even if it leads to the Trump campaign and Trump interests and associates? And can you assure us that in any conflict between the political interests of the president and the interests of justice, you will follow the interests of justice, even if your duties require the investigation and even prosecution of the president, his family, and associates?
Well, Senator Whitehouse, if there are laws violated and they can be prosecuted, then of course you'll have to handle that in an appropriate way. I would say that the problem may turn out to be, as in the Chinese hacking of our hundreds of thousands of, maybe millions of records, it has to be handled at a political level. And I do think it's appropriate for a nation who feels that they've been hacked and that information has been improperly used to retaliate against those actions. It's just
and I know we share a common interest in advancing the cybersecurity of this nation, and I look forward to continuing to work with you on that. Let me ask you a factual question. During the course of this boisterous political campaign, did you ever chant, "Lock her up"?
No, I did not. I don't think. I heard it in rallies and so forth, sometimes I think humorously done, but it was a matter that I have said a few things, a special prosecutor. I favored that. I think that probably is one of the reasons I believe that I should not make any decision about any such case.
And you understand that the good guy lawman in the movies is the one who sits on the jailhouse porch and doesn't let the mob in.
Exactly. Exactly.
So I'm from Rhode Island, as you know, Senator. We have NAACP and ACLU members who've heard you call their organization, who've heard that you called their organizations un-American. We have a vibrant Dominican community who look at Big Papi, David Ortiz, swinging his bat for the Red Sox and wonder why you said, quote, "Almost no one coming from the Dominican Republic to the United States is coming here because they have a provable skill that would benefit us." I represent a lot of Latinos who worry about modern-day Palma raids, breaking up parents from their kids, and Muslims who worry about so-called patrols of Muslim homes and neighborhoods. And I've heard from police chiefs who worry that you, as Attorney General, will disrupt law enforcement priorities that they have set out and disrupt the community relations that they have worked hard over years of community engagement to achieve. Time is short, but I noticed that in your prepared remarks, these are not unforeseeable concerns, and your prepared remarks did very little to allay the concerns of those people. Is there anything you'd like to add now in our closing minute?
Well, thank you. My comment about the NAACP arose from a discussion that I had where I expressed concern about their statements that were favoring, as I saw it, Sandinista efforts and communist guerrilla efforts in Central America. And so I said they could be perceived as un-American and weaken their moral authority to achieve the great things they had been accomplishing in integration and moving forward for reconciliation throughout the country. And I believe that clearly. And I never said and accused them of that. Number two,
so what would you
with
tell
regard
Jim Vincent of the NAACP in Rhode Island right now? He's the head of the NAACP.
Well, I would say, please look at what I've said about that and how that came about. And it was not in that context. It was not correct. I said in 1986 that NAACP represents one of the greatest forces for reconciliation and racial advancement of any entity in the country, probably number one. That's what I said then, and I believed it, and I believe it now. And it's an organization that has done tremendous good for us. With regard to the Dominican Republic, I had gone on a CODEL with Senator Specter. We came through the Dominican Republic. We visited public service housing projects that seemed to be working and did other things of that nature. And I went and spent some time with the consular official there just to ask him about things. And what I learned was that there's a good bit of fraud in it, and he was somewhat discouraged in his ability to, he felt, to do his job. And we also understood and discussed that the immigration flow is not on a basis of skills. The immigration flow from almost all of our countries, frankly, is based on family connection and other visas rather than a skilled-based program more like Canada has today. And that's all I intended to be saying there. Tell anybody that heard that statement, please don't see that as a diminishment or a criticism of the people of the Dominican Republic. It was designed to just discuss, in my remarks, the reality of our immigration system today. I'd like to see it more skill-based, and I think that would be helpful.
Mr. Chairman, my time's expired. Thank you for your patience.
Thank you, Senator Whitehouse. Before I go to Senator Lee, there's an evaluation of the work of Senator Sessions during his time as U.S. Attorney that I think speaks to his outstanding record. I'm made aware of this because Senator Feinstein requested an evaluation of Senator Sessions' office from the Department of Justice, and I'd note just a few points from their evaluation. Back in 1992, a couple short sentences. All members of the judiciary praised the U.S. Attorney for his advocacy skills, integrity, leadership of the office, and accessibility. And the second quote, the USAO for the Southern District of Alabama is an excellent office with outstanding leadership, personnel, and morale. The district is representing the United States in a most capable and professional manner. I, without objection, will put that in the record. Senator Lee.
Mr. Chairman,
yeah.
While we're putting things into the record, could I join?
Yes, please do
unanimous
that.
Consent that a December 5th, 2016 letter from leaders of the U.S. environmental movement and a January 5th, 2017 letter from the National Task Force to End Sexual Violence and Domestic Violence Against Women be added to the record.
Yes, and those will be included without objection. Senator Lee.
Hello, Senator Sessions.
Hello.
I've enjoyed working with you over the last 6 years and always found you to be someone who treats colleagues, regardless of differing viewpoints, with dignity and respect. You've taught me a great deal in the 6 years I've been here, and I've appreciated the opportunity to work with you. I think a lot of this has to do with the fact that we're both lawyers, although being a lawyer around here, certainly having a law degree is not unusual. One of the things that sets you apart and makes you different, I get the sense from you that you think of yourself not so much as a senator who used to be a lawyer, but as a lawyer who is currently serving as a senator. And I think that's an important thing, especially for someone who's been named to be the next Attorney General of the United States. Even though you and I have never had the opportunity to discuss the intricacies of the rule against perpetuities or the difference between the doctrine of worthier title and the rule in Shelley's case, I get the sense that you would eagerly engage in such banter when occasion arises. So maybe in a subsequent round we'll have the opportunity to do that. But this does raise a discussion that I'd like to have with you about the role of the lawyer. Because you know what, a lawyer understands who his or her client is. Anytime you are acting as a lawyer, you've got a client. This is a simple thing if you're representing an individual, because in almost every instance, unless the client is incapacitated, you know who the client is. The client has one mouthpiece, one voice, and you know what the interests of that client are, and you can evaluate those based on the interests expressed by the client. It gets a little more complicated when you're representing a corporate entity. Typically, you'll interact either with a general counsel or with a chief executive officer. The bigger an entity gets, the more complex it gets. There might be some ripples in this relationship between the lawyer and the client. In the case of the U.S. government and the Attorney General's representation of that client. This is a particularly big and powerful client, and that client has many interests. In a sense, the client is, of course, the United States of America, but at the same time, the Attorney General is there, put in place by the President of the United States, and serves at the pleasure of the President of the United States. And so, in that respect, the Attorney General has several interests to balance and must at once regard him or herself as a member of the President's cabinet, remembering how the Attorney General got there and can be removed at any moment by the President. And at the same time, the Attorney General has the obligation to be independent, to provide an independent source of analysis for the President and for the President's team and cabinet. How do you understand these things as a former U.S. attorney, as a former line prosecutor, and as a senator who served on the Judiciary Committee? You've had a lot of opportunities to observe this process. How do you see the proper balancing between all these interests from the standpoint of the Attorney General?
That's a very insightful or probing question, and it touches on a lot of the important issues that we, as Attorney General, would need to deal with. There are even sometimes these government agencies are like foreign countries. They negotiate memorandums of understanding that are akin to a treaty, actually. They can't seem to work together oftentimes in an effective way. And so the Attorney General is required to provide opinions on that. The Attorney General ultimately owes his loyalty to the integrity of the American people and to the fidelity to the Constitution and the legitimate laws of the country. That's what he's ultimately required to do. However, every Attorney General that has been appointed by a president, or they wouldn't become Attorney General, and they've been confirmed by the Senate, or they wouldn't be made Attorney General. And so they do understand, I think, that if a president wants to accomplish a goal that he or she believes in deeply, then you should help them do it in a lawful way, but make clear and object if it's an unlawful action. That helps the president avoid difficulty. It's the ultimate loyalty to him. And you hope that a president, and I hope President-elect Trump has confidence in me, so that if I give him advice that something can be done or can't be done, that he would respect that. That's an important relationship, too. But ultimately, you are bound by the laws of the country.
Some of that, I assume, could come into play when you're dealing with a politically sensitive case, and with a case that is politically sensitive because it relates to a member of the administration or to the interplay between the executive branch and the legislative branch, for example. In some of those instances, there can be calls for a special prosecutor. On the one hand, this is a way of taking the Attorney General out of the equation so that it can be handled in a manner that reflects a degree of separation between the administration and the case. On the other hand, there are constitutional questions that are sometimes raised, and sometimes people argue that this places too much of a presumption that the special prosecutor will seek an indictment in order to justify the expense and the time put into appointing a special prosecutor. For reasons that relate to the complexity of these considerations, there are, of course, guidelines in place that can help guide the determination to be made by the Attorney General as to when, whether, how to put in place a special prosecutor. But even within these guidelines, there's a lot of flexibility, a lot of discretion in the hands of the Attorney General in deciding how to do that. Do you have anything that you would follow? What can you tell us about what considerations you would consider in deciding whether or not to appoint a special prosecutor?
Well, it is not a little matter. It is a matter that's created controversy over the years. I don't think it's appropriate for the Attorney General just to willy-nilly create special prosecutors. History has not shown that has always been a smart thing to do. But there are times when objectivity is required and the absolute appearance of objectivity is required, and perhaps a special prosecutor is appropriate. The Attorney General Lynch, for example, did not appoint a special prosecutor on the Clinton matter. And I did criticize that. I was a politician. We had a campaign on. I didn't research the law in depth. It was just a reaction as a senator of a concern. But should be great care should be taken in deciding how to make the appointment or if an appointment of a special prosecutor is required. The Department of Justice, you're not required to be a judge, to be a prosecutor. One judge said there's nothing wrong with a prosecutor who likes his work and doesn't think laws should be violated. Is that a bias? I don't think so. I think that's a strength. So I just would say that's kind of the way, the best I could give you at this point, Senator Lee.
Thank you. No, that's helpful. Another challenging issue that relates to this duty of independence that attorneys general have relates to the Office of Legal Counsel. It's of course the job of the Office of Legal Counsel, or OLC as it's sometimes known, to issue opinions within the executive branch on a wide array of subjects. Some are subjects that a lot of people would find interesting. Others are subjects that only a lawyer could love, and sometimes only a lawyer specializing in something esoteric or specific. There's one recent OLC opinion entitled "Competitive Bidding Requirements under the Federal Federal Highway Aid Program." There aren't perhaps that many people who would find that interesting, but there are a lot of others that would capture immediately the public's interest. What's significant about all of these, though, no matter how broad or narrow the topic, no matter how politically sexy or dull the topic might be, they, in many instances, almost conclusively resolve a legal question within the executive branch of government. And in many instances, they're doing so on the basis of constitutional determinations that may or may not ever be litigated, such that the broaching of a constitutional topic might be opened, studied, and resolved entirely within the executive branch, largely as a result of how the lawyers within the Office of Legal Counsel decide to do their jobs. What can you tell me about what you would do, if confirmed, to ensure that the Office of Legal Counsel maintains a degree of professionalism and independence requisite for this task?
Senator Lee, that office is important. It does adjudicate or actually opine on important issues related to conflicts or disputes within the great executive branch of the American government. Like you said, what kind of competition is required before you get a highway grant? There may be a disagreement about that, and OLC is asked to review it and state one position, that the government of the United States is one. It's not a multiple government. These departments are not independent agencies. And so that office is so exceedingly important, as you indicate, because many times those opinions hold, and they set policy and they affect things. Sometimes it also has the power, and I'm sure you would be sensitive to expand or constrict the bureaucracies in their ability to execute under statutes. In other words, is this within their power or is it not within their power? So there's some of the things like that that can impact the American people over time in a significant way.
Thank you.
Klobuchar.
Thank you very much, Mr. Chairman. Good to see you, Senator Sessions. You and I have worked together on a number of bills, including leading the International Adoption Simplification Act, which I believe made a big difference to a lot of families in keeping their siblings together when they were adopted. Senator Cornyn and I led the sex trafficking bill that passed last year, and you had some important provisions in that. And then we've worked together on law enforcement issues, and I appreciate your respect and the support that you have from that community. And I also thank you for your work on drug courts, something we both share as former prosecutors and believe in the purpose of those courts. But I wanted to lead first with another part of the Justice Department's jobs, and that's protecting civil rights and the right to vote. My state has the highest voter turnout in the last election of any state. We're pretty proud of that. And as county attorney for 8 years for Minnesota's biggest county, I played a major role in making sure that the election laws were enforced and that people who were able to vote could vote and that people who shouldn't vote didn't vote. Since the Voting Rights Act became law more than 50 years ago, we've made progress, but I've been very concerned about some of the movements by states to restrict access to voting in recent years. We haven't been able to pass the Bipartisan Voting Rights Advancement Act forward last Congress, and I just think it's an area that's going to be ripe for a lot of work going forward. You and I talked about how at one point you previously called the Voting Rights Act an intrusive piece of legislation, and I wondered if you could explain that as well as talk about how you will actively enforce the remaining pieces of the act. That would be Section 2, which prohibits voting practices or procedures that discriminate on the basis of race, and the Section 3 bail-in provision through which most states can be subject to preclearance. And you don't have to go into great detail on those two sections. You could do it later. But if you could just explain your views of the Voting Rights Act moving forward and what would happen in terms of enforcement if you were Attorney General.
The Voting Rights Act, passed in 1965, was one of the most important acts to deal with racial difficulties that we face, and it changed the whole course of history, particularly in the South. There was a clear finding that there was discriminatory activities in the South, that a number of states were systematically denying individuals the right to vote. And you go back into the history, you can see it plainly. Actions and rules and procedures were adopted in a number of states with the specific purpose of blocking African Americans from voting. And it was just wrong, and the Voting Rights Act confronted that. And it, in effect, targeted certain states and required even the most minor changes in voting procedure, like moving a precinct across.
So how would you approach this going forward? For instance, the Fifth Circuit's decision that the Texas voter ID law discriminates against minority voters, that was written by a Bush appointee. Do you agree with that decision? How would you handle this moving forward?
Well, I have not studied that. There's going to be a debate about it. Courts are ruling on it now, and that is a voter ID, and whether or not that is a improper restriction on voting that adversely impacts disproportionately minority citizens. So that's a matter that's got to be decided. On the surface of it, it doesn't appear to me to be that. I have publicly said I think voter ID laws properly drafted are okay, but as Attorney General, it'll be my duty to study the facts in more depth, to analyze the law, but fundamentally that can be decided by Congress and the courts as they interpret the existing law. I did vote to extend the Voting Rights Act several years ago. I thought it included Section 5, but later Section 5 was eliminated by the Supreme Court on the basis that progress had been made. And on an intrusive question, let me answer that. It is intrusive. The Supreme Court on more than one occasion has described it legally as an intrusive act, because it only focused on a certain number of states, and normally when Congress passes a law, it applies to the whole country. So it's a very unusual thing for a law to be passed that targets only a few states. But they had a factual basis. They were able to show that it was justified in this fashion. So that's the foundation for it, and that's why I supported its renewal.
Mm-hmm. And I think you'll understand as you look at this issue that there are many voters, people who are trying to vote, that view some of these rules that are put in place as intrusive for them because it makes it harder for them to vote. And I think that is the balance that you're going to need to strike. And I hope, coming from a state that has such high voter turnout, that has same-day registration, very good turnout in Iowa as well, right below us, states that have put in place some really expansive voter laws, and it doesn't mean Democrats always get elected. We've had Republican governors in Minnesota, we have a Republican governor in Iowa, and I just point out that I think the more we can do to encourage people to vote, the better democracy we have. And I want to turn to another quick question on a democratic issue, as in a democracy issue that was raised by Senator Graham and as Senator Whitehouse. I just returned with Senators McCain and Graham from a trip to Ukraine, Baltics, Georgia, and learned there about how these intrusive cyber attacks are not just unique to our country, not just unique to one party, not just unique to one election, and they've seen that movie before in those countries. And do you have any reason to doubt the accuracy of the conclusion reached by our 17 intelligence agencies that, in fact, Russia used cyber attacks to attempt to influence this last election? I'm not asking if you believe that influenced it, just if you believe the report of our intelligence agencies.
I have no reason to doubt that and have no evidence that would indicate otherwise.
Thank you. Violence Against Women Act, Senator Leahy asked some of those questions, really important to me. You and I discussed it. I just have one question there. If confirmed, will you continue to support the life-saving work being done by the Office on Violence Against Women?
Yes.
Okay, thank you. Immigration, you and I have some different views on this, and I often focus on the economic benefits of immigration, the fact that we have 70 of our Fortune 500 companies headed by immigrants. At one point, 200 of our Fortune 500 companies were either formed by immigrants or kids of immigrants. Roughly 25% of all U.S. Nobel laureates were foreign-born. And just to understand, in a state like mine where we have entry-level workers in dairies are immigrants, major doctors at the Mayo Clinic, police officers who are Somali, if you see that economic benefit of immigrants in our society.
Well, immigration has been a high priority for the United States. We've been the leading country in the world in accepting immigration. I don't think American people want to end immigration. I do think that if you bring in a larger flow of labor than we have jobs for, it does impact adversely the wage prospects and the job prospects of American citizens. I think as a nation we should evaluate immigration on whether or not it serves and advances the national interest, not the corporate interest. It has to be the people's interest first, and I do think too often Congress has been complacent in supporting legislation that might make businesses happy, but it also may have had the impact of pulling wages down. Dr. Borjas at Harvard has written about that. I think he's the world's perhaps most effective and knowledgeable scholar, and he says that does happen. Wages can be diminished, and one of the big cultural problems we have today is middle class and lower class Americans have not, lower class economically, are not having the wage increases that we'd like to see them have. In fact, since 2000, wages are still down from what they were in 2000.
I just see that we can do a mix of making sure that we have jobs for people here and then understanding that we're a country of immigrants.
On that subject, you're familiar with Canada.
Okay.
And we are people of America. You have actively gone against prohibiting the legislation that would keep my family together. You are anti-immigrant. You are supported by hate groups that have been trying to push racist legislation. You are not a good attorney general.
Mr. Chairman, if I could just have another 30 seconds here. I had one last question.
Maybe 45 seconds. Mr. Chair, I would just say that you're close to the Canadian system. I think may be some of those policies ought to be considered by the United States.
My last question, Mr. Chairman, is on the reporters issue. Free press, I believe, is essential to our democracy. And I've always fought to ensure that those rights aren't compromised. My dad was a reporter, a newspaper reporter for years, and I'm especially sensitive to the role of the press as a watchdog. You've raised concerns in the past about protecting journalists from revealing their sources. You did not support the Free Flow of Information Act. In 2015, the Attorney General revised the Justice Department rules for when federal prosecutors can subpoena journalists or their records, and he also committed to releasing an annual report on any subpoenas issues or charges made against journalists, and committed not to put reporters in jail for doing their job. If confirmed, will you commit to following the standards already in place at the Justice Department, and will you make that commitment not to put reporters in jail for doing their jobs?
Senator Klobuchar, I'm not sure. I have not studied that those regulations. I would note that when I was United States Attorney, we knew, everybody knew, that you could not subpoena a witness or push them to be interviewed if they were a member of the media without approval at high levels of the Department of Justice. That was in the 1980s. And so I do believe the Department of Justice does have sensitivity to this issue. There have been a few examples of where the press and the Department of Justice haven't agreed on these issues, but for the most part, there is a broadly recognized and proper deference to the news media. But you could have a situation in which a media is really not the unbiased media we see today, and they could be a mechanism through which unlawful intelligence is obtained. There are other dangers that could happen with regard to the federal government that normally doesn't happen to the media covering murder cases in the states.
All right, well, thank you, and I'll follow up with that in a written question when you have a chance to look at
If you would, I would.
Thank you. Thank you.
I call for the first time on a new member of the committee, Senator Sass from Nebraska.
Mr. Chairman, thank you, and thank you for having me. Before I get started, I'd like to enter into the record a letter of support from 25 current state attorneys general, including Doug Peterson, the Attorney General from my state of Nebraska. The letter reads in part, "No one is more qualified to fill this role than Senator Sessions." This is obviously important testimony from the top law enforcement officers of 25 states. I ask unanimous consent, Mr. Chairman, to include this in the record.
Without objection, it will be included. Proceed, Senator Sass.
Thank you. Senator Sessions, when you were introducing your grandkids, and I'm amazed that they stayed around as long as they did, mine would have been more disruptive earlier, I was thinking about all the time I spend in schools, and we have a crisis in this country of civic ignorance. Our kids don't know basic civics, and we have a crisis of public trust in this country in that many Americans presume that people in this city are overwhelmingly motivated by partisan perspectives rather than the public good. Tragically, our current president, multiple times over the last 3 or 4 years, has exacerbated this political polarization by saying that he didn't have legal authority to do things and then subsequently doing exactly those things. Quite apart from people's policy perspectives on these matters, this is a crisis when kids don't understand the distinction between the legislative and the executive branches, and when American voters don't think that people who serve in these offices take their oaths seriously. So it's not always as simple as Schoolhouse Rock jingles on Saturday morning, but could you at least start by telling us what you think the place for executive orders and executive actions are?
That's a good question and a good premise that we should think about. People are taught Schoolhouse Rock is not a bad basic lesson in how the government's supposed to work. Legislators pass laws. The Congress, the President executes laws, as does the entire administration, as passed by Congress or follows the Constitution. And the judicial branch decides disputes as a neutral umpire, an unbiased participant of any of the sides of the controversy, and does it objectively. So I think every day that we get away from that is really dangerous. And it is true that if a president says, I do not have this authority, and other people say the president does not have certain authority, and then it is done by the president, it confuses people. And it's, I think, colleagues, we too little appreciate something that's corrosive happening out in our country. There is a feeling that judges just vote when they get a big case before them on what their political agenda is, and not what the Constitution actually requires. That judges can redefine the meaning of words to advance an agenda that they have that may not be the agenda of the American people. And that inevitably is corrosive to respect for law.
Thank you. But take it one step further, because there are going to be many cases, there'll be many instances where the administration in which you are likely going to end up serving will want to do things, and they'll want to know what the limits of their executive discretion is. Pieces of legislation that have been passed around here in recent years sometimes are, well over 1,000 pages with all sorts of clauses. The secretary shall ... fill in the law. So this Congress has regularly underreached and invited executive overreach. This Congress has regularly failed to finish writing laws and then invited the executive branch to do it. What are some of the markers that you would use to help understand the limits where the executive branch cannot go?
We really need to reestablish that. Professor Turley, Jonathan Turley, has written about this. It's just powerful. He's certainly an objective voice in American jurisprudence, and he says that Congress has just fallen down on its job. Now, of course, there are two ways. One of them is that it writes laws that are too broad. And I would urge all of you to be sure that when we pass a law, or you pass a law, if I'm confirmed, that that law is clear and sets limits. When it doesn't set limits, then you can have the secretary of this agency or that agency claiming they have certain authorities, and you end up with a very muddled litigation maybe resulting from it. So reestablishing the proper separation of powers and fidelity to law and to limits is an important issue, and I think that's what you're suggesting.
Could you tell me under what circumstances, if any, you think the Department of Justice can fail to enforce a law?
Well, it can fail to enforce it by setting prosecutorial policies with regard to declining to prosecute whole chunks of cases and, in fact, eliminate a statute. If a new tax is passed and the Department of Justice says it can't be collected, then the law is not followed. You also have the circumstances in which can redefine the statute or alter, if we're talking about improper actions, it could expand the meaning of the words of the statute far beyond what Congress ever intended. And that's an abuse, too.
Not to interrupt you too soon, but the improper, but also what is proper? Because this administration has made the case regularly that they need to exercise prosecutorial discretion because of limited resources, and obviously there aren't infinite resources in the world. So what are some proper instances, in your view, when an administration might not enforce a law?
Well, critics of the immigration enforcement, the DAPA and the DACA laws, said that the prosecutorial discretion argument went too far. It basically just eliminated the laws from the books. Secondly, with regard to that, the president's the order came from Homeland Security, not from the Department of Justice, but Homeland Security's order not only said we're not going to force the law with regard to certain large classifications of people, but those people who'd not been given legal status under the laws of the United States were given photo IDs, work authorization, and Social Security numbers, and the right to participate in these government programs that would appear to be contrary to existing law. So that would, to me, suggest an overreach.
And in parallel, before the courts, what instances would it be legitimate, if any, for the Solicitor General to not defend a law in court?
That's a very good question, and then sometimes it becomes a real matter. In general, the Solicitor General, as part of the Department of Justice and the executive branch, states the position of the Department of Justice. And it has a duty, the Department of Justice does, to defend the laws passed by this body, by Congress. And they should be defended vigorously, whether or not the Solicitor General agrees with them or not, unless it can't be reasonably defended. And so sometimes you reach a disagreement about whether it's reasonably defensible or not. But that's the fundamental question. And the Department of Justice should defend laws that Congress passed unless they're unable to do so in a reasonable way.
What is the place of independent agencies in a unified executive branch, and do you envision that you will be making any recommendations to the President to rein in independent agencies in an effort to preserve the constitutional distinction between the powers of the Congress and the administrative responsibilities of an executive branch?
Senator, it's a good question, kind of a historic question at this point in time, because it does appear to me that agencies oftentimes see themselves as independent fiefdoms. And sometimes you even hear the president complain about things clearly under his control. I remember President Clinton complaining about the death penalty processes of the Department of Federal Government when he appointed the Attorney General, who had just appointed a committee to make sure the death penalty was properly carried out. So, I mean, like, whose responsibility is this? You're in charge. You can remove the Attorney General if you're not happy. So those kind of things do continue out there that we need to be careful about. And I thank you for raising it.
I have less than a minute left, so last question, but going back to something that Senator Lee was asking about, could you just give a top-line summary of what you view the responsibilities of the OLC to be and what the relationship would be between the OLC, the Office of the Attorney General, and the White House?
Well, OLC has statutory duties to make opinions. The OLC team reports to the Attorney General, who could reverse, I suppose, or remove the OLC head, the Deputy Attorney General, if he thought that department was not following the law. But essentially, they are given the power. As Attorney General, I had an opinions section in Alabama, and they rendered opinions on a whole host of matters when called upon from school boards and highway departments and that sort of thing. So this OLC does represent a key position in the Department of Justice. They must have extraordinary legal skill. They have to be terrific lawyers. They have to understand the constitutional order of which we are a part, and they should render objective decisions day after day, week after week. Ultimately, the responsibility of the President and the Attorney General to ensure that we have that kind of quality at OLC.
Thank you.
Senator Rankin.
Thank you, Mr. Chairman. Senator, congratulations on your nomination.
Thank you.
In 2009, when you became the ranking Republican on this committee, you were interviewed about how you would approach the committee's work and nominations specifically. You said that Democrats should expect you to be fair because you had been through this process yourself back in 1986, and you felt that back then the committee had distorted your record. You said that moving forward, quote, "We're not going to misrepresent any nominee's record, and we're not going to lie about it," unquote. And we certainly don't want to do that to our colleague. But I also think it's fair to expect that sitting before us today that you're not going to misrepresent your own record. That's fair to say, right?
That is fair.
Good. Now, in that same interview, you said, quote, "I filed 20 or 30 civil rights cases to desegregate schools and political organizations and county commissions when I was the United States Attorney." So 20 or 30 desegregation cases. Did I misread that quote?
I believe that's what I've been quoted as saying, and I suspect I said that.
Okay, now that was 2009, but in November of this year, your office said, quote, "When Senator Sessions was U.S. Attorney, he filed a number of desegregation lawsuits in Alabama, not 20 or 30 this time, but a number." So tell me, did you file 20 or 30 desegregation cases, or is it some other number?
Well, thank you, Senator Frank, and it is important for us to be accurate. The records don't show that there were 20 or 30 actually filed cases. Some of the cases involve multiple defendants and multiple parties, like a school board and a county commission being sued for racial discrimination, things of that nature. But the number would be less than that, as we've looked at. So
what do you think would have caused you to say
I don't know.
that you filed 20 or 30 desegregation?
Well, we had cases going throughout my district, and some of them were started before I came and continued after I left. Some of them were brought and then settled promptly. And so it was extraordinarily difficult, actually, and I was surprised to get a record by checking the docket sheets to find out exactly how many cases were involved. I heard one lawyer from the Department of Justice agreed with
let
that
me move on.
large number,
Fine.
but the record doesn't justify it.
The questionnaire you submitted for today asks you to list and describe the, quote, 10 most significant litigated matters you personally handled. Personally handled. And among the cases that you listed that you personally handled are 3 voting rights cases and a desegregation case. Last week, I should note, 3 attorneys who worked at DOJ and who actually brought 3 of the 4 cases wrote an op-ed piece in which they say, quote, "We can state categorically that Sessions had no substantive involvement in any of them." Now, you originally said that you personally handled 3 of these cases, but these lawyers say that you had no substantive involvement. Chairman Grassley, I would ask that op-ed from last Tuesday's Washington Post be entered into the record.
Without objection, it will be entered.
Are they distorting your record here?
Yes. In fact, one of the writers there, Mr. Hebert, spent a good bit of time in my office. He said I supported him in all the cases he brought, that I was more supportive than almost any other U.S. attorney, and that I provided office space. I signed the complaints that he brought. And as you know, may know, Senator Franken, when a lawyer signs a complaint, he's required to affirm that he believes in that complaint and supports that complaint and supports that legal action, which I did. We sued.
So that's your personal involvement? Was that your name was on it?
Well, look, you can dispute the impact or the import of the questionnaire. Another attorney, Paul Hancock, who brought cases in our district, said, well, the Attorney General claims credit for the cases in the Department of Justice. He saw nothing wrong with my claiming that this was a case that I had handled.
Okay, 2 of the...
So you can disagree with that, but those cases
I want to get through this,
have
and
my
I don't want you
signature
to...
on the...
I want to get through
on
this.
the docket sheet, my name is listed number 1 on the as the attorney for the case.
I'm not a lawyer. I'm one of the few members of this committee who didn't go to law school, and usually I get by just fine. But it seems to me that a lawyer, if a lawyer has just his name added to a document here or a filing there, that lawyer would be misrepresenting his record if he said he was personally handled these cases. 2 of the lawyers who wrote the op-ed have also submitted testimony for today's hearing. Mr. Jerry Hebert and Mr. Joe Rich. Mr. Hebert says, quote, he, quote, litigated personally 2 of the 4 cases you listed. He said, I can state with absolute certainty that Mr. Sessions did not participate personally in either. Mr. Rich worked on one of the 4 cases you listed. He said, quote, I never met him at that time nor any other time, and he had no input to the case. These represent 3 of the 4 cases that you claimed that were among the top 10 cases that you personally handled. Now, in your 1986 questionnaire, you used phrases like, quote, I prepared and tried the case as sole counsel, and, quote, I was the lead prosecutor on this case, assisted by so-and-so. Why didn't you use the same level of detail in your 2016 questionnaire?
And looking at this questionnaire, we decided that was an appropriate response since it was a major historic cases in my office. Let me just reply, Senator Franken, in this fashion. Mr. Hebert, in 1986, when he testified at my hearing, said, quote, "We have had difficulty with several U.S. attorneys in cases we have wanted to bring. We have not experienced that difficulty in the cases I have handled with Mr. Sessions. In fact, quite the contrary," close quote. He goes on to say, "I've had occasion numerous times to ask for his assistance and guidance. I have been able to go to him, and he has had an open door policy. And I have taken advantage of that and found him cooperative." And that is an accurate statement. I don't know Mr. Rich. Perhaps he handled a case that I never worked with. He goes on to say, quote,
one of the cases
no,
that
I
you
want to,
listed-
you've raised this question,
One of
Senator
the
Franklin.
cases that you listed was a case that Mr. Rich handled. So if you don't know him, it's hard for me to believe that you personally handled it.
Well, when I found that these cases, I had been supportive of
filed.
them. Sure, I was. Mr. Hebert says, quote, "And yet I have needed Mr. Sessions' help in those cases, and he has provided that help every step of the way. In fact, I would say that my experience with Mr. Sessions has led me to believe that I have received more cooperation from him, more active involvement from him, because I have called upon him," close quote. Quote, "I have worked side by side with him on some cases in the sense that I have had to go to him for some advice," close quote.
In some cases. We're not necessarily the ones you listed.
Well, look,
Okay,
this was
look,
30 years ago, and my memory was of this nature, and my memory was my support for those cases.
Your memory. Okay. Look, I'm one of the few members of this committee who's not a lawyer. The chairman, the ranking aren't. But when I hear I filed a case, you know, I don't know some of the parlance. It might have a special meaning in legal parlance. But to me, as a layman, it sounds to me like filed means I led the case or I supervised the case. It doesn't mean that my name was on it. And it seems to me, look, I'll close, Mr. Chairman. Setting aside any political or ideological differences that you or I may have, DOJ is facing real challenges, whether it's protecting civil rights or defending national security, and our country needs an attorney general who doesn't misrepresent or inflate their level of involvement on any given issue.
I hear
So I consider this serious stuff, as I know that you would if you were in my position.
Well, you are correct, Senator Franklin. We need to be accurate in what we say. When this issue was raised, I did do a supplemental that said I provided assistance and guidance to Civil Rights Division attorneys, had an open door policy with them, and cooperated with them on these cases, close quote. I signed them, I supported cases, and attempted to be as effective as I could be in helping them be successful in these historic cases. I did feel that they were the kind of cases that were national in scope and deserved to be listed on the form. If I'm in error, I apologize to you. I don't think I was.
Well, you couldn't find 20 or 30 desegregation cases that you stated you had participated in, and it don't sound like you personally handled cases that you said you personally.
Well, I was on a
Thank you.
radio interview without any records, and that was my memory at the time.
I think you answered the question. Senator Flake, now it's 12:59, so at 2:09, we will adjourn for lunch. I'll be back here then at 2:39, and whoever's present will start then, but I hope everybody can be back here at least by 2:45. Or, well, whatever, I got the, you know what I mean. Go ahead, Senator.
Well, thank you. Wait, are you saying we're adjourned or I'm going?
Oh, you go ahead.
Okay, all right. Great. It's always nice being the last one standing between lunch.
Let's
with everyone.
let's have order for Senator Flake.
Hey, I just want to say at the outset how much I've enjoyed working with you and being your colleague. I appreciate having you as a friend It's no secret we've had difference of opinion on immigration legislation that we put forward. You've had different ideas, but I have no doubt that as Attorney General, you'll faithfully execute the office.
I'm sorry.
And I appreciate the answers that you've given today. Let me ask unanimous consent to submit a column written by our own Attorney General in Arizona, Mark Brnovich, for the Hill newspaper this week, supporting
without objection, it'll be included.
He's supporting your nomination. Let me talk to you about an aspect of immigration that's important in Arizona. As you know, we have a large border with Mexico. We have a program called Operation Streamline that has, over the years, been tremendously effective in cutting down recidivism in terms of border crossers. What it is, basically, it's intended to reduce border crossing by expeditiously prosecuting those who enter the country illegally under a no-tolerance or zero-tolerance policy. It's credited with being instrumental in achieving better border security, specifically in the Yuma sector along the western side of Arizona's border with Mexico. Nevertheless, in recent years, the U.S. Attorney's Office for the District of Arizona adopted a policy that ended prosecutions for those who cross without a criminal history other than simply crossing the border. I've asked Attorney General Holder and Attorney General Lynch, as well as Secretary Johnson at Homeland Security, on what is being done here, and I haven't gotten a straight answer, no matter how many times I ask the question. So I'm looking forward to a little more candor here. As Attorney General, if you're confirmed, what steps will you take to restore Operation Streamline to a zero-tolerance approach that's been so successful in Arizona, in a portion of Arizona's border?
Thank you. Senator Flake, I have enjoyed working with you, and I know the integrity with which you bring your views on the immigration system. Like you, I believe that Streamline was very effective, and I was really surprised that it's been undermined and significantly. The reports I got initially some years ago, maybe a decade or more ago, was it was dramatically effective. And so I would absolutely review that, and my inclination would be, but at least at this stage, to think it should be restored and even refined and made sure it's lawful and effective. But I think it has great positive potential to improve legality at the border.
All right. Well, thank you. It's been effective in Yuma, and I can tell you there's concern there among the Sheriff's Office, Sheriffs Wilmot and others, concern that we're seeing an increase in border crossings simply because the cartels understand very well where there's a zero-tolerance policy and where there is not. Word spreads. And we could quickly get to a situation where we have a problem in the Yuma sector like we do in the Tucson sector. Is there any reason why we haven't expanded this program to the Tucson sector if it's been successful elsewhere?
I do not know what reason that might be. It seems to me that we should examine the successes and see if they can't be replicated throughout the border.
All right. Well, thank you. I look forward to working with you on that.
I appreciate that opportunity to work with you on that because I've long felt it's the right direction for us to go.
All right. Thank you. When we have a successful program, it's difficult to see it scrapped and to see the progress that's been made in certain parts of the border done away with. Let me get to another subject here, victims' rights. This is an area of the law that you've shown particularly interest in over your time as a senator. I have with me letters of support for your nomination from various victims groups and advocates, the Victims of Crime and Leniency, Verna Watt, Victims of and Friends United, op-ed by Professors Paul Cassell and Steve Twist, all in support of your nomination. I'd ask that these documents be placed as part of the record. As Attorney General, what steps will you take to ensure that victims' rights are protected?
We cannot forget victims' rights. We have a victim witness legislation that creates within each United States Attorney's Office a victim witness coordinator, and the job of that person is to make sure the concerns of the victims are heard. If they have to come to court, to help them get there, to make sure that they don't feel threatened and are protected. That's a direct responsibility of the Department of Justice and the criminal justice system as directed by Congress. So I really think that's one step. And that's the fundamental mechanism. I think Senator Kyle was a strong advocate for that, and it helped really improve the treatment of victims in federal criminal cases. There's just no doubt about it.
Well, thank you. I was going to note the presence of former Senator Kyle, my predecessor in this office, who did so much work in this area, partnering with you. So thank you for that answer.
I'm honored that he's giving of his time to assist me in this effort. Honored very greatly.
Thank you. Let's talk about Prison Rape Elimination Act. It was mentioned previously, I think, by Senator Collins. As Attorney General, you not only led the Department of Prosecutors and law enforcement officers, but also the Bureau. You will lead not only the Department of Prosecutors and law enforcement officials, but also the Bureau of Prisons. You'll be responsible for 190,000 federal inmates currently in custody. This is an often overlooked part of the Attorney General's role, but it's an important part of the position that you're being nominated for. I believe one of the highlights in your record in the Senate is your leadership in passing the Prison Rape Elimination Act of 2003, or PREA, which passed both chambers without objection and was signed into law by George W. Bush. This was a bipartisan bill. You worked across the aisle with the late Senator Kennedy, as well as with Republican Representative Frank Wolf, Democrat Representative Bobby Scott in the House. And I have letters of support from anti-prison rape activists that I'd also like to put as part of the record. Without objection, if I could. Thank you. Thank you. With the law approaching its 15th anniversary, 11 states have certified that they're in compliance with the national standards. Another 41 states and territories have provided assurances that they're working toward compliance. Only 4 states and territories have chosen not to participate. Is PREA meeting the expectations you had for it when you introduced the bill in 2003?
I don't think there's any doubt that it's improved the situation. As to whether it's reached its full potential, I don't think I'm able to tell you with certainty, but I certainly think it's made a positive difference. You know, it was a special time for me. Senator Kennedy was a strong critic of me in 1986. And he said, you know, as we were working on this, he said, I've wanted to work with you on legislation like this. And I think it was sort of a reconciliation moment. We also worked on another major piece of legislation for several years. It would have been rather historic, but it was private savings accounts for lower wage workers in America that I guess the financial crisis of 07 or somewhere, some things happened that ended that prospect. But I believe that it's important for American people to know that when an individual is sentenced to prison, they're not subjected to cruel and inhuman punishment under the Constitution at a minimum. And the idea that was so widely spread that there's routine sexual abuse and assaults in prisons and other kind of unacceptable activities was widespread in our media and widespread among the American people. One of our goals was to establish just how big it was, to require reporting, to and create circumstances that help ensure that a person who should be prosecuted for violence in the prison actually do get prosecuted, was a real step forward. We do not need to subject prisoners to any more punishment than the law requires.
Thank you. In the just remaining seconds I have, let me just say there's another area that we have worked on and hopefully we can continue to work on, and that's the area of duplicative DOJ grants. As you know, Department awarded approximately $17 billion in grants over the years. OIG reports, GAO reports have all shown that there's duplication and waste, sometimes fraud and abuse. We continue to commit to work to root out this kind of duplicative action there.
Well, I know you've had a history of being a staunch defender of the Treasury against those who would abuse it. and I believe the same way. It's the taxpayers' money. Every dollar that's extracted from an American citizen that goes into the government needs to get to productive, valuable activities. And any of it that's delivered for political and insufficient reasons is a cause of great concern. I will make it a priority of mine to make sure that the dollars we have are actually getting to the purposes they're supposed to go for. It's one thing to say, I did a great thing, I got more money for this good purpose, but did it really efficiently and effectively go there? Did it really make a positive difference? So I think the Department of Justice can utilize those grant programs to help valuable activities, and it needs to guard against improper activities.
Thank you, Senator Sessions. Thank you, Mr.
We'll break for about 30 minutes. We'll reconvene at 1:40. And Senator Coons would be next up, and he's indicated he'll be here on time. So recess for now.
I only have
Okay.
Are you going to put the spider on?
What I think we're going to do on the ground is tied up a bit, whatever. Yep. Just trying to keep it easy. Yep. Of course, we're still in the air.
It would be much appreciated.
We leave our stuff here.
He also has ties to the David Horowitz Center, who the SPLC said is the godfather of the U.S. Islamophobia network.
Thanks to Iraq, tell how much we appreciate your being there. I was telling you, my deputy solicitor, Brett Powell, was in that transition to the DOJ. We run into him, he's just a super young guy. Good to see you, gentlemen.
Chairman, how do you see the session? The audio.
Okay, yeah. Oh, you got. Oh, listen. Mr. Chairman, well, I have indeed, Mr. Chairman. You're doing a great job, though, in the hearing. I like the way you handled it. Very good to see you.
Is this your turn? I think it is, but I want to make sure. London fine?
Yeah.
Nice to meet you.
So Ursula should be waiting for us.
Very
where
good.
She dropped you off.
Very good.
She'll be right there. Yeah, I told her one, so she said she might be a little bit after one, which is perfect.
So far.
Which is actually where it was like, like this, like a whole free chair. This man was like taken away. You don't want to bet. I know. Yeah, we have a photo on those Facebook page.
Oh, no, I know. I just get
The Muslim. Giggling. It was allowed.
Everybody left over.
Test 1, 2, 3, 3, 2, 1, test complete.
And then when he laughs. You don't laugh when they laugh. You can't laugh if they're not laughing.
I don't know if just as long as she did. I don't know. Like, when she gets to, there's
Because it's not. Just because we're snowing. We should have heard.
I just mean like my cards
No way.
talking about
Yeah, right? They are. In DC, they are. They are going to come to shows there. He's made it clear that he is going to enforce everything on the law, even the laws that are not being enforced. That's the question. He said they have to enforce the laws. Way more pressure on this side. I'm going to just take this platform away and we'll put the spider clock where you are. Okay. What's acceptable for this week? So yeah, just on the pulpit. I'm going to just fold this up and put it right there for now. That's a good idea. So I did a ride-along officer in California. It was fascinating. Okay. This is really dirt heavy. I'm going to put it, see that cone there? Between the cone and the bench? With the perfect facing down. Okay, I'm going to tilt this up now so it's standing. All right. So it's coming towards you. Actually, that makes a lot more sense. That makes a lot more sense. Unless you want to pull it further.
Yep, I'm good.
Did you bring your billy club today? Don't you wish you had it?
Dude, I was just having a fun time.
I was like, okay, I like those guys. Well, I'm like, what is this guy could undo everything that they just got done. And I was like, I haven't heard one of my friends who are like, about this going like, are you still working on this? Yep.
You guys plan on leaving your stuff up tonight?
I don't know. If you're coming back here tomorrow, then yeah, probably.
That would make the most sense.
Would, but the room's too loud.
But if I put it here, it's less visible. So it might be.
I know we are. We always.
You guys are pretty much sure he's coming back tomorrow?
It's scheduled. The only thing that would keep it is if Grassley decides.
No,
It's not scheduled for it.
Do you want the platform, in which case you move it over a little bit?
Oh yeah, he's gonna need the platform unless he's a lot taller than I
on there.
Because I've seen like some people actually like in this area we back. So is that so if I go use the bathroom during the session, I'll let everybody back in? That's all I need to know. Thank you.
It's just going to lunch break. That's okay. We had a lot of people that said that and haven't been able to get in. So
Thank you.
Get back in.
Okay, yeah, we just don't want to lose our spots or like not be able to re-evaluate because we've been here since 4. Thank you.
Not now. It did this morning. A lot of people went to SD 226 to the overflow, and they just wanted to see what. And some people downstairs that wanted to protest and didn't get in the first wave. They were the ones that went to Senator Sessions' office and protested. So we arrested 7 of them. That's a little more intrusive, actually. And now you're interrupting his workspace. They had our technical staff is being deceptive about that. It's good enough. We are doing it to get over the meeting. Right. Yeah, but there circa Washington, D.C. today. So it's, they got enough media coverage. Right, right. They'll do that. Right, right.
Then tomorrow, we'll come back, everybody gets a second vote.
Tomorrow, I think, is the people they're speaking for. The two senators are voting on his behalf, but then it's tomorrow. There's more people coming in, character base type issues. It could be. I think you could. With this election and everything is surrounded, nothing surprising. It's just neat to be up here. I didn't think I'd ever see an impeachment. I was here for Clinton's, you know. I mean, you got whatever you see. Yeah. Live in state. I was here for Reagan and Ford and Rosa Parks and also and then planes and flying the buildings. I was here for that, so it's just, you know, this job is really not the historical part of it. That's the reason So you were at the convention? Yeah. I was at the, I was downtown on some walkthroughs. I was at the command center out there. Oh, yeah.
I said the one with the officers, I'm like, I did something I never done before. I've been delegate to it. And I was a chairman. I walked from, I guess it was, reception.
Yeah.
Convention center. I was and I had my
right.
And there is 2,000 of me.
Right. Right. Well, I tell you, yes. So there have been people waiting downstairs. So they waited patiently, and that's why the young lady was telling me about it. I got the bathroom.
Yeah, we'll walk on it.
You sort of step on it. Is that what it was? Yeah. I had a seat.
Well, the main section, which is now what it has.
I tell you,
Is that what it has? It has a seat. There's another company in the truck. That's what I'm thinking of that.
Now in D.C., that's improvised. Everybody responded that way, got it all gone, probably shots exchanged.
Yeah, they actually did. You don't
That's one of the swipe clubs. So those were actually used. We got this. It's like sharpened e-tools. Some of the ones that like one is the big.
So you've seen that oil, pipe company, that little weight. They only have a mace on that weight. They pull it out to the wedge, put the mace on it, and shake that in. Because it now wedges the whole thing out. It's awesome.
Nice hardwood. Everything is perfect.
So I guess we just
until Bob's crew gets here now, because we're not seeing a lunch. No. Not with this 1:30 already. It's 1:30 already? Yeah. I'm gonna hit the head then. Yeah, that's why I was getting so annoyed.
Right here, and then start filling in that next one. Yeah. Okay, so she'll indicate. She'll throw that in. And then got a plan? We're ready? The next one. We're not being jailed. No, you're good. I should make the global dance.
Ladies and gentlemen, if you guys have a moment, the reason we're going to have to start the process.
Trying to make sure the center session is sweat.
And you want to hit since back in C-SPAN? Just so that you're clear what's happening. What we decided on is just literally moving the license, just take it away. And so we're in the same spot but higher up.
Just to let you all know in advance, same thing at the beginning. They won't tolerate any disruptions to their hearings. There's not going to be any breaks after it starts.
We're getting back on because they're going to be starting before you people appeal. At least I'm here for them. It's already been heard.
You sure they're going to start in a minute here?
I mean, no one's here, so.
Well, I figure once we get rolling again, we'll take breaks.
Yeah.
After run downstairs and have a
Yes, they can hear this. Like the season outside. Yeah, the camera setup is four is
You got in?
Can you go to the bathroom?
No. We're gonna go now. I don't even know if you can tell. There's nobody downstairs, so you might get back. One thing you guys did, break flat or something.
What do you think?
I'll tell you what, why don't you hand me that?
240 on the shirt.
And what time is it?
Running into the bargain prize.
And this next round, each senator gets 8 minutes. Sessions is the next. You can take a question and stretch it out to 8 minutes. And not answer.
Yeah, it doesn't quite work.
Yeah, there was several.
No.
So they got a drug crap. That's fine. That's fine. Yeah, you can choose your term. And we're at DC in Minnesota, so everyone's got campus. I just switched to that would be yeah, that's what I wanted. So far,
First thing is that he's going to start enforcing federal law against we're going to he's probably going to put me in jail and everybody you can see here in jail. So we're freaking out. Like we're not ready. We're changing now to the law day one. Did you hear about the giveaway? And you can still do our stuff at days earlier.
we're going to be 4,000 seriously.
So, because we see it as giving away the adults. You're going to come together? This is like a statement. It's like autonomy. It's like here. Forcing the people. It's like they don't crack down because they don't want to look bad.
Wow. He
knows. The government is being really.
Well, he won't even be an office. I mean, it's like you can do it. It's like most people take that. They're going to come. We just asked that 4 minutes, 20 seconds. I'm not afraid of it. I mean, when they take the park up wherever you are.
It'll be an opportunity to get
I
was so happy to see that he was going to occupy his office. We started to smoke. I really wish he would reach out to us and say, I want you guys to speak about marijuana. Someone from your group. We have like a mother. She was 40. She has a 9-year-old who has epilepsy. Again, and she started with her daughter. She has CBD oil about a year and a half ago. Her daughter doesn't have seizures anymore. It's real medicine, and she was here early, and we're like, you know what, you're doing fine. She got here like 4:30 in the morning, and so she was doing president waiting. I was just saying, I have we got here maybe she's not the president, she's like a staff. It's Anthony's my bad. And she's left. She was like, I mean, I could ask her, I didn't want to speak, I just think it would be smart for the rights groups to be like, hey, I think not all marijuana legalizers believe in civil rights. Like, a lot of them are libertarian, a lot of them are like conservative or moderate, and not all of them, I think it's a minority. So some of them are queasy about like joining with any other group. They're like, but I'm like, no, this is civil rights. We should be standing for civil rights. Talk about disenfranchisement, right? Since Clinton was president, there's been 5 million felonies. We have 5 million people who lost their right to vote. Some of them got it back. And how since Clinton, Bill Clinton, it's small number, all of millions of people that are disenfranchised permanently. You know, we're talking about the number one reason why these it's drugs and cigarettes. So I see it as like the same issue. It's like, you know, I get this disenfranchised. Oh, by the way, how would that work? I heard from a woman whose husband was the target of his dead back in the 80s. He was the target of She explains that it was two factions of that group. One is pro-business and one is radical, left-wing. The left-wing faction was attacked by the pro-business faction, which is concessions with siding. The prosecution of the president for voter disenfranchisement is really like a that was meant to like reward certain blacks in Alabama and punish those who were dissenters. Yeah, and she was on the radio. Yesterday, someone must have done something. It's at the camera. She's like, she's like really old. No, she's railing, and then they brought out her son, who's like 60, and he's like, well, I'm supporting the sessions. What are they doing? Like, there seems like there's, in other words, you can switch codes. It's like a Tweety bird. These old folks, I like the fun. That's what it is, I know that. Hey, we've all been there. You can tell he just wanted to start. Started to busting out. I reckon he tried to be tough with them. They're all working. Is it both sides of the three that are more bad? So far, they have. Read it.
I call on Senator Coons, I want to explain why one of the members on my side of the aisle can't be here. Senator Tillis is unable to attend Senator Sessions' confirmation hearing today because his brother is being sworn into the Tennessee General Assembly. So he's asked me to have his statement submitted into the record, and it signals his strong support for Senator Sessions. He also, Senator Sessions, he also wants me to know that he will submit questions for you to answer in writing. Senator Coons, as we announced before, will be the first one this afternoon. Proceed. And Senator Sessions, if there's any, I won't know unless you tell me, if there's any sort of 15-minute break or anything you need, let me know.
Thank you, Mr. Chairman.
We'll do that at the end of some person asking questions. Senator Coons.
Thank you, Chairman Grassley. Welcome, Senator Sessions. Congratulations to you and Mayor and your whole family on your nomination. The position of Attorney General of the United States is one of the most important positions on which this committee will ever hold hearings. And the next Attorney General of the United States will assume leadership of the Justice Department on the heels of an election in which there were many issues thrown about in the course of the campaign, some of which have been asked about previously. Calls for a Muslim ban or patrols, issues of a potential Russian cyber attack affecting our democracy, calls for mass deportations, and chants at some rallies to lock her up for one of the candidates. And given the divisiveness of this election, I think it is critical that the next Attorney General be well suited for this position and this time. And as such, I think a successful nominee has to be able to persuade this committee that he will act fairly and impartially administer justice and advance justice for all Americans. Senator Sessions, we've served on this committee together for 6 years, and we've worked well together on a few issues, on state and local law enforcement issues, on the reauthorization of the Victims of Child Abuse Act, and on the restoration of funding for federal public defenders, and I appreciate that partnership. But there's also been many issues on which we disagreed, issues from immigration to civil liberties to civil rights to criminal justice, voting rights, and torture. And I am concerned about your views on a number of these issues, as we discussed when we met last week. So I am grateful to the chairman and to you that we're going to have a full and fair hearing on all of these issues today. Let me start with some questions about your time when you were Alabama Attorney General and how you understood some direction you received from the U.S. Department of Justice. At that point, Alabama was the only state in the country that handcuffed prisoners to hitching posts. And we talked about this when we met before, and I said I would ask you about this in this hearing. A hitching post was used as a punishment for prisoners perceived as being unwilling to work or participate in the daily lives of the prison, whether serving on a chain gang or participating in work. And they would be cuffed by both wrists to a pole at chest height, sometimes for 7, 8, or 9 hours, unprotected from sun, heat, or rain, without access in some cases to water or even a bathroom. And as the Attorney General, you and the Governor received letters from the U.S. Department of Justice telling you that Alabama's use of the hitching post in both men and women's prisons was unconstitutional and unjustified. But as I understand it, the use of the hitching post continued throughout your term, and you did not act to stop it. During this same period, the state of Alabama was sued not just about hitching posts, but also about chain gangs. Prison policies in Alabama said a man could be put on a chain gang if he failed to shave or keep his bed clean, if he disrespected a member of the staff, and would end up doing hard labor breaking rocks while being chained together in groups of 5, shackled with 8 feet of chain between men. And these practices, the case that was brought demonstrated, were disproportionately affecting African Americans. In later litigation, the practice of using the hitching post was called by an Alabama judge the most painful and torturous punishment in Alabama, short of electrocution. And in 2002, the United States Supreme Court said using the hitching post was clearly unconstitutional when it was used in Alabama. Can you please, Senator, tell me your view today of the use of the hitching post and chain gang in Alabama corrections, and what your view is of what action you would take today if these practices were restored.
Thank you very much, Senator. That was a initiative of the governor who campaigned and promised that prisoners should work, and he was determined to make that happen. I believe the litigation occurred after my time as Attorney General, according to my records, but we could be wrong. I'll supplement the records for you. Certainly the decision by the Supreme Court and the federal courts were after I left office, I believe. So working of prisoners is an issue that we've dealt with in the Congress of the United States and by state legislatures. I think good employment of a prisoner is a healthy thing. I do not favor personally this kind of work. I think it should be more productive work that kind of help the individual develop a discipline that they could use when they go on to private life after they leave prison. After the Supreme Court ruling, I think it's crystal clear what the law is. That was disapproved and disallowed and found to be unconstitutional, and I would absolutely follow that as Attorney General.
In your view, did it take a ruling by the U.S. Supreme Court to clarify that this constituted torture, that it was not just bad corrections policy, it was actually substantively torture of prisoners?
Senator Coons, I don't recall ever personally being engaged in the studying of the constitutional issues at stake. It's perfectly legitimate for prisoners to work, but they should be on decent conditions, and I think it should be the kind of work that's productive and it could actually lead to developing good habits. I've heard some evidence on that subject, so I do not have a legal opinion about the case. Have not studied the details of it.
Just to be clear, what I was pressing you on there was the use of the hitching post, which is a disciplinary measure that had been abandoned by all states but Alabama. It's really reminiscent more of the stocks, the stockade that was used centuries ago, and to me somewhat troubling that it continued without challenge. Let me ask you more broadly. As you know, both Republicans and Democrats on this committee have worked together to address ways in which our criminal justice system is broken and to address the disparate racial impact of over-incarceration that's resulted in the last 30 years. Senator Tillis and I just yesterday published an op-ed that we wrote jointly about the importance of responsible, balanced criminal justice reform, and Senators Grassley and Cornyn, Lee, and Graham and Flake, all your fellow Republicans, have supported meaningful reforms to address excessive mandatory sentences and incarceration. And in my experience here in 6 years with you, you have steadfastly opposed all of these efforts at bipartisan sentencing reform. Help me understand why you've blocked efforts at reducing mandatory minimum sentences, at creating opportunities for the revisitation of sentences that may have been overly harsh when initially imposed, and help me understand whether you think it is ever proper for a prosecutor to charge anything less than the most serious offense available and carrying the longest sentence.
Well, there's a lot of questions there, yes, Senator Coons. So the Sentencing Act has one foundational requirement now, and that's the minimum mandatories. The guidelines have been either made voluntary by the Sentencing Commission and the courts and the policies of the Attorney General. So the thing that does stand in place are the minimum mandatories, the minimum that can be sentenced for a certain offense. I offered legislation in 2001. It was opposed by the Bush Justice Department that would have reduced the sentencing guidelines, and in fact, a number of years later, unfortunately, essentially could have been done in 2001, when I made a speech in favor of it, made a speech saying what you are saying, that it was disproportionately impacting our African-American community, and we needed to fix it, and eventually that was passed. So I have a record of doing that, number one. Number two, so these other things happened in the meantime. The guidelines were reduced. The Justice Department has reduced its requirements. The Justice Department now allows a prosecutor to present a case to the judge that doesn't fully reflect the evidence that they have in their files about a case. That's a problematic thing. You shouldn't charge, I think, it's problematic and difficult to justify a prosecutor charging 5 kilos of heroin when the actual amount was 10, and to get a lower sentence. Now, there may be circumstances when somehow proof and other issues could justify that, but I just would say, as a principle, you got to be careful about it. Finally, colleagues, sentencing guidelines are within the breast of the Congress. They're mandated by law. I was concerned about what we're seeing is beginning to see a rise in crime, and at the same time, a decline in sentences. Sentences are down 19% already, as based on Sessions, Durbin, and guidelines changes. So that's a matter of interest. And I felt we should slow down a bit before we go further.
Well, if I might
make sure we're not making a mistake, Senator Coons.
It is my hope that if you are confirmed and we do make progress on bipartisan criminal justice reform, that as Attorney General you will carry out whatever legislative decisions might be made by this body. Last, let me just say that in my 6 years here, in addition to not working with us on a number of bipartisan proposals on criminal justice reform, you've been one of the few senators to repeatedly and steadfastly vote against congressional attempts to prohibit torture in the military context or in the interrogation context, and to repeatedly defend enhanced interrogation practices. Are you clear now that our statutes prohibit torture? And if the President were to attempt to override that clear legal authority, what actions would you take?
On your previous question, I would note that federal prison population has already dropped 10 or more percent and will drop another 10,000 this year. So what's happening now is reducing the federal population. This law only dealt with the federal prison population, and that represents the most serious offenders. Our federal DEA and U.S. attorneys are prosecuting more serious cases. With regard to the torture issues, I watched them for some time and have been concerned about what we should do about it. This bill that passed last time was a major step. I thought it was really not the right step. Senator Graham, I know, has been an opponent of torture steadfastly and supported a lot of different things, opposed it. It basically took what I was teaching the young soldiers at the Army Reserve Unit as a lecturer, as a teacher, the Army Field Manual, and it made that the law for the entire government, including the intelligence agencies and other departments. I thought that was an unwise step to take something that directs even the lowest private to do, to make that the rule for higher ups.
Well,
but it's the law. It is a law, and it needs to be enforced. Absolutely.
As we both know, there was a bipartisan effort to review our experience with enhanced interrogation.
It was, but
it's not effective.
Yeah, it was, and of course Senator Graham's a JAG officer, as I was for a little bit.
Thank you, Mr. Chairman. Senator Sessions, congratulations on your nomination.
Thank you.
You are a friend. You are a man of integrity. You and I have worked closely together on this committee, on the Armed Services Committee, and I have every confidence you are going to make a superb Attorney General. You know, this has been an interesting day at this hearing, listening to Democratic senator after Democratic senator give speeches in praise of the rule of law. And I am heartened by that. I am encouraged by that. Because for 8 years it's been absent. For 8 years we've seen a Department of Justice consistently disregarding the rule of law. When Eric Holder's Department of Justice allowed illegal gun transactions, illegally sold guns to Mexican gun traffickers as part of Fast and Furious, guns that were later used to murder Border Patrol agent Brian Terry, the Democratic members of this committee were silent. When Eric Holder was found in contempt of Congress for refusing to cooperate with Congress's investigation into Fast and Furious, once again the Democratic members of this committee were silent.
when the IRS illegally targeted United States citizens for exercising the First Amendment views, for exercising their roles in the political process. Democratic members of this committee were silent. When the Department of Justice refused to fairly investigate the IRS targeting citizens and indeed assign the investigation to a liberal partisan Democrat who had given over $6,000 to President Obama and Democrats on this committee were silent. When numerous members of this committee called on the Attorney General to appoint a special prosecutor to ensure that justice was done in the IRS case, Democrats on this committee were silent. When the Justice Department began using Operation Choke Point to target law-abiding citizens that they disagreed with politically, you know, free speech is a wonderful thing. When the Department of Justice used Operation Choke Point to target legal businesses because they disagreed politically with those businesses, the Democrats on this committee were silent. When the Obama Justice Department sent millions of dollars of taxpayer monies to sanctuary cities that were defying federal immigration law, the Democrats on this committee were silent. When the Obama administration refused to enforce federal immigration laws and unilaterally rewrote those laws, the Democrats on this committee were silent. When the Obama administration released tens of thousands of criminal illegal aliens, including rapists and murderers, into the general population, Democrats on this committee were silent. When the Department of Justice signed off on the Obama administration paying a nearly $2 billion ransom to Iran, contrary to federal law, the Democrats on this committee were silent. When the Obama administration ignored and rewrote provision after provision of Obamacare, contrary to the text of the law, the Democrats on this committee were silent. When the Obama administration signed off on illegal recess appointments that the Supreme Court had to strike down unanimously, the Democrats on this committee were silent. And when the Obama administration released 5 Guantanamo terrorists without the required notification of Congress, the Democrats on this committee were silent. But I take today as a moment of celebration. If once again this committee has a bipartisan commitment to rule of law, to following the law, that is a wonderful thing, and it is consistent with the tradition of this committee going back centuries. Now, if we were to play a game of tit for tat, if what was good for the goose were good for the gander, then a Republican Attorney General should be equally partisan, should disregard the law, should advance political preferences favored by the Republican Party. Senator Sessions, do you believe that would be appropriate for an Attorney General to do?
No, I do not. I believe you, and I think we do have to be aware that when something like this is done, and some of the things I'm familiar with enough to agree with you that I thought were improper, I do believe it has a corrosive effect on public confidence in the constitutional republic of which we are sworn to uphold.
I think you are exactly right. You and I are both alumni of the Department of Justice, and it has a long bipartisan tradition of staying outside of partisan politics, of simply and fairly enforcing the law. I will say right now, if I believed that you would implement policies, even policies I agreed with contrary to law, I would vote against your confirmation. And the reason I am so enthusiastically supporting your confirmation is I have every degree of confidence you will follow the law faithfully and honestly. And that is the first and most important obligation of the Attorney General. Now, earlier in this hearing, Senator Franken engaged you in a discussion that I think was intended to try to undermine your character and integrity. And in particular, Senator Franken suggested that you had somehow misrepresented your record. It is unfortunate to see members of this body impugn the integrity of a fellow senator with whom we have served for years. It is particularly unfortunate when that attack is not backed up by the facts. Senator Franken based his attack primarily on an op-ed written by an attorney, Gerald Hebert. There is an irony in relying on Mr. Hebert because, as you well know, in 1986, during your confirmation hearing, Mr. Hebert testified then and attacked you then, making false charges against you. And indeed, I would note in the 1986 hearing, 2 days later, Mr. Hebert was forced to recant his testimony, to say that he had given false testimony to this committee, and indeed to say, quote, "I apologize for any inconvenience caused Mr. Sessions or this committee by my prior testimony." So an individual who's testified falsely once before this committee, his op-ed is now the basis for Senator Franken's attack on you. And indeed, the basis of Senator Franken's attack is he claims you were uninvolved in several civil rights cases that were listed on your questionnaire. In 1986, Mr. Hebert testified, this is a quote from him, "I have needed Mr. Sessions' help in to the Judiciary Committee." Is that right?
That is correct.
Mr. Franken didn't mention that. And let me point out, here's how you describe your involvement in your written submission to this committee. Quote, "For the cases described in 2, 4, 8, and 9, my role, like most U.S. attorneys in the nation and not with non-criminal civil rights cases, was to provide support for the Department of Justice, Civil Rights Division's attorneys. I reviewed, supported, and co-signed complaints, motions, and other pleadings and briefs that were filed during my tenure as U.S. Attorney. I provided assistance and guidance to the civil rights attorneys, had an open-door policy with them, and cooperated with them on these cases. For the cases described in 6, I supervised litigation and signed the pleadings." Now, that is consistent with the 1986 testimony that you provided help every step of the way. Is that correct?
Well, I think so, yes.
There's no question you've been forthright with this committee, and I would note that members of this committee don't have to search far and wide to know who Jeff Sessions is. We've known every day sitting at this bench alongside you. I want to shift to a different topic, and it's the topic I opened with, which is the politicization of the Department of Justice. The Office of Legal Counsel has a critical role of providing sound legal and constitutional advice, both to the Attorney General and the President. And in the last 8 years, we have seen a highly politicized OLC. An OLC that has given politically convenient rulings, whether on recess appointments, whether on executive amnesty. And early on, perhaps that was started by 2009 Attorney General Holder overruling OLC concerning legislation trying to grant the District of Columbia representation in Congress. And it may well be that that sent a message to OLC that its opinions were to be political and not legal in nature. Tell me, Senator Sessions, what will you do as Attorney General to restore professionalism and fidelity to law to the Office of Legal Counsel?
Senator Cruz, I think any short-term political agenda gains that come from the abuse of the lawmaking processes and requirements of the Department of Justice just don't make sense. It will always, in the long run, be more damaging than the short-term gain that one might have. The Office of Legal Counsel, all of us who've served in the department know, is a big-time position. You need a mature, smart, experienced person who understands this government, who understands the laws, and is principled and consistent in their application of the laws. That will help the President, it will help the Congress, and it will help the American people. I do believe we need to work hard to have that, and I will do my best to ensure we do have it.
One final question. In the last 8 years, the Department of Justice's Solicitor General's office has also, I believe, been unfortunately politicized, and it's sustained an unprecedented number of unanimous losses before the United States Supreme Court. Indeed, President Obama's Justice Department won less than half of its total cases before the Supreme Court, which is the lowest presidential win rate since Harry Truman. The average historically for the last 50 years has been about 70%. Numerous of those cases were unanimous, with indeed both Obama Supreme Court appointees voting against the lawless positions of this Justice Department, including their assertion that the government has the authority to supervise and direct the appointment and the hiring and firing of clergy in the church. What will you do as Attorney General to ensure the integrity of the Office of Solicitor General, that it is faithful to the law and not advancing extreme political positions like the Obama Justice Department did that have been rejected over and over again by the Supreme Court?
I think the problem there is a desire to achieve a result sometimes that overrides the commitment to the law. In the long run, this country will be stronger if we adhere to the law, even though somebody might be frustrated in the short term of not achieving an agenda. The Solicitor General should not advocate to alter the meaning of words to advance an agenda. That is an abuse of office, and I would try to seek to have a Solicitor General who is faithful to the Constitution, serves under the Constitution, does not feel it has the power to rise above it and make it say what it wants it to say.
Thank you, Senator Sessions.
Mr. Blumenthal goes, I think we have votes still scheduled for 2:45. It's my idea that we would continue this going, like I'll go with, and then vote and come back. And I hope other people will preside and keep asking questions while the two votes are going on, so we can finish at a reasonable time today.
What about Sessions voting?
What?
He's not voting.
Okay. Well, that's right. Did we get a decision? You can stay here during that voting part. Senator Blumenthal.
Thanks, Mr. Chairman, and thank you for conducting this hearing in such a fair-minded and deliberate way. And I want to join you in thanking Senator Sessions for his public service over so many years, and his family, who have shared in the sacrifices that you have made. So I am sure that my colleagues and I appreciate your service and your friendship. This experience for us is a difficult one, not only because you're a colleague, but I consider you to be a friend and someone who is well-liked and respected in this body, understandably. And I know if you were sitting here, you'd be pretty tough on me, maybe tougher than I'm going to be on you. Kinds of tough questions. You and I have shared some experiences. Both of us have been United States attorneys and attorneys general of our state, and I want to thank you as well for thanking our law enforcement community, which is so important to this nation. And it makes sacrifices, and those sacrifices often are not only in time and foregone income, but also in lives. And I join you in respecting the law enforcement officers who were victims most recently of gun violence. I want to begin just by asking you a question which I asked in a letter. Will you recuse yourself from voting on your own nomination and the nominations of other cabinet secretaries?
I do not have plans to vote on my nomination. I have not thoroughly examined all the issues, but I think there could be a conflict of interest or a violation of the ethics rules, and I would comply with the rules.
I believe it would be a conflict of interest for you to vote on other cabinet secretaries, as they are nominated by the president, who is also your boss, and I think that I hope you will consider recusing yourself from those votes as well, because I think it will set a tone for what you will do in cases of conflicts of interest. And I want to talk a little bit about conflicts of interest, because I think that the Attorney General of the United States has a unique and special role, especially at this point in our history. He should be a champion a zealous advocate of rights and liberties that are increasingly under threat in this country. And he's not just another government lawyer or another cabinet secretary. He is the nation's lawyer. And so any appearance of conflict of interest or compromising positions because of political involvement, I think, is a real danger to the rule of law and respect and credibility of the rule of law. So I would hope that you would consider appointing special counsel in cases where there may be a conflict of interest involving the president. And one of those cases involves Deutsche Bank. The President of the United States owes Deutsche Bank several hundreds of millions of dollars. It's currently under ongoing investigation. Will you appoint a independent counsel to continue the investigation of Deutsche Bank?
Well, Senator Blumenthal, I'm not aware of that case. I'm not in any way, have not researched it or even read some of the published articles about it. So I'm totally uninformed about the merits or lack of it of the case. I don't know that the president is implicated simply because he's borrowed from a bank. But I would say that, as Senator Lee, I think, raised in his questioning, you don't want to be in a position where every time an issue comes up, the Attorney General recuses himself. But at the same time, serious questions, when they arise, the Attorney General should recuse himself on the appropriate circumstances. And I guess that goes with the appointment of a special counsel, which is a somewhat different issue. There's been a lot of criticisms of that, but I think it's a useful tool in the appropriate circumstances.
Would you agree with me that the Emoluments Clause applies to the President of the United States?
Well, the Emolument Clause applies. I guess the dispute is, and the discussion is to what extent does it apply, and how does it apply in concrete situations,
If
which
there's
I have
evidence,
not studied.
If there's evidence that the President of the United States has violated or may be violating the Emoluments Clause, will you appoint a special counsel?
We would have to examine that. I would not commit to this day, at this time, of appointing a special counsel when I'm not aware of a precise factual situation that would be in play.
If there is a violation by the President's family of the Stock Act, which prohibits the use of private or insider information for personal gain, will you apply special counsel?
Well, we'll have to evaluate that if such a circumstance occurs, and I would do my duty as I believe I should do it at the time.
I would suggest that in those cases, an independent counsel is not only advisable but required to avoid a conflict of interest, and I would hope that you would be sensitive to those concerns.
Well, there are reasonable arguments to be made for that. I suggested that Attorney General Lynch should appoint a special counsel in the Clinton matter. I don't know whether you supported that or not.
One reason I'm asking the question is that you have advocated a special counsel in other instances where, in fact, the argument for it was weaker than it would be in these cases, and I think it would be appropriate.
Well, I will suggest that during a campaign, sometimes we get excited. But as Attorney General, you have to follow the law, you have to be consistent, and you have to be honorable in your decision-making, and I respect the questioning you're raising.
Let me ask you about another group. I welcome your condemnation of the Ku Klux Klan. You may be familiar with a group called Operation Rescue. And Operation Rescue endorsed you. In fact, Troy Newman, the head of Operation Rescue, said, quote, "We could not be happier about the selection of Senator Jeff Sessions as the next Attorney General." Operation Rescue has, in fact, advocated, quote, "execution," end quote, of abortion providers. And as an example of its work, this poster was circulated widely in the 1990s and early 2000s about a Dr. George Tiller, who subsequently was murdered. After his murder, Operation Rescue said that his alleged murderer should be treated as a political prisoner. Dr. Tiller was murdered in 2009, and I'm sure you're familiar with this case. Will you disavow their endorsement of you?
I disavow any activity like that, absolutely. And a group that would even suggest that is unacceptable. And I will enforce the laws that make clear that a person who wants to receive a lawful abortion cannot be blocked by protesters and disruption of a doctor's practice. I might not favor of that. I am pro-life, as you know, but we've settled on some laws that are clearly effective, and as Attorney General, you can be sure we would follow them.
You would use the FACE statute, the Freedom of Access to Clinic Entrances Act, to empower and mobilize the FBI, the Federal Marshal Service, or the Bureau of Alcohol, Tobacco, and Firearms to protect clinics if there were harassment or intimidation.
I would use the appropriate federal agencies, and I do believe it is in violation of the law to excessively or improperly hinder even the access to an abortion clinic.
Will you rigorously enforce statutes that prohibit purchase of guns by felons or domestic abusers or drug addicts, and use the statutes that exist right now on the books to ban those individuals from purchasing guns?
Well, Congress has passed those laws. They remain the bread and butter enforcement mechanisms throughout our country today to enforce gun laws. The first and foremost goal, I think, of law enforcement would be to identify persons who are dangerous, who have a tendency or have been proven to be lawbreakers and been convicted, and those who are caught carrying guns during the commission of a crime. Both of those require mandatory sentences. As United States Attorney in Alabama, it was a high priority of mine. I calculated a number of years. We were one of the top, even though a small office on a percentage basis, we were one of the top prosecutors of those cases. I think it saves lives, Senator Blumenthal. As a matter, my judgment at least, as experience tells me, it can help create a more peaceful community.
Will you support laws necessary to effectively apply those laws, including universal background checks that are necessary to know whether the purchaser is a felon or a drug addict or a domestic abuser?
Well, I believe in background check laws, and many of them are appropriate, but in every instance, there are some instances when it's not practical. Like, say, for example, somebody inherited a gun from their grandfather. Those transactions, I'm not sure, should require that kind of universal background check.
Member of this committee, Senator Crapel, welcome to the committee, and you may proceed.
Thank you, Mr. Chairman, and I too want to thank you for the way you are handling this hearing and appreciate your service here in the committee. And Senator Sessions, I also want to join those who have congratulated you on your nomination to be the Attorney General of the United States. I am one of those who has had the opportunity to work with you for years and know you very well. I consider you well qualified and look forward to your service as Attorney General of the United States, if you are confirmed, and I expect you will be. I know you to be a man of your word. I know that you're committed to the Constitution of the United States of America, and you are committed to enforcing the law of this country, as you have said multiple times here in this committee. So I thank you for that. I want to go in my questions into just a couple of other areas beyond just the notion of the enforcement of the law, but the manner in which the Department of Justice enforces the law. Three basic areas. One, the abuse of the power or discriminatory enforcement of the law. Two, regulatory overreach that we're seeing across this country, and what role the Department of Justice plays in trying to deal with that. And then finally, cooperation with the states. We live in a union of 50 states, and under our Constitution, there are appropriate roles for the federal government and the states, and the Department of Justice has a very powerful influence on that. So if I could get into those three areas. The first one I'm just going to use as an example of the kind of abusive use of power that I hope you will help stop and prevent from continuing to happen. It was already, this example is one that was already referenced by Senator Cruz, Operation Choke Point. Operation Choke Point, for those that aren't familiar with it, the only appropriate thing about it, in my opinion, is its name. It was a program designed by the Department of Justice to help choke financing away from businesses and industries that were politically unacceptable or for whatever reason unacceptable to the administration. The Justice Department, working with and I think perhaps even pressuring some of our financial regulatory agencies, created this program to give additional scrutiny, indeed such aggressive scrutiny that it pressured them out of their access to financing to certain industries. I don't know how these industries got on the list, but I'll just read you several that are on the list. Ammunition sales, coin dealers, firearms sales, installment loans, tobacco sales. This list is a list of 30 that was put out by the FTC. When they actually realized they shouldn't have put the list out, they quickly took it back. And the FDIC says that they're not pursuing this program anymore. But when we tried to defund it earlier, the administration fought aggressively to make sure we didn't get the votes to defund it. This program is one where the justification is, well, the businesses who operate in these industries haven't done anything wrong. But these are industries that might do things wrong more than other industries. And therefore, we're going to pressure people out of these industries. It reminds me of a 2002 movie called Minority Report. It was a Tom Cruise movie, and that was one about an advanced police force in the future that had determined or had developed the ability to know if you were going to commit a crime before you commit the crime. And then their job was to go arrest you. It was really good at stopping crime because they arrest you before you even commit it. And then one of them came up on the list, and that's the story of that movie. My point is, we can't really tell for sure whether Operation Choke Point is still operating, although we still have people in these industries who can't get financing. If that kind of thing is going on in the Department of Justice, will you assure that it ends?
I will. At least as you framed this issue, and as I understand the issue from what little I know about it, but fundamentally, a lawful business should not be attacked by having other lawful businesses pressured not to do business with the first business. That's, to me, it would be hard to justify. I guess maybe they've got some arguments that would be worth listening to, but fundamentally, that seems to me, Senator Crapo, you're a great lawyer, but it seems to me that goes beyond what would be legitimate in a great economy like ours.
Well, I would hope the Department of Justice would not be a partner with any of our federal agencies in this kind of conduct. Another one which I'll throw out as an example is the National Instant Criminal Background Check List, which is now being utilized by the Veterans Administration and by the Social Security Administration to put people's names on the list so that they can be denied access to owning or purchasing a firearm. And the way they put their name on the list is to say that they are mentally deficient. If they need a little help on their Social Security benefits, if they're a veteran who put their life on the line for us and goes to war and receives a head injury, and so they need a little bit of assistance, then they get their name often put on the list. I know that these are not the agencies that you supervise, but I know the Department of Justice supervises the NICS list. And I would just encourage your help, whether it's here or anywhere else in our government, as we see agencies using their power to achieve political purposes or some other discriminatory purpose of the administration, I would hope you would stand solidly against it.
Well, thank you, Senator Crapo. I know you've worked on that issue. So I'd be sympathetic and be willing to receive any information that I know you've gathered to form your views about it.
All right, I appreciate that. Let me move on to the question of regulatory overreach. I'll just use one example there. I'm one who believes that today we talked a lot in this hearing today about the rule of law. In America, statutes are passed by Congress and signed into law by a willing president. But now we have multiple agencies that are doing rulemakings that, in my opinion, are going far beyond the legal authority of the laws under which they operate. I'll use one example, the Waters of the United States rule that has been implemented or is seeking to be implemented by the EPA and the Army Corps of Engineers. In my opinion, that is totally unfounded in law. And often the Department of Justice is partnered up with these agencies as they try to defend their activities in court. And I'm not sure I actually know the proper role there. Does the Department of Justice simply have to litigate on behalf of these agencies? Or does it have the ability to advise these agencies that they are pursuing activities beyond the bounds of the law?
It can be that an agency would ask an opinion of the Office of Legal Counsel, the Department of Justice, and as to whether their interpretation is sound or not. That opinion, until reversed at some point, stands for the entire government. But basically, these agencies oftentimes just set about their own agendas without asking for an opinion. And often they are narrow-minded, or they're focused only on what they feel are the goals of their agency, and don't give sufficient respect to the rule of law and the propriety of what they're doing. In particular, did the Congress really intend this? Did this law really cover this, or is it just something you want to accomplish and you're twisting the law to justify your actions? Those are the kind of things that we do need to guard against.
Well, I appreciate that, and I hope that under your leadership, we will have a Justice Department that will give strong advice where it can and have strong influence where it can across the United States system, across our agencies in this country, to help encourage and advise that they stay within the bounds of the law. The last thing, and I'll just finish with this, and you can give a quick answer. I'm running out of time here, and that is cooperation with the states. As I said earlier, our system of government is comprised of 50 states in a union under a constitution that establishes a federal government. And you and I both know well that the 10th Amendment says that those rights and powers that are not specifically granted to the federal government in the Constitution are reserved to the states and to the people, respectively. Many of our states feel that that proper respect for their sovereignty is being abused, again, by federal agencies, not just the Department of Justice, but the Justice Department often gets involved in this through providing the legal services that it does to our agencies. And, I could go through a ton of more examples and lists of litigation that is ongoing right now with my state and other states around the country, where if we simply had a better level of respect for the role of states in this union and under our Constitution, we could work out a lot more of these issues rather than having the heavy hand of the federal litigation system come to play into forcing compliance by states. And so I won't go into any specific details, but we'll just ask your feelings about that importance of respecting the role of states in this country.
There's no general federal criminal crimes. So many things like larceny and even murder unconnected to some civil rights connection. These things have traditionally been totally the responsibility of the states. As a young prosecutor in the 1970s, I remember almost all the cases had an interstate commerce nexus. It wasn't the theft of an automobile that you prosecuted. It was interstate transportation of a stolen vehicle.
A lot of
that is just now we've forgotten that distinction, that limitation on federal power.
We have, and a lot of what I'm talking about happens in the Environment and Natural Resource Division or in others. There's a lot of litigation out there. I just encourage you. I am out of time.
Let me make a suggestion before I introduce Senator Ronald, and she's welcome back to the committee. She's been off 2 years. To make efficient use of our time, when she's done, it would be Senator Kennedy's turn, but you probably have to go vote. So if there's somebody back here that can start the second round, do it. And then we'll call on Senator Kennedy to finish the first round. Senator Hirano.
Thank you, Mr. Chairman. It's good to be back on this committee. And aloha to you, Senator Sessions.
Aloha.
I will do my best to be nice to you.
Well, that won't be hard for you.
Thank you very much. I know that the Attorney General has broad prosecutorial discretion. You noted in some of your responses to questions from Senator Durbin around the issue of what would happen to the 800,000 DACA registered people if the president-elect rescinds that program, and you indicated that I think at that point that the AG's office has only so many resources, and that may not be a high priority for you, but you indicated that's why we needed immigration reform. So my series of questions will center around how you would exercise your prosecutorial discretion, which I think you would acknowledge as wide as Attorney General, wouldn't you?
In many cases, you do, the federal prosecutors set discretionary limits, but you have to be careful that it does not exceed a reasonable judgment about what a discretion
I agree.
should be.
It's not totally unfettered, but why prosecutorial discretion? So my questions will center around how you would exercise prosecutorial discretion with regard to some specific issues. You probably know, Senator Sessions, that I am an immigrant, and you indicated in one response that you would want immigration reform to center around skills-based immigration reform. And if that were the case, my mother, who brought me to this country to escape an abusive marriage, would not have been able to come to this country, and she acquired her skills later, but I just want to let you know that this is one of the reasons that issues relating to immigration are very important, not just to me, but to millions of people in this country. And I have heard from them. I've heard from immigrants in this country, LGBT Americans, women, and religious minorities who are terrified that they will have no place in President-elect Trump's vision of America. And based on what I've heard since the election, I am deeply concerned that their fears are well-founded. I'm hoping that you can address some of these concerns today. So I mentioned the exercise of prosecutorial discretion. When you came to see me, we did talk about whether or not you would support a ban on Muslims coming to this country based on the fact that they were Muslims, and you said you would not support that. But you also indicated that you would support basically what would be considered enhanced vetting of people with extreme views. What would characterize an extreme view to you, and how would you go about ferreting out people with extreme views when there are millions of people legally coming into our country? And also, related question, the fact that you would consider vetting of people with extreme views to be a proper use of our governmental authority, there must be a connection in your mind that people with extreme views, which I hope you will describe what you mean by, will do something that would compromise the safety of Americans. Could you respond to my series of questions relating to extreme views?
Well, I do think, first of all, the vetting process is in the hands of the State Department, at the consular offices, and those offices that are meeting people abroad and evaluating them for admission to the United States. So the Department of Justice really does not dictate that, as long as it's as long as it's within constitutional order. I think the approach that's preferable is the approach that would be based on areas where we have an unusually high risk of terrorists coming in, people who could be clearly violent criminals, and those certainly justify higher intensity of vetting. I think that maybe responds to your question, but again, the ultimate decision about that would be done through the State Department and by the President.
I'm sure they would ask for the Attorney General's opinion as to the limits of the Constitution in requiring these kinds of questions to be asked of people who come to our country. And you did indicate that one's religious views would be a factor in determining whether somebody has extreme views. Let me turn to...
If their religious views
not in and of itself.
Extremism, right. Not, if their interpretation of their religious views encompasses dangerous doctrines and terroristic attacks, I think they should certainly deserve more careful scrutiny than someone whose religious views are less problematic.
Yes, Senator Sessions, you did say that one's religious views would be a factor in determining whether one has extreme views that would enable that would not enable them to come to our country. Let me turn to the question of abortion. On Roe v. Wade, you did say, quote, "I firmly believe that Roe v. Wade and its descendants represent one of the worst, colossally erroneous Supreme Court decisions of all time, and it was an activist decision." My question is, do you still hold that view? I believe you answered yes to someone who asked you that question previously, that you believe that Roe v. Wade was a bad decision.
Well, I did.
You still believe that?
Well, I guess I've said that before. I'm a pro-life advocate, but fundamentally, the problem, as I see it, with Roe versus Wade, is that it denies the people the right to make laws that they might feel appropriate. Did the Supreme Court have that power? I concluded they didn't, because the Constitution didn't answer that question. But
Senator Sessions,
I respect people.
I hate to interrupt you, but I have less than 2 minutes, so I don't want to get into the substance of Roe v. Wade. I realize you still believe that that was a bad decision, although it was based on constitutional privacy protections. So we can expect the makeup of the Supreme Court to change, and we can very well end up with a Supreme Court that will be very open to overturning Roe v. Wade. And should you be the Attorney General, would you direct or advise your Solicitor General to weigh in before that Supreme Court, which has an opportunity to overturn Roe v. Wade? Would your Solicitor General go in and weigh in to repeal or to overturn, I should say, Roe v. Wade?
Well, Roe versus Wade is firmly ensconced as the law of the land, and I don't know we would see a change in that. You're asking a hypothetical question. Those cases seldom come up on such a clear issue. They come up at the margins. I just would not be able to predict what well-researched, a thoughtful response would be to matters that could happen in the future.
I think most of us know that the next opportunity for the Supreme Court to weigh in on whether or not to change Roe v. Wade would be a very close decision, and likely possibly a 5-4 decision, and that it's not just a hypothetical, but it is of real concern to a lot of people. Let me turn to the Voting Rights Act. While the Supreme Court did eliminate parts of the Voting Rights Act, it still retains Section 2, which prohibits states from enacting laws that would have a discriminatory impact. And the Attorney General's office was a party to challenging 2 states' laws. I believe it was Texas and there was another state, that the Supreme Court ultimately agreed with the Attorney General's position that these laws violated the Voting Rights Act Section 2. Would you, should you become the Attorney General, just as vigorously prosecute those kinds of state laws that have a discriminatory voting impact?
Well, this administration's Attorney General has intervened when it felt it was appropriate and not intervened when it did not feel it was appropriate. So I think my responsibility would be to ensure that there's no discriminatory problems with a Voting Rights Act of a state. If there is, if it violates the Voting Rights Act or the Constitution, I think the Attorney General may well have a responsibility and a duty to intervene. You cannot allow improper erosion of the right of Americans to vote.
Well, we know that since the Supreme Court's decision that did away with major parts of the Voting Rights Act, that numerous states, perhaps 13 states, have already enacted laws that could be deemed contrary to the Voting Rights Act. So I would hope that as Attorney General, you would vigorously review those kinds of laws and to prosecute and to seek to overturn those state laws, just as your predecessors have done. I want to turn to VAWA. I know that you voted against the most recent iteration of VAWA because you had concerns about how the, non-Indians would be prosecuted under tribal law. And you indicated that, yes, you do acknowledge that non-Indians do go on tribal lands, commit crimes, and that these kinds of crimes should be prosecuted at the federal level. And I would expect that should you become Attorney General that you will do that. But at the same time, my question is, would you then seek to overturn that part of VAWA that allows the tribal courts to proceed?
That would be a strictly legal decision. We should give respect to the laws of Congress that have been passed. As a member of Congress, I was uneasy with it, did not think it was a good approach, and I believe 8 out of 9 Republicans on the committee shared that concern and did vote against it. As I noted earlier, I voted for the Violence Against Women Act in 2000, yes. 2010, and I voted for the Grassley version of the Violence Against Women Act this past time, even though I did vote against the version that became law.
As Attorney General, you would not do anything to challenge that part of VAWA that allows for tribal courts to proceed.
Well,
right?
I would have to make a legal decision on that. I'm not able to do so today.
Thank you, Mr. Chairman.
Thank you. Senator Sessions, as you're aware, in many instances, Congress, when enacting a law, will choose to issue a broad sort of mandate, a broad aspirational statement, leaving the details of the actual lawmaking process to a regulatory system that then has to follow certain procedures in turn to effectively make laws. We call those regulations typically. And sometimes an executive branch agency will go a step further. And outside the process that has to be followed when promulgating a new regulation, they'll just issue a guidance document outlining what the agency feels is the status of the law in this area. Guidance documents have received a lot of criticism from members of the public who point out that they are bereft of any kind of safeguard and that they haven't gone through a legislative process. They haven't even gone through any type of review process that would normally accompany the regulatory rulemaking cycle. As a matter of policy making, will the Department of Justice, under your leadership, assuming you're confirmed, use guidance documents as a matter of course in promulgating legal interpretations?
Senator Lee, a guidance document that's clearly within the intent of Congress and the law's plain words can be beneficial. I think they're normally issued by the agency or department that administer it, like, for example, Health and Human Services, Homeland Security, Department of Commerce. Often or sometimes they ask the Office of Legal Counsel for their opinion about what the proper interpretation of a statute is. But I do think you raise a valid concern. A guidance document cannot amount to an amendment of a law. Bureaucrats do not have, that's a pejorative term, but department and agency attorneys and members don't have the ability to rewrite the law to make it say what they'd like it to say. And if we get away from that principle, we've eroded respect for law and the whole constitutional structure where Congress makes the laws, not the executive branch.
What about in the context of litigation, where you're litigating a case involving one of these guidance documents and you're representing the federal agency in question? Will the department, under your leadership, assuming you're confirmed to this position, ask courts to defer to non-binding guidance documents in the same way that courts are routinely asked to defer to regulations?
Well, that's a good question. from a good lawyer, I have to say. In other words, the question you're suggesting is the established law of the land or the courts is that they give certain deference to well-established, properly established regulations issued pursuant to statute. But what if the secretary just issues a guidance document? Is the court entitled to give full deference to that? I would. First of all, I don't know. I haven't researched it. But I do think that would be a pretty bold step to go that far and would be dubious about it.
Thank you. As you know, from time to time, the Department of Justice receives subpoenas, or one of the entities being represented by the Department of Justice might receive requests from members of Congress, from committees in Congress, including some committees that have the power to issue subpoenas. In other instances, just letters or other types of requests from Congress for documents. I suspect that there may be a number of outstanding requests of this nature that are left pending at the end of this administration. Requests that were issued during the 114th Congress, the Congress previous to this one, but that will still need to be handled within the department after you're confirmed, assuming you are confirmed. Will you commit to reviewing any of those that remain pending and doing so in a manner that's timely and showing the respect for a coordinate branch of government?
Essentially, if you would, repeat for me that, but kind of...
pending requests for documents that might be left over from the previous Congress.
Requests for documents in what kind of proceeding?
Requests for documents either from the department itself or in matters where the department is involved representing an entity within the federal government. I just want to make sure that those don't get left behind, that they don't get ignored simply because they haven't been dealt with by the previous administration.
Well, I do think they're entitled to be evaluated, and proper requests, I would assume, would continue to be valid, and we would try to follow whatever the law requires in that regard.
Thank you. I appreciate that. I want to talk about the use of the attorney-client privilege by members of the executive branch, by executive branch officials. In a 1998 opinion, the U.S. Court of Appeals for the D.C. Circuit reached the conclusion that executive branch officials do not enjoy the same common law attorney-client privilege as ordinary lawyers, lawyers who are not executive branch officials. And Justice Scalia, while he was serving as the Assistant Attorney General over the Office of Legal Counsel, authored a legal opinion stating that that executive branch officials do not enjoy the privilege unless they're dispensing with personal legal advice. Instead, in that view, executive branch officials need to exert the executive privilege rather than the traditional common law attorney-client privilege. And yet, executive branch agencies routinely can be observed asserting the attorney-client privilege instead of the in much the same way they would in the traditional context, rather than just invoking the executive privilege. Would you agree with that, that might raise some questions?
Senator Lee, I've not studied that opinion of Justice Scalia. I would be reluctant to comment, except I would say that it's probably good for the American Republic that department and agency officials seek legal advice before they act. In the long run, that's probably better. And I think having some expectation that they can have a candid comment with their attorney is of value. I hadn't thought about and never given study to the question of whether it should be on the executive privilege or attorney-client, although I can imagine the difficulties.
Yes. No, I appreciate your candor on that point, and it gives me some comfort knowing that you're aware of the situation. You'll look at those. I'd like to talk about some antitrust issues in the moments I have remaining, and then perhaps we'll get back to these during a subsequent round. Antitrust regulators, when they're reviewing potentially anti-competitive harms that might arise as a result of a merger, will sometimes impose conditions on the merger moving forward, saying unless you do A, B, and C, this merger can't go forward. But if you do A, B, and C, in order to address whatever concerns we, the antitrust regulators, have, then the merger can be consummated. It is my view that there is a temptation for antitrust regulators sometimes to impose conditions that don't involve anti-competitive concerns, and that raises some red flags, that because the role of the antitrust regulator is to look out for anti-competitive concerns arising out of the merger, that's where their inquiry ought to be focused, and that's where their conditions ought to be focused. Do you disagree with that?
I would agree with that, as you formulated, I believe, and it would be wrong to further some other separate, discrete agenda that's not reasonably connected to the merger itself. So I think we should ensure that we have the highest integrity in antitrust adjudications because they can have great impact. The law is not crystal clear about what's lawful and what's not lawful and what the antitrust division is required to do, and it leaves dangers of, if not politicalization of it, it remains dangers of policy agendas getting embroiled in it. So it's an important division that requires great integrity and ability, I believe, in the leadership at the antitrust division.
Thank you. Just a moment. Senator Leahy.
Thank you, Mr. Chairman. I listened to Senator Lee asking these questions. It occurred to me that you were one of a very, very, very small minority of members who opposed the USA Freedom Act that I drafted with Senator Lee. It passed with a supermajority in both the House and the Senate. Even though you voted against it, and this, of course, stopped the bulk collection by NSA that both Senator Lee and I oppose, do you agree the executive branch has to follow the law that they cannot reinstate the bulk collection of America's phone records without amending federal statutes?
Senator Leahy, that appears to be so, and I can't swear that that's absolutely, totally always true, but it appears to be so.
Wait a minute. We either passed the law or we didn't pass the law. Supermajority voted for the Lee-Leahy law. The president signed into law. You voted against it. Will you oppose the law?
I will follow the law, yes, sir.
And will you commit you're not going to allow the NSA to gauge in the bulk collection of Americans' records in violation of the USA Freedom Act based on a theory that somehow whoever is president has the power to disregard the statute?
I do not believe that the statute can be disregarded, and it should be followed.
Thank you. I appreciate that. We had a dust-up in the press. As you recall, when Mr. Trump bragged about how he had grabbed women and so on, you, shortly after the tape came out, and I realize there's an explanation here, you said, I don't characterize that as sexual assault. But then you said later, the weekly standards characterization of comments I made following Sunday's presidential debate is completely inaccurate. My hesitation is based solely on confusion of the contents of the 2005 tape, the hypothetical posed by the reporter, which was asked in a chaotic post-debate environment. Of course, it is crystal clear that assault is unacceptable. I would never intentionally suggest otherwise. That's basically what you said after the confusion on your first comment. Is that correct?
I believe that's correct.
Thank you. Is grabbing a woman by her genitals without consent, is that sexual assault?
Clearly, it would be.
Thank you. If a sitting president or any other high federal official was accused of committing what the president-elect described in a context in which it could be federally prosecuted, would you be able to prosecute and investigate?
The president is subject to certain lawful restrictions, and they would be required to be applied by the appropriate law enforcement official if appropriate, yes.
And the conduct described, based on the description, would be sexual assault?
Well, the confusion about the question was a hypothetical question, and it related to what was said on the tape. I did not remember at the time whether this was suggested to be an unaccepted, unwanted, that would certainly meet the definition. If that's what the tape said, then that would be...
My question is very simple. Is grabbing a woman by her genitals without consent, is that sexual assault?
Yes.
Thank you. Now, you were asked earlier about having called the NAACP and the ACLU un-American. You said that was before you were a senator. But as a senator, you have continued to be hostile to them. You criticize nominees for having what you call ACLU DNA. Now, I remember when Republicans led the Justice Department, as Inspector General found the Bush administration engaged in unlawful, politicized hiring practices. That's the Republican administration's own Inspector General. They said the Ashcroft Justice Department used litmus tests whether applicants would be sufficiently conservative. If they're ever in the ACLU, they couldn't have a job. You said in a radio interview, justice has to be saved from secular, progressive liberals. Okay, let me ask you a couple simple questions. Are an individual's religious beliefs relevant to their employment at the Justice Department?
Not unless it's such that they can't perform their duties in an honorable way consistent with the law.
What would be an example of that?
Well, if an individual so strongly believed that abortion should be unlawful that they use their position to block constitutionally approved abortions, I think that would make them not subject to being employed in the Department of Justice.
Are you going to have a litmus test at the Department of Justice for people who've worked at civil rights organizations?
No.
Senator Graham mentioned you've long been a champion of states' rights, and certainly you and I have had enough discussions on that, and I realize those are deeply held beliefs. But states have also voted on an issue of marijuana and regulation. I believe your own state of Alabama permits the use of a derivative of marijuana known as CBD oil, legal in Alabama, illegal under federal law. If you are confirmed as the nation's chief law enforcement official, and you know that we have very, very limited federal resources. In fact, we're spending about a third of our budget now just to keep the prisons open because of mandatory minimums and whatnot. Would you use our federal resources to investigate and prosecute sick people who are using marijuana in accordance with their state laws, even though it might violate federal law?
Well, I won't commit to never enforcing federal law, Senator Leahy, but absolutely it's a problem of resources for the federal government. the Department of Justice under Lynch and Holder set forth some policies that they thought were appropriate to define what cases should be prosecuted in states that have legalized, at least in some fashion, some parts of
Do you agree
marijuana.
with those guidelines?
I think some of them are truly valuable in evaluating cases, but fundamentally, the criticism I think that was legitimate is that they may not have been followed. Using good judgment about how to handle these cases will be a responsibility of mine. I know it won't be an easy decision, but I will try to do my duty in a fair and just way.
The only reason I mention it, you've been some very strong views. You even mandated the death penalty for anyone convicted of a second drug trafficking offense, including marijuana, even though mandatory death penalties are, of course, unconstitutional.
Well, I'm not sure under what circumstances I said that, but I don't think that sounds like something I would normally say. We're glad to look at it,
Would you say that's not your view today?
It is not my view today.
Thank you very much. Thank you.
I perked up when he started talking about federalism. And, of course, everything Senator Leahy said was interesting, but the federalism stuff is particularly interesting.
Your
Yes,
legislation.
exactly. I appreciated that, too. That was great. Federalism is an issue that's near and dear to many of us, and I know it's important to you. The notion that our federal government possesses powers that James Madison described as few and defined, those reserved to the states are numerous and indefinite. We were supposed to be a different legislative body. Our federal government was always intended as a limited purpose national government, not a general purpose national government, one possessing complete police powers. We've seen a slow but steady drift over the last 80 years away from this principle of federalism, such that powers exercised at the federal level today could no longer be described as few and defined, but more appropriately described as numerous and indefinite. And in light of the supremacy clause in the Constitution, any powers we do exercise through the federal government are, by definition, replaced from the states. In other words, when our action conflicts with state action, it's our action that prevails in light of the supremacy clause. It's one of the reasons why federalism needs to be looked out for so carefully. One of the reasons why a view that I think you and I both share is that U.S. government officials in all three branches of government, whether they wear a black robe or not, are expected, when they swear an oath to uphold the Constitution, to look out for basic structural protections in the Constitution like federalism, so that we don't have an excessive accumulation of power in the hands of the few. So the Founding Fathers set up this system in which we have these structural protections. We have the vertical protection we call federalism, which we've just described, and the horizontal protection we call separation of powers. It says within the federal government, in order to protect us against the risks associated with the excessive accumulation of power in the hands of the few, we're going to have one branch that makes the laws, another branch that enforces the laws, and a third branch that interprets the laws. As long as we keep each branch within the same lane, the people are protected from what happens when one person or a group of people gets too powerful. But over the last 80 years, just as we've seen a deterioration of federalism, we've also seen a deterioration of separation of powers. You have an interesting set of circumstances with our laws, our controlled substances laws concerning marijuana, in that for the first time in a very long time, you've seen some attention paid to federalism, but in the limited area associated with marijuana. In other words, there are federal laws prohibiting the use of marijuana, the sale of marijuana, the production of marijuana, that apply regardless of whether a state has independently criminalized that drug, as every state until recently had. Then you had some states coming along and decriminalizing it, sometimes in the medical context, other times in a broader context. The response by the Department of Justice during the Obama administration has been interesting, and it's been different than it has in other areas. They've been slow to recognize principles of federalism elsewhere. They chose to recognize it here. My question to you is, did the way they respond to that federalism concern run afoul of separation of powers? did the department's approach to this issue that they identified as a federalism issue contravene the understanding that we are the lawmaking body, the executive branch is the law enforcing body?
Well, I'm not sure I fully understand the point of your question, but you're talking about separation of powers within the federal government, the
Yes.
three branches of federal government.
Yes.
And how does that implicate the marijuana laws?
Yes. Are there separation of powers concerns arising out of the Department of Justice's current approach to state marijuana laws?
Well, I think one obvious concern is that the United States Congress has made the possession of marijuana in every state and distribution of it an illegal act. So if that's something is not desired any longer, Congress should pass a law to change the rule. It's not so much the Attorney General's job to decide what laws to enforce. We should do our job and enforce laws effectively as we're able.
Thank you. I'd like to get back to antitrust issues for a moment. In 2010, you co-sponsored some legislation that extended the Antitrust Division's leniency program and extended it all the way out to 2020. So it was a 10-year extension at the time. You helped move that through. The legislation provided that members of a cartel could receive reduced penalties if they reported cartel activity to the department and cooperated with any investigation the department had in connection with that antitrust cartel. Now, the Antitrust Division within the Department of Justice considers this tool, quote, its most important investigative tool for detecting cartel activity, close quote, because it creates an incentive for cartel members to self-report, to come forward and to identify things that the Antitrust Division needs to be aware of. So I applaud your leadership in this area because it's been very helpful to the enforcement of our antitrust laws of the department. So I have two questions related to this program looking forward. First, given its importance, do you think the program should be made permanent? And second, are you open to any other ideas that might strengthen the program?
Senator Lee, I would not commit to you that I have formed an opinion on that. These are very complex areas of the law. I'm not a member of the antitrust subcommittee, as a number of members of our committee are, and have achieved levels of expertise like Senator Klobuchar and you and others. So I would just have to commit to you that I'm open to hearing the views of this Congress and that subcommittee, and would try to work with you. But I do understand that antitrust policy is an important issue for America, and we need to get it right, and that will be my goal.
Thank you. One important question that sometimes arises in the antitrust context relates to what role the Department of Justice should play in communicating with foreign authorities, authorities in other countries that deal with competition laws, deal with things analogous to our antitrust laws in this country. The Department of Justice has typically played a leading role, but in recent years it has also allowed the Federal Trade Commission, the FTC, to become heavily involved. To my mind, this raises some potential concerns because the FTC is an independent agency. As compared to the Department of Justice, of course, which is headed by a presidential appointee who, with Senate confirmation, serves at the pleasure of the president. Do you have any opinion on this, this point that the Department of Justice, which is more accountable to the president and therefore has some connection to the people, should be more actively involved in communicating with foreign antitrust or competition authorities?
I really wouldn't attempt to comment today on that. I would be glad to hear your thoughts on it. I think it can be problematic if U.S. officials encourage foreign officials to join with them against an action of a private company that could put so much excessive pressure on them that they're not able to resist, and when they may have a lawful basis to resist. But so these are big issues, and you have to be sensitive to the power that the Department of Justice has, that Antitrust Division has, and make sure that there's a principled policy and lawful basis for what is done.
Thank you, Senator Sessions. I see our chairman's back. Oh, he's not back. Senator Feinstein.
It's my understanding that Senator Durbin has not yet had its second round, and so I would like to defer to him.
Senator Cannon. Oh,
I'm going to defer to Durbin because he somehow got missed.
Thank you very much. I want to thank the chairman and my friend Senator Feinstein. This morning, before the Senate Intelligence Committee, Director Comey of the FBI was testifying on the question of investigating the Russian involvement in this last election. And he was asked if there was any ongoing investigation about contacts between Moscow, the Russians, and any presidential campaigns. And he refused to answer, said he wasn't going to discuss any ongoing investigations publicly. I would like to ask you a question related to recusal. You stated earlier today that you had made the decision, and you haven't given us a real background on it, but made the decision that you would recuse yourself from any prosecutions involving Hillary Clinton or the Clinton campaign and emails. And then I understand, I wasn't present, but Senator Blumenthal asked you for some other hypotheticals as to whether you'd recuse yourself on an emolument question or some other things, and you said you'd take it on a case-by-case basis. What if, the hypothetical, same as Hillary Clinton, we are dealing with an investigation that involves the Trump campaign or anyone in the Trump campaign? Would you recuse yourself as Attorney General from that prosecution?
Well, my response to my recusal issue was because I'd made public comments about it that could be construed as having an opinion on the final judgment that would have to be rendered. I don't think I made any comments on this issue that go to that, but I would review it and try to do the right thing as to whether or not it should stay within the jurisdiction of the Attorney General or not.
It would strike me that this is an obvious case for a special prosecutor if it involves a campaign leading to a candidate who selected you as the Attorney General. Wouldn't an abundance of caution suggest that you wouldn't want any questions raised about your integrity in that type of prosecution?
Senator Durbin, I think it would be incumbent upon anybody who's holding the office of Attorney General at that time to carefully think his way through that, to seek the advice, and to follow the normal or appropriate special prosecutor standards. And so I would intend to do that, but I have not expressed an opinion on the merits of those issues to my knowledge.
Senator Sessions, there's been a lot of controversy about refugees. The United States had a dubious record on refugees during World War II, refusing to accept Jewish refugees who were then, in some cases, returned to Europe and the Holocaust and perished. After World War II, a new policy emerged in the United States, a bipartisan policy, and the United States became more open, in some cases generous, to accepting refugees. The numbers, I've heard various numbers, but 650,000 Cuban refugees who came to the United States during the ascendancy of the Castro regime, 125,000 or more Soviet Jews accepted in the United States, spared from persecution in the Soviet Union, 400,000 from Eastern Europe after World War II, 400,000 from Vietnam, 150,000 from the former Yugoslavia. In the audience today is Omar al-Muqdad. I don't know if he could please stand here. Mr. Muqdad is a Syrian refugee. His story is a story of a journalist who for more than a decade publicized human rights abuses by the Assad regime, arrested 7 times, imprisoned for 2 years. When he refused to stop writing after that, the prison guards broke his hands. After his release from prison, he continued to write about the abuses of the Syrian security forces. When he was again pursued by the regime, he fled to Turkey. He was resettled in the United States by Catholic Charities after receiving refugee status. There have been some strong words spoken about Syrian refugees. In fact, during the course of the campaign, there were some who said we should accept none, and many who've questioned whether we should accept any refugees from anywhere. Despite the lengthy vetting process and background checks, some have said no refugees, we're finished with that business. One of your responsibilities as Attorney General will be the involvement of prosecutorial discretion, decisions that have to be made about the fate of men like Alton Mills I introduced earlier, who had served 22 years of a life sentence for the possession of crack cocaine. Cases of Oscar Vasquez, a man who was a dreamer and wanted to serve the United States in uniform, and this case involving Omar al-Muqdad. The American Bar Association standards say the duty of a prosecutor is to seek justice, not merely to convict. It is an important function of the prosecutor to seek to reform and improve the administration of criminal justice. When it comes to cases like these, in your role as the leading prosecutor in the United States of America, what is your feeling about your discretion to make the decision as to whether or not to spare individuals like those I've described?
I've been made aware in the last several years how this process works. It's really the Secretary of State, usually through consultation with the President, that decides how many refugees should be admitted to the country. And there's little Congress can do other than getting into a funding argument with the President about that. So Secretary Kerry met with members of the Judiciary Committee to announce what he planned to do on refugees. That will be how it would be decided, and legally the President appears to have that power, but it would be my responsibility, I think, to make sure that it was exercised within the bounds of law.
But you have a responsibility too. You oversee the Office of the Pardon Attorney, which recommends that sentences like those of Alton Mills be commuted. You oversee the immigration courts, which are responsible for interpreting how our nation's immigration laws apply to dreamers and refugees like Mr. Muqdad. So this isn't another agency, it is the Department of Justice, and you will be the leader of that department. You will have the authority and prosecutorial discretion. You can't point to Congress and you can't point to the State Department. There's a responsibility within your own department.
Well, a refugee is admitted or not admitted to the United States on the approval or disapproval by the Secretary of State and its consular officials. It's not a trial or not a litigation. So that's how that would be determined. The gentleman from Syria that you mentioned should have be able to make a strong case for his acceptance as a refugee because he's been damaged and injured and attacked and at risk for his writings. So that would give him a more, proving that should give them, put him at a higher level of potential acceptance.
Well, you and I can disagree on this one point in your authority over immigration courts as Attorney General, but I hope that we both agree that there are compelling cases of people who are victims around the world of terrorism and war, discrimination and maltreatment, men and women, and many of them look to the United States as the last possible place for them to find safety and security. I hope after the heated language of this last election campaign that we can come back to some of the standards that have guided this nation since World War II.
Well, we'll not end the refugee program. I would not favor that, but we do have a responsibility to be careful and make sure those who are admitted have been properly vetted and are not a danger.
Thank you.
Before this is what I'd like to do. The votes kind of made this a convoluted rounds that we're in here. One person's had third round, we got one person with no round. So this, or not without his first round. And then Senator Sessions would like to take a break. So here's what I'd like to do, Senator Sessions, is okay with you. I want to go with Senator Hatch, Senator Feinstein for their second rounds, and then Senator Kennedy for his first round, and give you a short break at that point. Is that okay?
That would be good.
Okay.
Thank you.
And for the benefit of the rest of you, I kind of got lost out of this, but I've got to be here for the rest of the meeting where maybe some of you don't have to be. So I'll wait and do my second, third, and fourth round when everybody else is gone.
Oh, is that nice?
How many?
Okay. Now it's Senator.
I think it's
Senator Hatch, yes.
Senator Sessions, I think you've done a terrific job. I've known you all your 20 years. I've watched you work diligently on the Judiciary Committee and on your other committees as well. You're an honest, decent man, and you have tremendous abilities in law enforcement. And you've proven it here today, and you're showing it here today. It's hard for me to understand why anybody would be against you. But let me ask just a couple of questions. I want to emphasize that you have wide support for your appointment among law enforcement, including the National Sheriff's Association, National District Attorneys Association, the National Association of Police Organizations, National Association of Assistant U.S. Attorneys, National Narcotic Officers Association, the Fraternal Order of Police, the Federal Law Enforcement Officer Association, the International Union of Police Associations, and the associations of major county sheriffs and major city chiefs of police. I'm not sure I've seen anybody that had all that kind of massive support for this position. Now, I draw attention to this for an important reason. Disagreement about political or policy positions are one thing, but accusations about your commitment to fairness or suggestions that you're not sensitive to race is another. Would these law enforcement organizations enthusiastically support someone who was biased? We know they wouldn't. Of course not. Would they endorse someone who would fail to be impartial? Of course not. Such accusations, especially without any evidence to support them whatsoever, are not simply attacks on Senator Sessions. They are also smears against organizations like these, which have similarly examined the record and found Senator Sessions worthy of support. So I'm grateful to you and for your willingness to take this on, knowing that you might be smeared by certain organizations. It takes some guts to do this, but we all know you have guts. We all know that you believe in what you're doing. We all know that you have a tremendous integrity. We all know that you have a tremendous intellectual ability as well. And even though you and I have disagreed on some issues that are important to both of us, you've always acted with distinction and with fairness and decency. And I would expect you to do the same thing as Attorney General of the United States. One thing I know, you would be giving it everything you have. And that's a lot. You have a lot to give. Let me just say, this morning one of my Democratic colleagues said that the standards for evaluating your nomination is whether you will, quote, enforce the law fairly, evenly, without personal bias, unquote. Do you agree that the Attorney General has a duty to do that?
That's a core responsibility of the Attorney General, absolutely.
And I have no doubt, knowing you, that you'll live up to that. No doubt whatsoever. I think everybody should have to agree with that. The real question is how we can be confident that you will fulfill that responsibility. And most of the questions this morning were about statements you made, positions you took, or votes you cast as a senator on legislative issues. And some of these questions suggested that you could not enforce a law you had not voted for, or that you would not enforce a law or policy that you might have questioned or personally disagreed with. Now, I personally categorically reject that, and you have too. Am I right?
That is correct.
You're darn right it is. Some of my friends would also reject the suggestion that a liberal could not be impartial. I think liberals can be impartial.
I do too, Senator Hatch. And some people I don't think it would be hard for me to be impartial and to enforce laws that I didn't vote for. I just don't think that's going to be I think I can separate my personal votes of maybe years ago from what my responsibility is today, and I hope that my colleagues can believe that.
Well, the answer to the question whether you can, as Attorney General, enforce the laws fairly, evenly, and without personal bias, it's a resounding yes, you can. And anybody who disagrees with that hasn't been listening, hasn't observed you over the last 20 years, or any time over the last 20 years. There's not a shred of evidence from your entire record to undermine that conclusion. Now, does the fact that you have already served in both the executive and legislative branches strengthen even further your commitment to the duty of fairness and impartiality? Seems to me it does. Am I right?
Well, thank you, yes. I do believe that I've conducted myself according to principles that I think are valid and try to be consistent and honest in my evaluation of the many complex issues that we have here. Sometimes good people can certainly disagree on them.
Well, anybody who knows you knows that that's true. Now, the Justice Department has a duty to defend in court the laws enacted by Congress. As a member of this committee for 20 years, you had heard Attorney General nominees profess their commitment to fulfill that duty regardless of politics. Now, in my opinion, the Justice Department under the outgoing administration reneged on its duty to do so in a number of respects. In some key instances, they made decisions on political rather than legal grounds. How important is it for the Justice Department to defend Congress's statutes? And will you commit to do so even when, as a legislator, you would have opposed those statutes?
Senator Hatch, you've been through these issues for many years, and I certainly respect your judgment. But I do believe that the lawyer for Congress, the lawyer for the United States that represents the United States government in court should be the lawyer that defends an act lawfully passed in Congress wherever it's reasonable, a reasonable argument can be made, and I commit to you I will do that.
Well, I believe you, and I know that's true. And I have a rough time seeing why anybody would find any real flaws or fault with your nomination. I just want to personally thank you for being willing to go through this, for your willingness to be able to do this, and for your integrity that you have shown and exhibited and demonstrated over the last 20 years. I can personally testify about you and about what a fine, really good person you are. And we've differed on some pretty important issues from time to time. I have respect for you because you stand up for what you believe, however wrong you may have been. And no, just kidding.
I heard my wife laugh at that.
Well, I have a lot of respect for you, and I hope that the rest of this proceeding goes really well and that we can get you confirmed as soon as possible, because I know you'll do a terrific job, and I'm very proud of you for being willing to accept this. Thanks, Mr. Chairman.
I'm honored to have your support, Senator Hatch.
Thank you. You have it.
Senator Feinstein.
Thanks very much, Mr. Chairman. Just to begin, I would like to ask unanimous consent that all statements and written testimony sent to the committee concerning Senator Sessions be made part of the record, and I have some testimonies and letters.
Without objection, so ordered.
Thank you very much. Senator Sessions, when I was a small child, it was during World War II, and my father took me to a racetrack south of San Francisco called Tanforan, and it had become a detention camp for Japanese American citizens. And during the length of World War II, well, thousands of families were held in this compound. And we checked with CRS, who says no Japanese American was ever convicted of any sabotage against the United States during that period of time. Senator Lee, Senator Cruz, and I have tried together to enact a bill to assure that no American citizen or lawful permanent resident detained in the United States can be held indefinitely without charge or trial pursuant to authorization of military force. So here's the question. Do you believe that the government can, pursuant to a general authorization to use military force, indefinitely detain Americans in the United States without charge or trial?
Senator Feinstein, that's an important question. Classically, the answer is yes. Classically, if you captured a German soldier, they could be held until the war ended. That was done, I'm sure, at the Civil War and most wars since.
I'm talking about
I hear
an
you.
American.
So then the question is, we're in a war like we have now that's gone on multiple years, and I would think the principle of law certainly would appear to be valid, but as reality dawns on us, and wars might be even longer, you know, it's honest to discuss those issues. So I respect your willingness to think about that and what we should do. But in general, I do believe, as Senator Graham has argued forcefully and for many years, that we are in a war. And when members who, unlike the Japanese, who were never proven to be associated with a military regime like the Japanese government, these individuals would have to be proven to be connected to a designated enemy of the United States. So I probably explained more than I should, but that's basically the arguments and the issues we're facing. I respect your concerns, and I'm sure they will continue to be debated in the future.
Well, let me just say a few things about that. I've served on the Intelligence Committee for 15 years. I read all of it. I think I know as much as anybody about what's happening in the United States. And this is not, these are Americans that we're talking about. They can be picked up and detained and held without
You're talking about Americans
of trial indefinitely. And that should not be the case.
Well, I understand your point, and a citizen of the United States has certain important rights. They cannot be abrogated. It is absolutely so. They cannot be detained without undergoing a habeas review, and the government surely has to prove that they are indeed connected sufficiently with an enemy action against the United States, so they couldn't be detained. And
well, I appreciate that. Let me go on to another subject. You were one of 9 senators to vote against the Detainee Treatment Act of 2005. It prohibited the imposition of cruel, inhuman, or degrading treatment or punishment of any person in the custody or control of U.S. personnel. You also voted against an amendment sponsored by Senator McCain in the 2016 Defense Authorization Bill to limit interrogations to the techniques provided by the Army Field Manual, which does not include waterboarding. Do you agree that the CIA's former enhanced interrogation techniques, including waterboarding, are prohibited by this provision of law as now codified at 42 U.S.C. 2000 DD?
It does appear to be clear that the last act, the McCain Amendment, would prohibit waterboarding.
And you would enforce that?
I would force the law, yes.
Thank you very much. Now, my third question is, and this was in the Washington Post, a report last night that you failed to disclose to this committee and to the Office of Government Ethics subsurface rights to oil or other minerals on more than 600 acres in your home state, some of which, I gather, are adjacent to a federal wildlife preserve. Apparently, Alabama records, and this is a quote, show that the senator leased undivided mineral interests to Chief Capital, a Texas firm, in 2015. Do you, in fact, own these interests?
Senator Feinstein, I believe that's so. and the way it happened was that many years ago, at least 50 or more years ago, my family, ancestors, sold some land and reserved mineral rights. Later, there was a dam built on the river and a desire to take land that were going to be flooded and to add additional land for a duck preserve. And they negotiated, and the family sold land to the government and retained the mineral rights per the agreement. At least that's my understanding. So by an odd series of events, the properties fell to me. I've never reviewed the deeds. I've never known how much land is out there that I own mineral rights on, although oil companies are pretty good about making sure they contact real owners before they drill a well. So you're correct that we reported the income on my return as
I saw that.
As coming from the property that I own and the property where the oil well is. I did not note in that report specifically that it was oil income because the blank said royalties, but maybe I'm there. So I would just say to you this. We absolutely had, this is something I've taken no affirmative action in. It's something I'm going to take affirmative action in. I have one of the simplest, clearest, fairest financial reports you can see. My assets and my wife's assets are almost entirely Vanguard funds and municipal bonds. I've owned no individual stocks because I want to be sure that I don't have conflicts of interest. I want to adhere to high standards. We're going to find out what we did or didn't do and correct it.
Good. Thank you.
I welcome brand new Senator Kennedy, not only to this committee, but to the Senate as well. Senator Kennedy, you're allowed 10 minutes now.
Good afternoon, Senator.
Thank you.
My name is John Kennedy, and that's really my name. Just so you'll know, I used to have a law partner named Jose Canseco.
Oh, is that interesting?
Would caused a lot of confusion when we'd go to meetings together.
I guess.
I have been impressed in preparing for the hearings with the deep support you enjoy from law enforcement. In fact, one of my sheriffs from Louisiana, I don't know if Greg is still here, Sheriff Greg Champon, who also happens to be a lawyer, came all the way up from Louisiana to lobby other senators on your behalf. And I've noticed that a lot of the organizations that are supporting you are organizations that have not always agreed with your positions on the issues. And that impressed me. I just wanted to read you one quick excerpt. This is from a statement by the Sergeants Benevolent Association from the NYPD, New York. About as far away from Mobile as you can get. This is what the letter said. Quote, as a union representing law enforcement officers over the years, the SBA, that's the Sergeants Benevolent Association, has worked as both an ally and a respectful opponent of Senator Sessions. This experience has shown us that Senator Sessions is a man of unquestionable integrity, devoted to the rule of law and the best interests of our nation. It's for these reasons and many others that we believe Senator Sessions is the absolute right choice to serve as America's chief law enforcement officer. Now that impressed me. I'd like to know what you intend as Attorney General to do to further partner with state and local law enforcement.
That is so important. And the United States attorneys throughout the country, as in Louisiana and Alabama, are key players in this. All United States attorneys' colleagues are funded to have law enforcement coordinating officers. I had two in my small office. We had regular meetings. In the early 80s, this is when it started. This is when the first time. And so instead of having a law enforcement plan produced in Washington, D.C., the U.S. attorneys were directed to get all the federal agencies and all the state and local agencies to sit down and identify what their main threats are, and to direct their resources to deal with these real threats in that district, and they would be different in different districts around the country. I sense that that's been eroded somewhat, so we need to go back to a lot of that. The Department of Justice has great resources for identifying tactics and strategies that work on crime. We ought to be able to always help the state and local police officers have the best data on what works and how to create safer and better communities. The federal government cannot dictate to these agencies. It would be a disaster. They wouldn't accept it, number one, and any influence you might have would be eliminated. We need to be partners. The federal government, through its power internationally and nationally, can help a local investigative agency solve a complex criminal case that they don't have the subpoena power, or they don't have a Louisiana U.S. attorney or a sheriff doesn't have power to have investigations conducted in Texas or Denver. So these are the things that are all important. And I truly believe that from a matter of public policy, we need to see the big picture. And we're all in it together. We're all in it together. And 90% of the law officers in America are state and local. And they're the ones that are the eyes and ears of law enforcement. So I really think, Senator Kennedy, you're correct that we need to do this. I think there's a feeling among law enforcement that that's not been happening sufficiently.
I think you're right, Senator.
And I sense that that's one of the, and the fact that I think I understand that I've had as much strong and enthusiastic support as I've had.
You know, when a radical Islamic terrorist drives a truck into a group of people and kills them, we're told that we should not judge all Muslims by the act of a few. And I agree with that. Don't you think the same rule ought to apply when one or two law enforcement officers make a mistake? Don't you think that same rule ought to apply to all the other 99.9% law enforcement officials out there who just get up every day and go to work and try to protect us?
Well, I really do. And I think those of us in high public office do need to be cautious about demeaning whole departments and whole groups of people, because within those, most any departments you can find in America, surely most of the people are just wonderful servants, public servants trying to do the right thing. So when we say these things, we can increase risk for them. We can make it harder for them to have relationships with the constituents where they're serving, and actually result in an increase in crime and ineffectiveness in law enforcement. So, boy, these issues we can't miss these issues. Yeah. You cannot make big mistakes like we may be making now. And so I commit to doing my best as a law officer to engender the kind of unity and comprehensive effort, state, local, federal, that would be the most effective engine to fight crime and make our communities safer.
In Louisiana, Senator, we believe that love is the answer, but we also believe that we have the right under the Constitution to own a gun just in case. Could you share with me your thoughts on the Second Amendment?
Well, I do believe the Second Amendment is a personal right. It's a historic right of the American people, and the Constitution protects it and explicitly states it. It's just as much part of the Constitution as any of the other great rights and liberties that we value. So my record is pretty clear on that. However, if people can forfeit their right to have a gun, and it can be a factor in receiving sentences and being prosecuted if you carry a gun, for example, during the commission of a crime. that can add penalty and convictions to you. I think that's a legitimate and responsible restraint on the Second Amendment right to keep and bear arms.
I think they believe this in Alabama too, but in Louisiana we also believe that nothing makes it easier to resist temptation than a good upbringing, a strong set of values, and witnesses. I'd like to know your thoughts on the Freedom of Information Act.
Well, the Freedom of Information Act is law, and I would say it's carried out, and the policies of the country need to be followed.
Okay. I've got one final question. I read the Inspector General's report about the Department of Justice. I think it came out in about the middle of 2016 last year. The Inspector General talked about problems with the department's massive grant programs. And the Inspector General said that approximately $100 million over the last 5 years went for, quote, questionable expenditures or funds that, quote, could have been put to better use. Now, this is taxpayer money. It didn't just fall from heaven. We thank heaven for it, but it came out of people's pockets. I'd like to know your thoughts about the IG report, if you're familiar with it, and what you plan to do once you're confirmed, and I believe you will be confirmed, to help our friends at the Justice Department prioritize their spending a little bit.
Thank you, Senator Kennedy. That report raises real concerns. I believe that any responsible public official should recognize that when they obtain an IG, their own Inspector General, and saying that their department is not performing according to high standards, should listen to that report and take action and review what's happening and make sure it does not continue. The American people have no desire, and they absolutely should not have their money sent to Washington and then be wasted. We can do a lot more with the money that we have, having been ranking member of the Budget Committee, and I know that how difficult it is, but one way to get extra money, free money, is to use the money you've got wisely for things that are valuable.
Senator, I don't know you well, but I've followed your career with respect and admiration for a lot of years, and I just wanted to tell you that. You're going to be a great Attorney General.
Thank you. Thank you very much.
Senator Sessions, you asked for a short break, so I hope maybe 15 minutes would be adequate.
That would be adequate, absolutely.
Just because I came back, he's wants to...
Senator Whitehouse is going to be next.
No, that's okay.
So when he comes back, yes, go ahead, Senator, take your time. We'll stand in recess.
What's our schedule now?
Okay.
We had the vote.
We are
Thanks, man.
It's kind of convoluted. We just finished the first round.